Hey guys, I'm going to wait for you guys to get in, but we have the murder trials going on today. We're just going to be monitoring this trial. I don't know how many people will be watching, but we do have people on our account that likes to watch this and wants to support our channel. So we're giving you guys the opportunity to do so as we start rolling out the trial for Alex Murdaugh. Let me make sure everything is the way it's supposed to be. It is. So we will see how it all goes. I expect, make sure that we're still in good shape. We're still in good shape. So we are going to be watching this on this channel. I'm going to be stepping away once it gets started. We should be getting started anytime now in about 10 minutes. So if you guys want to go ahead and get your coffee, please do so. I will be here with you guys all day. I may be in the other room, but I'll be watching it on the phone, and I will plug in throughout this trial to talk about what we've learned, to give some insight. We know that things are starting to heat up in this case, you know, whereas before it was kind of just people entering stuff into evidence, such as, somebody just sent, hold on a second. Give me just a second. I just got a notification from someone. I don't know why these give me notifications. Some of my accounts don't. So let me just see who it was. Thank you, Valdez. Thank you for the $5 super chat or super cash app. Thank you. Thank you. God bless you. But anyways, this is one of the cases that this gentleman has had a lot of bodies racking up against him, you know, quite frankly, from 2015 when Stephen Smith was ran over in the road, apparently. But then when the autopsy happened, it seemed more of a blunt force trauma, not consistent with being with a hit and run. And then it was Gloria Satterfield. We heard from Gloria's son on the stand last week. Talk about how he had no knowledge that there was a settlement in this case for millions of dollars, that Alex was just telling him that they're just trying to get him, you know, him and his siblings or other family members, $100,000 apiece. Alex ended up squandering every penny of that settlement. From my understanding, it sounds like the law firm, if I heard the Gloria's son correctly, that the law firm made that right, because at the time they had no money. They didn't even know they were entitled to money. And Alec actually kept the entire settlement almost a secret from the Satterfield family. Now, mind you, Gloria had been in their home for 20 or 30 years. I can't remember the exact date that the son had stated, but it had been several decades that she was the housekeeper and the nanny. She raised the boys. She was the nanny to the boys. She had a great job there, probably loved her job. Everybody, you know, trusted Alex Murdaugh, and Alex sued himself, got another attorney involved. And his understanding was Alex was still his attorney, even though Alex was really the respondent in the civil suit. So it was a little odd how that all happened. But, you know, unfortunately, it didn't seem like the family, like Gloria or family was, you know, like others, this is not to be insulting in any way, but not very wise or smart about the law. Like things like that would have had red flags going off for me, because I know he's the one being sued. How can he represent me? That would be truly a conflict of interest, right? So it does have some hallmarks of this being potentially, you know, an issue up front. And I'm still curious how the other attorney did not know that this didn't feel right. It was weird. It's just weird. I don't get it. However, it is what it is. So we had Gloria Satterfield in 2018. So we had Stephen Smith 2015, Gloria in 2018, and then Paul took out the boat. And clearly, from, if you guys were watching the last stream we had, we talked about the affidavit from his Paul's girlfriend saying that Alec, his wife, and the family knew of his drinking. They contributed to his drinking. They paid for his drinking. Many times he would drink at the family home till point of past intoxication. The family knew he was driving boats under the influence. They knew he was driving cars under the influence and did absolutely nothing to help their son. And, a lot of these things, it looks like we're going to be starting here really soon. And then we get down to his wife and son being killed on the family property it's a large property, but they weren't where the family home was. They were where the dog kennels were, which was, down the road, so to speak, from the actual family home. I saw the gates to the family home and I drove past it to the mailbox, and the mailbox that you see for the home is at the kennels. That's where their mailbox is. It's not out in front of their home. It's down the road in front of the kennels is where the mailbox for that property is, and it's all one property. Now we're here, and then after that, his father passes away a few days after his wife and son. And then a little bit later, I think it was like a month or two later, cousin Eddie tries to help him in a foiled suicide plot, where he was bequesting all of his lifelong possessions to his remaining heir, his son Buster. And that brings us to where we are today, is we're here at the trial of Alex Murdaugh. And this is the murder trial. It sounds like somehow or another the financial motivation has been brought into his murder trial. And we were hearing from people like Gloria Satterfield's son as to what happened to him. We also learned that there was a friend of his that was squandered from that very law firm out of $275 or $250 to $275,000 as well, and that foiled their friendship. So this has been going on for quite some time, and it's surprising to me that the family that ran the law office had no knowledge of this. I mean, there's a lot of checks and balances in place for law firms, so something like this doesn't happen. That may very well be why the Murdaugh name was removed from that law firm, is because, why not? I mean, it seems like there must have been some underhanded dealing. We just learned through an affidavit and some records that $620,000 was given to that cousin Eddie, the one that tried to help him, do this plot to off him. So lots of weird stuff. This is a very interesting case. It's one that I undoubtedly believe a movie will be made of, because it has all the stuff that movies are made of: the power, the prestige, the fall from grace, the family legacy. That not only that, but the family was solicitors in the Lowcountry, South Carolina, for over 100 years. The grandfather had the Murdaugh name on that law firm since 1910. This is insane. This case is really kind of has a life of its own. And every time we turn around, we're hearing jaw-dropping information that happened in this case. And it still comes back to, how did nobody know this was going on? How did his family be so blissfully unaware that this happened? Well, this family has lost a lot of their power. Can they cause problems for people? Yeah, they probably could. I would definitely not behoove it, because that is a felony, tampering with a witness, even past witness, harassing them because they are giving lawful testimony in a court hearing. So I hope the Murdaugh family does not wield their power to the people that are speaking out against Alec, because at the end of the day, Paul, your family member, Maggie, your family member, is deceased, and most likely at the hands of your family member. So we must remember that. And I hope that justice is served. It sounds like this Alex Murdaugh had a life of crime under under this disguise of power and prestige, and he was no better than the thugs that are arrested off the side of the road for the same garbage that he just did. So I really do truly believe. But one thing I have noticed is his rocking kind of started stopping. He started paying more close attention to the people on the witness stand. His sobbing has not been as what it was, in their trial strategy, where he's bobbing his heads down. He looks like he's crying, but really isn't. I've only seen his eyes turn red one time, and I think that was when he finally got to see uh, you know, up close and personal what he is capable of. So again, we're going to be starting here. What time is it? It is 9:30. We are going to be starting very, very soon with this case. For those that have decided to watch over here on the Bullhorn Betty channel, thank you so much for supporting this channel. I do appreciate it. And we will have commentary throughout this again. So when there's any dead voids like there is right now, as they're preparing for the judge to come in, for everybody to get set up, we will be commentating on there, so you're not listening to a whole lot of dead air. I may be here in this chair. I may be in a different chair because you guys know my back, and I'm not going to be able to sit right here for 9 hours, but I will be listening. And again, we will have commentary during the arguments that have to go off air, as well as, breaks and other things. We're not going to be stopping. It appears that we've got one person at least sitting. When we see the judge coming in, it looks like that might be his clerk. Looks like she's getting stuff set up right now. So I anticipate this starting any moment. Yes, make sure you guys hit the like button as you come in. This is a very interesting case. Not too many people on YouTube that are YouTubers like me are covering this case. Most people, it's Court TV and Law and Crime that are really covering this case. Law and Crime is getting undoubtedly a lot more views than even Court TV, which is the one that's actually live streaming this and is pooled as one of the live stream sources. I'm not sure if Law and Crime is also, but we definitely know by court order, Court TV is. So that's what we're pulling from, is the Court TV, because they have no duty of copyright, and they cannot, for any reason. I just don't like seeing their logo. There's nothing I can do about that. The only thing I can do about that is put these banners up, which I will go ahead and install one now. There we go. And see, when I go like this, it's covered, at least for the most part. But, oh, that's not what I wanted to do. So I'm not sure. Usually we start on time, but there must be something going on. Kimberly says it's 2:30 in the UK in this afternoon. Well, thank you for watching from the UK. I appreciate the love and support. Like and share. I saw someone else pop up covering, but watching it here. Thank you, Tammy Crimes. I appreciate that. This has been going on for forever. His antics have always disgraced his family. Love MJ too. Thank you for that. Are you going to cover the Tyler Doyle case? I'm not sure if I'm going to cover that case. I know we touched on it this morning, but I'm not sure how much energy I will be putting into it. I will be making sure everybody, if they want to be a part of the search parties and things of that nature, we'll keep them abreast of those, so they can be, if they're in that area, in the South Carolina area. It might be something, if I do go up there to cover this case in person, this Alex Murdaugh, which I am entertaining going back, so we can at least be there for the jury, for their deliberation and things of that nature. We may go over there and see what we can do to help the family. And that's if I go back to South Carolina. I have to be honest with you, the travels do get expensive. They hit the pocketbook. And, it's just, I've gone to 4 states in this last month. So you can imagine the costs that are associated with that. So I got to give myself a break to, increase some reserves because the first month of this year have been pretty exhausting. I do not like sitting here. I like being out in the field helping, but again, we have to be smart with the funds that we're using because again, they're donations, and I like to make sure that I use them properly. T-Rab, I believe you. Thank you, by the way, for coming over here and saying hi. But yeah, I believe as well, T-Rab, that he is guilty. But I see. That's why I would never be part of this jury because I had already made my determination long before he got to this point that he was guilty. What else do we have here? I am Team Summer. Good morning, love. Good morning, Team Summer. Phoenix Rising. It's nice to see you in here. Miss Lee, mom of 3. I didn't even see you this morning, but I know you were in the chat because I remember I didn't say hi to you. So hi. Now that we have some, we don't have such a crazy chat going on because the cases I cover does bring in some more. This is, like I said, on related to Alex Murdaugh. This was just one that wasn't hitting really on YouTube for whatever reason, at least for my algorithm. But it was a case that really kind of sparked my attention. And Miss Robin, she her she goes to South Carolina quite a bit. So she's the one that kind of turned me on to this case. But the more I dug into it, the more it was interesting. And so I'm like, this is pretty interesting, And then you start hearing about the Stephen Smith, and then you start hearing about Gloria Satterfield. And it's like, after that, I'm like hooked. This case bit me. What courthouse are they doing this? What? Oh, the courthouse is family. Listen to this. It's in the courthouse. It's in Colleton County, but it's in the courtroom that is family. Like when I started hearing about this and how they were going to be bringing in, people from other areas to try to find the proper jury pool so it could stay there, I thought that was brilliant. However, I wasn't thinking that this is the courthouse his entire families had pictures of themselves in for the last 100 years. They literally had to remove the family's photos out of the building because they had been there. They were a pivotal part of that courthouse. I mean, his family was basically in power as the solicitor, the prosecutor of that county for literally 100 years. 100 years. Can you imagine how, like Alec didn't just learn this. This was taught behavior. This was taught behavior from ancestors before him. How much of this has been going on that they were none the wiser about for generations? I mean, this just doesn't happen. Many people I've heard of some stories, some slimy stories of the family and, the Murdaugh family, the Murdaugh name, what they were able to get away with, for a really long time. This is not, for people that are in the Lowcountry, this is not that surprising to them, believe it or not. And people are wondering why SLED came in so early on in this case is because they knew. I'm sorry, no matter how those officers knew. They knew that they could not do this investigation because of the implications of this being yet 4 people now in a matter of a few years associated, and that 5, if you want to add Mallory Beach in there, that is associated with the Murdaugh name. Just a few years. 5 people around that family are no longer here. I'm sorry, that just doesn't happen to normal folks. So I think that's the reason why the SLED team was brought in very early on. They had already known that, statistically what this was. And they had to cross their I's and dot their T's, and thank God they did. Because what a nightmare this would be right now had the SLED team not come in. They would have been saying, oh, well, this was, their whole defense would be much different. And it would be more centered around corruption in their county, the power, the fact that they lost their power. And now this is some kind of witch hunt for, I can see where the argument would have been if they didn't bring in that SLED team when they did for Maggie and Paul Murdaugh. But we have to remember Maggie and Paul also Murdaugh. They still, them too still wield power as well because of the Murdaugh name. So I think that I think that was a right decision for the police, the Colleton County Sheriff's Department. I think they made the right call very quickly and had slid out there very quickly. That is a testament to the fact that they did not want to leave any stone unturned, and I'm glad they made those decisions. They are still doing ProFit, aka on-camera questioning of expert witnesses. Okay. Hello again. I wonder if you see the case on Dateline. Okay, guys, we're starting to get. Everybody rise.
Please be seated.
All right, guys, here we go.
Good morning. You ready to proceed? All right, may proceed. I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to record in this trial shall be the truth? So help you God.
I do.
Take a seat in the witness stand. State your name again for the records. Spell your last name.
Morning, Your Honor. My name is Mark Tinsley.
I'm going to be turning off my microphone so I don't
Mr. Tinsley, how you doing today?
make
Good.
a whole bunch of noise.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would were you testifying before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And how long you been practicing in Allendale?
Since 2000, so 22, 23 years.
Do you have a statewide practice, or is it primarily?
To the extent I want it statewide, I mean, I handle cases statewide if I'm inclined to handle those.
Okay. Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
In the first? Okay. You know the defendant, Alex Murdaugh,
I do.
and how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
And do you represent the Beach family, the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alex Murdaugh. Is that
I did.
correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, when this case started.
Mr. Waters, my recollection is that I sued Alex Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believe that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdaugh, which is Alex's son. But I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, and well, let me ask you this: did your client Renee Beach have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Okay. Now, can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday. So the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case as part and based on that experience?
No. Nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alex's personal lawyer, brought me all of Alex's insurance policies. And so I reviewed them at that time before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
In a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right. And when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had.
And explain that to the court why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was a Satterfield matter, and that it was Nautilus and I think Lloyd's of London, and they would not renew the policy. And so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusion. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge. Is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alec's attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing what insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case."
Okay. And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was no 20. September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
COVID, court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. We'll show you what's been marked as Exhibit 401, State's Exhibit 401, and see if you recognize that document.
I did. I do.
Right? And what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right. Could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alex said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel. And about a week after I'd filed that motion to compel, Danny Henderson, who again was Alex's personal lawyer, came to my partner, said he couldn't believe that we were going after Alex personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right. And why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever. And so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time, Alex thought there was a fix on, that he was just a placeholder, a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because it was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alex, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take? You know, the analogy I use with my clients is it's kind of like that show Deal or No Deal. You may have the $1 million suitcase or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just wasn't, there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alex was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that. Show me the books to prove that. What was your response from Alex's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. I'll show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alex's responses to the interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right.
Just to let you know, there's several
All
types
right.
of
I'm going to
discovery.
put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number one, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can you
right.
read that?
List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
Right. And ultimately, what was the Alex defense's response to that? Generally, you don't have to read that, but just tell me.
It was overly broad, unduly burdensome.
That's a
and irrelevant.
boilerplate response.
And so ultimately, you filed a motion to compel. Is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others. Is that correct?
Correct.
All right.
Trying to see if I can talk here. There's several different types of discovery: request for production, interrogatories, and request for admissions, among others, like subpoenas, ducus tecum, and other subpoena powers.
To your knowledge, when information was being gathered by the defendant in this particular case, let me ask you this: who were his attorneys in the boat case? Alex attorneys.
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon. Ultimately, I think Amy left in February of 21. And by then, I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at them and see what might be available, correct?
That's right.
Remember, Henderson was in the back of the car the night Maggie and
this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, you know, the way to, again, like I in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, you know, that's what I'm trying to do is put pressure on him to force him into a settlement. You don't want it disclosed. Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alex's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right. And explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right. Put this up on the screen. All right, if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021. Is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah. So in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time, I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed a jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
Was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells me everything happens there is secret, so you tell me. But
I'm asking you today.
But yes.
Ultimately, and while you were in Florida in March and April of 2021, to your understanding, had the state grand jury reached out to you for information that you had uncovered in your investigation of the investigation into the boat crash?
Correct. And specifically the handling of the criminal investigation by law enforcement.
The investigation into the investigation.
Correct.
I'm going to show you what's been marked as states 404, 405, and 406. So you're for this hearing, and see if you recognize those, please. Generally.
I do.
All right. And tell me what's going on here, please.
There were a number of motions pending in the boat crash case. They had been pending for some time. I mentioned one a moment ago, a motion to transfer venue. There were some motions to amend. And so Judge Hall had set those motions to be heard. My recollection is May the 10th, 2021. So I'm back now. I got a couple weeks to sort of get my wits about what's going on, and the motions are scheduled to be heard.
And that's May 11th, 2021.
It's either the 10th or my recollection is the 10th. I know the emails say something different, but and in the week before, I don't know that John Tiller always knew how many chemotherapy treatments he was going to get or how long they were going to last until almost immediately before. So on or about May the 7th, John knew that the day of our hearing, his chemotherapy was going to run long and he wouldn't be done. And he had asked the judge to continue the motions, including the motion to compel.
All right. And looking at, again, we're now looking at states 405. What was the judge's initial response to Mr. Tiller's request to have that hearing continued based on his chemotherapy?
That we were going forward as scheduled, and that it says Mr. Condon, but it meant Miss Condon would be able to handle it.
All right, looking at states 406, what happened after that?
Ultimately, what happened is, my recollection is I sent another email to the judge expressing that I really didn't have, they were mainly my motions. Parker's had some motions, but that I didn't have a problem with continuing to accommodate Mr. Tiller. And the judge finally set a status conference for, maybe it was May the 11th.
All right. Just said that initially Judge Hall did not want to continue the May 2021 hearing, saying that there was another lawyer for Alex's side that can handle it, correct?
Correct.
And then you kind of interceded and said that this would work, and so it was rescheduled. Was that correct?
After a status conference.
After the status conference, it was rescheduled at that status conference?
It was rescheduled to June 10th.
June 10th? All right. I'm going to show you what's been marked as states 407 and states 408. And just quickly tell me if you generally recognize those documents.
I do. One is an email from John Tiller saying that the judge's law clerk said that the judge would be sending a message telling us that the hearing was going to be rescheduled to June 10th. The other is the email from the law clerk.
All right. So the hearing that was initially in May that Judge Hall did not want to reschedule was rescheduled for June 10th, 2021. Is that correct?
That is correct.
And ultimately, that would be to hear a number of things, but one of the most significant things would be your request for a list of all checking accounts from Alec, all identification of all accounts. Is that correct?
It is correct that that motion was going to be heard.
And ultimately, when the murders happened, I'm going to show you what's been marked as Exhibit 408. What happened to that particular hearing that was scheduled that way?
It was continued.
All right. And is that what's reflected in this email right here?
It is.
And then Exhibit 407?
It is.
After the murders happened, let me ask you this. You've known Alec and have worked with him for a number of cases, is that correct?
I had not worked with Alec in a number of cases, but I've known him for a long time.
Okay, but you were generally familiar with him as a lawyer, is that right?
I was.
And what was your assessment of his skills as a plaintiff lawyer? What was he particularly good at?
He was particularly good at reading people, making people feel like they were the most important person in the room, and capitalizing on surprise with the defense. You have a case with Alec. He hasn't done anything. It's Monday morning of the roster. Maybe you expect it to be continued. And he says, I'm ready for trial. And so he leveraged a lot of settlements that way.
All right. Was he good at understanding the emotional and sympathetic aspects of plaintiff's work and tort work that can be so crucial in defining what recoveries can be in these types of cases?
Yeah, I think he was particularly good at reading people and knowing what made people tick.
You've testified that you had made it very clear to the defense throughout this time period that you were seeking a substantial personal recovery from Alec and had been told, well, he's broke, which you then responded, I don't believe that. Show me the books, correct?
Correct.
And that was what was on the table for June 10th, 2021, correct?
Among other things, but
Among
yes.
other things. But that's on the table, correct?
Correct.
After the murders happened, did that have any effect on your assessment of the case against Alec, and particularly as it relates to the sympathies and the emotion of the case, which can be so important to recovery?
Yes. It did.
Explain that to the court then.
Well, initially, probably say the first week, there was the shock and horror of what had happened. And nobody really thought about anything other than that. But pretty quickly, I recognized that the case against Alec, if he were a victim of some vigilante, would in fact be over.
It would be over.
It would be over.
And explain just quickly to the court why that's the case.
Well, when you're asking for a money judgment, people have to be motivated to give you that money judgment. If you represent Attila the Hun versus some sweet old grandmother, nobody's going to give Attila the Hun money. They would give money to some sweet grandmother. So if Alec had been victimized by a vigilante, nobody would have brought a verdict back against Alec. And I had other defendants in the case, so I would have ended the case against Alec.
You would have ended the case against Alec with just...
I probably, certainly there was $500,000 in insurance that was offered. I may have tried to see if he could cobble together the $1 million, but whatever the last offer would have been from Alec's side, that would have been the offer that we took.
You had mentioned before that you had advised the defense of some of the mock jury presentations that you had done and some of the results from that and how they were very favorable to your case. Is that correct?
The defense and some of Alec's partners, but yes.
And it's fair to say, though, that as you just stated, that if Alec had been the victim of some sort of vigilante, those sympathies would have entirely changed as it related to Alec and Paul as well. Is that correct?
Certainly.
And that's led to what your assessment then in the wake of these murders. Is that correct?
Correct.
I think we can put the Parkinson thing to bed with Alex Murdaugh. He's not
At some
shaking.
point,
today.
did you receive any call or any communication from the Satterfields about any recovery in the Gloria Satterfield death?
At some point, my recollection is it's early September of 21. Eric Harriet came to my office about that. There are a number of articles in the paper or the papers that are talking about this previous wrongful death case and wrongful death settlement. And he came to my office at that time.
All right. And did you send them to someone?
I sent him to Eric Bland.
Hold on for me 1 second.
Again, Alex Murdaugh not shaking today, very intently listening as this case starts heating up against him. No more shaking, no more sobbing, no more trial antics.
Good morning, Mr. Tinsley.
How are you?
You testified at length to the state grand jury, basically this similar testimony you're giving here today. Is that correct?
The testimony I gave today is included in what I said to the state grand jury, yes.
And it seems like the gist of this is that you were suing Alex Murdaugh, who you believed was
Thank you, Sailor Perch.
underinsured for this incident, and you're going to go after his personal assets. And that was going to put some financial pressure on him. Is that correct?
Probably not exactly. I mean, I don't mean to quibble with you over the words you used, but I don't think it was financial pressure because I was holding him personally accountable. I was insistent that he pay. I didn't see how a payment plan on a settlement would put any pressure on Alec. It was sort of a deal that he couldn't turn down from where I sat.
But you were asking for money from
Oh,
him.
sure.
Yeah. And the inquiry here today is about money, his finances, correct?
I don't think so, but it certainly concerns his money.
And you're anticipating you're going to go to trial, is that correct?
Yes.
You're going to go to trial and get a verdict against Alex Murdaugh, correct? That was what you thought. That's where this was going.
No, I mean, I didn't see how any reasonable person wouldn't settle the case, especially Alec. So I expected the case to settle. 90% of cases settle, maybe 99. But if we had to try it, yes, we were going to try it.
And if he were unable to offer more money, then your expectation on, say, on June 7th, before these murders, your expectation was if he doesn't offer more money, we're going to trial.
Any money.
Right.
It was no money. No money had been offered.
So your expectation then was we're going to trial.
If you offer me no money in a case that I'm pursuing against you, then the response is we are going to trial.
And you were pretty far from trial on June 7th, 2021, were you not?
No,
You believe you were close to taking it to trial?
there was an urgency because John Tiller knew that he had about a year to live. And we were going to try that case. My expectation was early fall, late summer.
You expected to try the boat case in the summer of 2020, late summer of 2021?
August, September, October, sometime in that time.
You felt like you were only 2 or 3 months away from trial,
Sure.
even though we had all these pending motions that hadn't even been heard, including what venue to have?
I had tried the case 2 times with a Beaufort jury during COVID. I was ready to go to trial.
On that day, on June 7th, you hadn't even yet asserted a negligent entrustment claim against Alex Ed.
Well, I had with John Tiller. John Tiller knew and had agreed to the amendment. There were a number of things that Alex counsel had agreed to, including knowing that there was substantial punitive evidence in the case.
But you, at that time, you hadn't even asserted that claim to the court. That wasn't before the court, was it? That was just a conversation with John Tiller.
That's the conversation that mattered, because John Tiller would be the one who would object to the late presentation of the evidence, the late presentation of an expert, and he had agreed to all those things.
But he had objected to the financial discovery you asked for.
Well, there was an objection posed, correct?
But he did object to that.
When that answer was given in October or September of 20, it was an objection.
And the hearing that motion to compel the financial detail, the testimonies, that's just one of many motions that needed to be heard. Is that correct?
Correct.
There were many motions that had piled up and needed to be heard.
There were several.
There were several. Do you remember what they all were?
There was a motion to change venue. There was a motion to compel against Parker's. There was, Parker's had 1 or 2 motions. Some of the motions got resolved. One of which was this motion to assert admiralty in the case, and with the agreement that I would amend to assert your negligent entrustment claim, to get in all of the evidence that they knew I had. That was resolved that way.
You've had a lot of motions practice in this case with Parker's, haven't you?
More so since the murder.
But has that motions practice with Parker's been about the murders of Maggie and Paul?
Well, I mean, it's about it in the sense that that it certainly created a lot of additional issues to deal with, but not specifically.
There was a lot of motion practice about allegations of leaking of video from mediation, for example, correct?
I don't know about a lot, but I had filed a motion that I ultimately withdrew.
And you believe that you were going to drag Parker's to a trial within 2 or 3 months, late summer of June 7th, even though we have all these fairly preliminary motions that haven't been heard, change of venue, asking amend pleadings, motions to compel discovery.
Yeah, maybe you've never tried a civil case. So when COVID happened and everything was shut down for 2 months, I got my case together. My case is not dependent on, if I'm forced to try it, the bank institutions where he has accounts. My case is not dependent on the leaked video. That's a separate matter, and ended up being a separate lawsuit. So the answer is yes. I was ready to try my case.
And you didn't need, for example, an answer on the motion to compel that was pending against Parker's. You didn't actually need any of that stuff to go to trial against Parker's. Is that what you're saying?
You're talking about the percentage of financials, percentage of sales that alcohol made up in his profits? No, I didn't need that.
Well, let's put that up.
I wanted it, but I didn't need it.
Show you what's been marked as Defendant's Exhibit 82. You recognize that?
It appears to be my motion to compel against Greg Parker's company.
We pull up 82, please. And this is the document on the screen that I've handed to you. So we have, it's not just buried in here is some request for financial information, but you're requesting answers to request for production 3, request for production 11, request for production 16, request for production 17, which is financial information, request for production 18, request for production 19, request for production 20, request for production 22, request interrogatory number 5, interrogatory number 8, interrogatory number 9, interrogatory number 10, interrogatory number 12, interrogatory number 13, interrogatory number 15, interrogatory number 18. It seems like it's quite a bit of discovery you're demanding from Parker's in this motion.
Which I would have had the answer to on June 10th.
So you didn't-
Either I was getting it or I wasn't getting it, but my case wasn't dependent on these things. They may have helped my case. They may have put pressure on Parker's camp like I was trying to put pressure on Alex, but the trial wasn't dependent on these things.
And turning to the motion to compel Alex, first, do you believe that the Judge Hall's initial request in May to go forward with pending motion hearings was telegraphing a ruling on that specific motion, or do you believe that that was him looking at these motions piling up and wanting to get some movement?
Yeah, I think so. There's nobody in the courtroom, maybe even including me, that wants the case resolved more than Judge Hall.
And when the late Mr. Tiller asked for a continuance, you don't believe that was any kind of stalling tactic, do you?
No.
That was a legitimate health-based concern.
And if you read my emails, you would see that I immediately agreed to it. John Tiller was my friend.
With regards to what you're asking for from Alex, let's maybe pull that up. I believe the state has already marked this as an exhibit, but this is the motion to compel. Can we pull up 80, please? It's already been shown to you, but I'll show you when it's been marked as 80 for your reference. So this is asking for an order compelling production on interrogatories 9 and 10, and then a set of supplemental interrogatories and supplemental requests for production. Is that correct?
It is.
And if we turn to
And 9 and 10 are important as well. We didn't cover that, but I'm happy to speak to 9 and 10 because, 9 and 10 asked Alec about.
sir, no one's asked you about that.
Okay.
And we'll get to it, but first let's turn to answers to first supplemental interrogatories. This is the first page of Exhibit B. So we can see what it is that is being asked for.
There's no D in mine, I'm sorry.
B.
Oh,
Exhibit
B?
B. It's the first page of what's Exhibit B in here. It's right there. That's it. It's the first page after the motion, so it'd be page 9 of the PDF.
They're not
So
numbered, but
Mr. Waters asked you about this list of all checking savings accounts, retirement accounts, and then you don't have to highlight or expand this stuff. All stock, and then number 2, all stock certificates, and we go to the next page. All property and interest of property of every kind whatsoever, from February 24, 2019 forward. all life insurance policies, 4 or 5, all personal financial statements submitted to any bank, etc., profit sharing plans, pension plans, etc. Doesn't this look like supplemental discovery after you get a judgment? Supplemental proceedings?
I never had been involved in supplemental proceedings, so no, I don't think so. This is what my people needed answers to before they would agree to take anything that Alex would have offered.
In tort cases against individuals, in this case, a negligence in entrusting a boat and in an alcohol-related incident, before there's even motions for summary judgment, before there's any consideration of whether a case has been made for punitive damages, do you typically get this level of financial discovery of defendants?
I think so. I think the judge ultimately agreed to give it to me.
He agreed to give it to you?
Sure.
But I thought the hearing didn't happen.
Well, you thought wrong. There's a lot of papers, so maybe you got confused.
He granted this motion?
I think so. You want to see the order?
Yeah.
It's the record, October 7th, 2021.
And correct me if I'm wrong, what you've highlighted here is that Mr. Tiller, because of circumstances beyond his control, unable to gather, provide necessary information, answer requested interrogatories. Once the information is made available to Attorney Tiller, the court will schedule a hearing.
If necessary. You forgot the last part.
If necessary. The
Yes.
court will schedule a hearing
That's
if
right.
necessary.
Which
If
means,
Mr. Tiller, the attorney on the case, can from his own client get the information. This is no way says that the court granted this motion, does it, sir?
only to you, I think. I mean, it's clear that John said that Alex was unavailable because he was in rehab at the time. He couldn't get the material. He's going to get the material, and the judge ordered, you get the material, and if we need to schedule a hearing because you don't have the answers that you want, Mr. Tinsley, then we'll reschedule the hearing.
I mean, this is an order that says the court will schedule a hearing on this motion to compel if necessary. It's not granting the motion to compel, sir, is it?
Oh, I think so. I think if he was just going to deny it as you suggest, then it would have just said denied, or
If it was
it's
granted, would
premature.
you say granted?
Well, I think that's what it says. It's a practical matter when parties have discovery motions, oftentimes, like Alex is in his own statement said he was working on getting the answers. The reason is you give the answers because you don't want to face what could happen in the argument with the judge. So my point is that if the judge were going to say it's premature, you're not going to get it, it's denied, any of the things you suggested in your motion, he would have said that. That's not what he did. That's not what happened.
First of all, I just want to get the date that this order is, which is October 6, 2021. You asked for financial information in the motion that was pending against Parker's that was also going to be heard on June 10th.
It was different and for different reasons.
You asked for alcohol sales, correct?
What I explained to Judge Hall is that they say he's broke. And before let me finish my.
No, sir, I'm asking what you asked for from Parker's. I'm pretty sure that wasn't, they say he's broke. What were you asking for from Parker's?
I asked for, among other things, the percent of alcohol sales that made up his net profit, I believe.
And this was like a dram shop action against Parker's, correct? They sold the alcohol.
Like a dram shop action,
Okay.
yes.
And did you get a ruling on that? That request for that financial information from Parker's that was going to be heard on that June 10th day, just along with all these other motions that had piled up in a case that apparently wasn't moving very
Well,
quickly.
I understand you don't want to acknowledge what I've handed you, but.
Sir, I asked you what the ruling was on the motion.
Well, it-
compel from Parker's.
It was very limited, and as it related to the percent of sales of alcohol that made up his profit, it was premature. The judge ruled, unlike he did in that order I handed you, that it was premature at the time.
Why was it premature?
Well, The difference between Parker's and Alec is that Alec had, and his lawyers had 25 videos of alcohol. They had the punitive damages evidence. You didn't see that with Parker's. It was just a straight up transaction and sale. So to the extent you're suggesting that there wasn't this evidence, there were these mere allegations of negligent parenting, that wasn't the case. That wasn't the
You
argument.
presented that evidence to the court?
I didn't have to present it to the court. That's what you don't understand. John Tiller knew about it. John Tiller is the one who's responding because John Tiller knows ultimately he's going to be in front of the
You're saying
judge.
the court was granting your motion, though obviously it was saying there might be a hearing on the motion, and maybe at that hearing you would present some evidence in support. But
I don't think that's what it says.
I mean, you asked for financial information from Parker's. It was deemed premature because it related to punitive damages, correct?
It was different than the motion that related to Alec.
Because the law is how much money you have is a factor for punitive damages, correct?
Well, you're making statements of law. I'm telling you what was happening, and what was happening is that Alec's lawyers knew what the evidence was. They knew what the amendment was going to be and the allegations. And he knew ultimately he was going to be back in front of Judge Hall making some ridiculous argument that you're suggesting now.
And again, the gist of this is that there was perhaps going to be this judgment day, I think is a term the state has used, but that was going to be trial, right? That was going to be the verdict. That was going to be judgment day, not this motion hearing where there's a pile of motions that have piled up. And we saw the one that asked for financial information was deemed premature.
Not at all. You know, what was going on is, as I've said a number of times, Danny Henderson was very involved. Danny Henderson was a shareholder. Before I would have gotten the bank account information, before I would have seen the records, Danny Henderson would have seen those records. And I've seen the records. I've seen all the bank statements now. It would have been apparent to Danny Henderson, and I believe it would have been apparent to me what Alec had been doing. So that's the judgment day, is the discovery. And there were a lot of threads that were being pulled, and it was subject to unraveling at any moment. And if those records were disclosed, if Danny Henderson reviewed those records, he would have known there's no way Alec's getting these checks. There's no way these checks are going to Forge. There's no way that this money should be transferred.
And even if, hypothetically, had this hearing on the 10th and you got a different ruling regarding Alex Murdaugh than you got against Parker's, but for some reason it's not premature to him, isn't it true all you would have been enabled, all you could have gotten would have been a net worth statement, financial statement?
Not even remotely close.
Isn't that you don't, in your opinion, there's no case law out there saying that's what you get, you know, for that's the measure for punitive damages, net worth. There's no such case in your opinion as an attorney.
I had 7 circuit court orders where the circuit court had ruled that you don't bifurcate discovery, that it wouldn't be proper to have denied the motion. And then what are we going to do? We're going to try the case, and suddenly we're going to stop the trial and go and do the discovery? No. And so I had 7 circuit court orders that I handed up to Judge Hall that supported our position. I think that that's what Judge Hall did in his order. And again, you know, the issue is not that complicated. It's, does he have the ability to pay? Is he broke such that these people should accept this pitiful offer if he could cobble it together?
But sir, that's not what you get on a motion to compel, is it? Right? You just said ability to pay so your client can make a decision on whether to accept a settlement offer. But that is not what the motion to compel is about, is it? It's about evidence for trial. That's the legal standard, is it not?
No, the motion to compel was about putting pressure on Alec. I didn't really give 2 cents about whether or not he ultimately had money, because I knew he had money. I didn't need those things. The fact that he didn't want me to have them is the reason that I'm pushing it.
So,
I just didn't know why he didn't want me to have them at the time. I do now.
So the motion to compel was to put pressure on Alex. It wasn't about an expectation the judge was actually going to give you this stuff on June 10th?
If you're a good plaintiff's lawyer, everything you do in a case is to put pressure on the other side.
But the expectation of the outcome of a hearing on June 10th was not that you're going to get to launch a full-scale forensic audit because you had a conversation with someone whose lawyer said, oh, he's broke, and you didn't believe it. Not at that stage of the litigation, sir, is it? That's not what's going to happen, is it?
I don't think you need a full-scale forensic audit for something a 5-year-old could see. So, no.
You wanted pretrial ability to pay discovery to inform whether or not to accept compulsive discovery, compelled, so that your client could decide whether or not to take a settlement offer.
I know you don't like the answer, but I'm telling you, I did not care about the answer. What I cared about was putting pressure on Alex. I think that your assessment of the law is wrong, and I didn't really care whether I got it at the end of the day. I knew he didn't want me to have it. And so that's what I was doing, was putting pressure on him. It would have suited me fine not to have ever gotten anything and to leverage it into a settlement and gone on about my way. That's not what happened.
So the motion was not about obtaining information that may have been relevant at trial. It was about getting information to inform whether or not your client would take a settlement offer.
What I told Judge Hall was, they say he's broke. My people have lived in Hampton their entire lives. They do not believe he's broke. If he's broke, we need to open the books and let them see it so that they can then form an informed opinion about what they should do. It didn't have anything to do with the trial. It had to do with the case and resolving the case. And
then I think we briefly touched on Satterfield. Just to be clear, they came to you, the first time they came into your office, was September 21?
It's either late August or early September, but very early September. And since now I'm thinking that since the roadside shooting, whatever that ridiculousness was the 4th, it could have been August.
Okay. But it was well after June 7th.
It was after June 7th.
Thank you, Courts and Buildings. If the hearing had gone forward on June 10th, this was a Thursday, what outcome did you expect?
The same one that we got when it went forward. The judge hadn't seen.
Well, I mean, the outcome wouldn't have been the court will schedule a hearing. I mean, if the hearing had gone forward, what outcome would you have expected?
Well, now I know that Alex was working on Monday to get the information together. If the objection was sufficient, there's no reason he would be getting the information together on Monday. So I could have gotten the information. But since that didn't happen, if we had argued it, I think I would have had the same outcome. Because he didn't.
Let me just make it a little simpler. Would the court have issued an order? Right? Some order would have issued on the motion.
I would expect an order to issue.
Break it down. An order would have issued at some point later, and what if it were granting your motion? What would that order say?
I think it would say the same thing as.
Well, sir, that says a motion hearing will be scheduled if necessary. It obviously wouldn't say that. So, what would the order granting the motion say?
Look, again, what it says is that once Mr. Tiller gets the information from Alex, gives it to me, if necessary, if I deem it insufficient, then we'll have another hearing and we'll argue about it. So that's what I expect.
It's a voluntary disclosure, and then if you deem that insufficient, we go have a motion to compel hearing?
That's the way motions to compel go every single day.
So if you deemed it insufficient, if the court actually had to issue an order on your motion, what you would have gotten you've gotten his, would the law firm books have been open to you?
I don't know that I'm asking for the law firm books. I'm asking for Alex.
Right. Would you
Accounts.
have gotten, what, a financial statement? The
No.
court would have ordered every account detailed listed to you, all those personal accounts? Just because you asked for it to inform a settlement decision?
I was asking for the names of the institutions where he had accounts. I've told you that a couple
Right,
times.
to subpoena,
Sure.
and
But that's different
and
than
that would
him
have been
giving me.
resisted, and there would have been further litigation. This process would have taken some time, would it, if it was resisted, right?
I'm not sure if what was resisted.
If you got the names of the banks and issued subpoenas, there would be motions to quash the subpoenas.
Well, you're
Right.
speculating as same as you're asking me to speculate. I'm trying to talk to you about what the judge actually did and what was actually in front of the judge. I get you don't want to talk about that, but and we can speculate any number of things could have happened.
That at some point in the future, you would maybe get a voluntary disclosure, and if you didn't like it, then the motion would be heard, the motion to compel. That's what you say it says, right?
Well, if we had shown up and they had made the argument that you're advancing here, then maybe in this imaginary world, there's things that didn't happen, the judge would have actually ruled on it. We would have a ruling on whether or not it was relevant, whether or not I was entitled to it.
And you'd have been relevant for Alex, but not for Parker's.
Look, there are different things that are being asked here. And to your point, if it were the same, why didn't the judge sign the same order that you say he would have done? That's not what he did. At the same time we argued the Parker's motion, we argued the motion for Alec. And so he came to two different conclusions on those issues. One is he said it's premature. The other is that Mr. Tiller's going to get the information, give it to the plaintiffs, and if it's not sufficient, we'll have another hearing. I don't know how you can be any clearer than that. Judge, I've been thinking about you. Thank you.
So just, and maybe we can agree on this. The hearing had gone forward June 10th. That day would not have been some sort of judgment day when everything unravels, correct? There would have been further activity, maybe a voluntary disclosure, an analysis by you, whether it's adequate, another hearing if you thought it wasn't, maybe some subpoenas would go out. There was going to be some time after that. Is that fair?
I think it's fair to say that there wouldn't have been an explosion on June the 10th, but the fuse was lit the moment that information became available in the case. Not as much to me, but certainly to Danny Henderson, who would have, like the phone records, like some of the other materials, reviewed it before I got it. And Alec would have known that.
I mean, in that analogy, aren't you really saying that the fuse was lit when you were going after his assets, and that fuse was going to go down until trial because you're going to go to trial against him, and that's when the fuse would burn down?
I think the fuse was lit when he started stealing money. Yeah.
So it wasn't going to be lit on June 10th.
They're certainly getting a lot more oxygen.
Right. But it was lit way before, and it was going to keep burning well after June 10th.
I don't know about well after, but it wouldn't have been Judgment Day on June the 10th, but he would have known it was beginning to unravel.
Not Judgment Day. No further questions.
Yes, sir.
And that's really the point, isn't it, though, that had that hearing taken place on June 10th, 2021, it could potentially set in motion, or was going to set in motion, a process that ultimately would not have ended until there was either settlement or disclosure of that information, correct?
I believe so.
And so just the fact of that hearing taking place, and whether it's an order or representations by the defense or whatever it is, that process, if it occurs, starts and it has an inevitable conclusion, correct?
Objection. Your Honor.
There's only one.
Objection, Your Honor. Leading.
Don't lead the witness.
If the hearing takes place on June 10th, 2021, what is the net effect of what could happen at that point?
The discovery of everything he's done.
Whether it happens that day or some point in time.
Correct.
You had filed this motion to compel, or had you filed this motion to compel because you had been advised supposedly that Alex was broke and you didn't believe it?
Exclusively for that reason.
And you believed that if he was broke, he had to be hiding assets.
And if he were hiding assets, he didn't want me to discover it, which would be the pressure point.
Were you merely asking for a financial declaration at this June 10th, 21 hearing?
No, I was, it's broader than that, but I wanted the institutions because I knew I couldn't trust the number I would have gotten
From Alec.
from Ellen.
You were asked a little bit about having not pled certain theories yet at this point in time, such as negligent entrustment. Can you explain a little bit about why that was, if that was still out there?
It was only out there in the sense of the pleadings that were on file. I mean, John Tiller had already agreed to the amendment. It was already coming. I had shown him the videos a long time before that of alcohol, the Facebook, social media likes of Paul consuming alcohol, having alcohol. So only on the documents that were filed.
So were those issues, though, in play in your conversations with the defense?
I'm sorry?
Were those issues already in play in your conversations with the defense?
I'm not quite following you. Which issues?
Additional theories of liability that might not have been filed.
Oh, absolutely. No, I mean, those were, all I'm saying is that the black ink wasn't on the white paper, but John Tiller knew we had discussed, these are the issues.
I'm gonna hand this back to you, but I'll show you what's been marked as States 407 so you can recognize that.
Yeah, the order that I handed, whatever that lawyer's name was.
Mr. Barber?
Yes.
And that's from October of 2021, is that correct?
It is.
You had previously testified that $1 million, was not going to be enough, at least prior to the murders. Is that correct?
Correct.
Had you come up with a number that had been conveyed that was far, far in excess of that?
A demand to Alec?
Yes.
Yes.
And that also included signing over Moselle and Edisto,
It was an option.
as well as a payment plan?
Payment plan was an option. I mean, it was, you could pay this amount, you can sign over these properties, work out a payment plan on the balance. I didn't care how we got it done. It was just a matter of him doing it.
Was the payment plan an option because you believe that he still would have a lucrative law practice from which he could generate money to pay your clients?
Yes.
Thank you, Your Honor.
Anything further?
Nothing, Your Honor.
Thank you.
Thank you, Your Honor.
Step down. Next witness.
Your Honor, our couple things. Our next witness would be Ronnie Crosby. Just to let the court know, your court indicated Friday that we had kind of already established as far as clear and convincing evidence on the law firm issues. Mr. Crosby would be here about that meeting I referenced to, Your Honor, just to establish the circumstances of that. I don't plan at this time to get into testimony that he may offer about the circumstances of the fake forge and all of that, based on Your Honor saying that you had heard sufficient evidence regarding that. So I just wanted to make sure that was acceptable to the court. I did want to cross the bridge, though, of this meeting on June the 10th as to the circumstances of it. Again, and thus that if there was no attorney-client privilege to that because of the presence of third parties, then at that time, we don't have to do it on the stand, but I would, make myself and prep in the evening or whatever, privy to that particular conversation.
Any other comment about the attorney-client privilege issue, Mr. Griffin?
Your Honor, I'm still at a loss as to what he's attempting to accomplish through this.
He wants to call
Right.
some of the folks as witnesses who were there when you were there, along with Mr. Murdaugh.
And so it is the question, these witnesses are going to testify as to what Alec and I were talking about, because we've had attorney-client privilege conversations every day in this courtroom, and there are 250 people in this room. Does that mean that the conversations are not privileged? I don't think so. And so it really is more nuanced than is someone else in the room. And I don't know if they overheard anything that I talked to Mr. Murdaugh about, and that's where this is going. Or if the question is Mr. Murdaugh talking to Mr. Crosby, and is that privilege? Or Mr. Murdaugh talking to Mr. Lee Coke, and is that privilege? I'm at a loss here.
I don't know either, but I say, as far as the law is concerned, that Mr. Griffin was not the lawyer for Mr. Crosby or any other party. Mr. Griffin was solely the lawyer for Mr. Murdaugh. So there is no attorney-client privilege involving people that Mr. Griffin does not represent.
Sure, and I guess what I'm actually trying out of an abundance of caution to protect his attorney-client privilege. I mean, Mr. Griffin says he's at a loss when I've been bending over backwards to make sure I'm not privy to something that Your Honor might find productive.
I don't know what you're seeking. There is no attorney-client privilege involving people that Mr. Griffin does not represent. If you have them as witnesses and you want to call them as witnesses, if there are necessary witnesses to this hearing, you may proceed.
All right. Thank you, Your Honor. We would call Ronnie Crosby to the stand.
Raise your right hand.
Okay, that is fine.
Sorry, guys, I didn't realize my microphone was turned off. I was going to say that this is kind of huge because they're being able to call a witness that does not have attorney-client privilege just because they spoke with the attorney.
Left hand on the Bible.
This is going to be very interesting.
The court in this trial shall be the truth, so help you God.
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Ronnie Crosby, Crosby, Crosby.
Mr. Crosby, how are you?
I'm okay.
All right. Tell the court what your profession is and where you work.
I am an attorney that practicing law with the Parker Law Group.
And are you a former law partner of the defendant, Alex Murdaugh?
I am.
You see him in the courtroom here?
I do.
And where is he sitting?
He is sitting between Mr. Griffin and Mr. Harpootlian at the defense table.
On, and again, this is an in-camera hearing, so you understand I'm not exploring everything that might, depending on the judge's ruling, be before a jury, but I do want to explore a particular meeting. Were you present for a meeting with, in which the defendant spoke on June 10th, 2021?
I was.
And at this particular meeting, can you tell the court who all was present?
I'm not going to swear that I don't miss somebody because it was a fluid event. My recollection is it would have been late morning, midday that we gathered at Alex brother John Marvin's place, which is not very far from Alameda that I've been talking about. And I know I'd been by to see Mr. Randolph that morning. There was going to be a meeting with law enforcement. They had given Alec a couple of days before they were meeting with him. And so we gathered there. I was present. Mark Ball was present. Lee Cope was present. John Marvin was present. At some point, I believe, I don't remember exactly when Buster arrived. Jim Griffin arrived at some point. And I want to say Corey Fleming was there. And there could have been others.
All right. While that group of people were assembled, did the defendant, and I don't want to get into the content, but the defendant make any statements about what had happened on the night of June 7th, 2021?
He did. We were there as friends. We had been with him starting the night of the murders every day. And we were there for support. And he went over the events of that afternoon or that evening, starting from the time he got home from work until the discovery of Paul and Maggie.
Where was this discussion taking place? Was it inside, outside?
We were in John's house there. I guess, I don't know if he calls it a house or a hunting lodge, but we were inside. But largely, I mean, there was some in and out of the house as well, but the majority, we were all sitting in a room together. And I was doing more listening than talking.
And were these the statements being made by the defendant? Were they being made quietly to his counsel, or were they being made openly to all the people in the room?
Well, the statements that I heard obviously were being, for me to hear them, I was not overhearing a conversation that was private between Mr. Griffin and Mr. Murdaugh. They did have some private conversations that the rest of us were not privy to, but so there's a mixture of that.
But there were private conversations that you don't know what they were because you weren't privy to those, correct?
Correct. And this was before, I believe, the South Carolina Law Enforcement Division agents arrived at this location.
To be clear for the court, you did at other times, aside from this meeting or this discussion, have conversations with Alec about his activities the night of June 7th, 2021. They were outside of this. Is that correct?
Well, that's correct. I mean, obviously, we all were in shock, but also wanted to try to find out what all had went on because we, as we got past that night of June 7th and the morning of June 8th, we're all, trying to help find out what had happened and who may have been a potential suspect.
But in this investigation and in preparation, you were instructed to stay away from those until from that meeting, as opposed to the other ones that weren't in that meeting, out of an abundance of caution until we could get guidance from the court as to whether or not those in any way were protected. Is that correct?
That's correct. I mean, I We had multiple conversations, as you might expect, all of us in a group, and there may be pieces and parts. But what you and I have discussed up until now have been outside of what was discussed on June 10th at John Marvin's house.
Your Honor, I don't believe I have anything further for purposes of this matter.
Anything further?
Please, court. Crosby, I believe Danny Henderson was also there.
Yeah, I told you I might miss one, but Danny was there. I don't think Danny was there at first, but he ultimately arrived.
And the meeting had been scheduled so that Alec and others, Brother Randy, for one, and John Marvin and Buster could be interviewed by SLED. Is that correct?
That's correct. The purpose was to, that SLED had scheduled a time, and I don't know who scheduled it with, and you're correct, Randy was there. And it was essentially going over the timeline of the evening of the 7th, because knowing that that Alec was going to be interviewed, and I think Buster was, and maybe Randy and John Marvin over the course of that afternoon.
And you were not scheduled to be interviewed, correct?
I was not scheduled to be interviewed. And Jim, now that you speak of it, I do think that while Mr. Randolph did not come into the meeting, he and whoever brought him over did come by. Right. There are two that I'd forgotten.
Yeah, and
then went back to Alameda.
Where he died within hours of that, right?
He died as we were leaving, or right after we left this meeting with law enforcement. We were on our way back to, and Randy got a call.
Did you sit in any of the interviews conducted by SLED in the car?
I did not.
Okay. And Lee Cope was there, and he was not to be interviewed, right? That's not why he was present.
We were there as friends to provide support and listen.
And Mark Ball also was present.
Mark was, and I know Mark had some meetings with law enforcement about some concerns that he had, not about potential suspects and safety of.
And had you recall whether you and or Mark and Lee had given Alex some advice about whether he needed to have a lawyer at this interview?
I don't remember that specifically, but knowing that you were already involved, I mean, any of us would have thought it was a good idea.
Okay. What do you know whether Alec considered you and Mark and Lee, as well as Danny and Corey, as his counsel that day? I mean, do you know what he was thinking?
I don't know what he was thinking, but he never approached me as his lawyer, or throughout this, I never had the perception that I was representing him. Well,
did you, or in your presence, Mark Ball or Lee Cope, make it clear to Alec that, hey, we're not your lawyers here, and if you talk to Jim Griffin in my presence, then there goes the attorney-client privilege? Did you give him that warning?
Mr. Griffin, we're all lawyers. I don't, other than John and Buster that were there, I don't think anybody needed to say that. And it never crossed my mind that when we were sitting in a room and all of us were talking, that we were somehow representing Alec.
No, I understand that. Okay.
And nor would I ever do that, because I don't practice in the area that you do.
Right. But it's clear that Danny had an ongoing attorney-client relationship with Alec. Is that right?
He did. With regard to the boating accident, he was Alec's personal counsel in that.
And Danny had sat in the initial interview that was conducted by SLED Agent Owen and Collin County Deputy Laura Rutland on the night of June the 7th. Are you aware of that?
Yes, I was aware of that.
Okay. And he was representing Alec during that interview, as far as you know.
I don't know. I saw, I mean, I know when Alec got in the car, we felt like one of us ought to sit in there with him, you know, for support because
Well, can you say for certain that whenever you heard conversations from Alec about his recollection of what happened on the 7th, that there were any non-lawyers in the room? And I guess non-lawyers have been Buster and John Marvin. I mean, can you say for certain there were no non-lawyers in the room?
there were,
That you're referring to hearing conversations with Alec in the group about what happened on the evening, the events of the evening of June the 7th. And my question to you is when Alec was making these statements, let me make it clear, were they just lawyers in the room?
I can tell you that John and Buster were there for points of time. Can I tell you who was sitting and where they're, you know, where John had walked out when I heard any specific thing? I can't tell you that. I couldn't catalog, because I said it's a little bit fluid. People come and go, and, you know, law enforcement arriving outside and people walking out to greet them. I mean, it wasn't like the sled agents just showed up and it was, you know, some rigid thing where you walked out. I mean, there was small talk going on with the officers as well.
Sure. Okay. 1 second, Your Honor, please. That's all the questions I have, Your Honor.
Nothing further, Your Honor.
Thank you. This issue.
This particular issue, no, I know that's a little bit different than the larger issue we've been dealing with, and I'll certainly be happy to argue that further if the court would like. As far as the larger issues, one of the things that we, in discussions with the defense, that we've stayed away from so far in testimony is the side of the road. And that might be the other piece of the puzzle a little bit that might need some in-camera testimony as I think all of this through. I know that we're butting up with the jury being here shortly, but
That can be done at a later time.
yes, sir.
Anything further on this issue regarding evidence of other crimes?
Aside from the side of the road, not at this time, no, Your Honor.
Do you have other witnesses to present on any other issue at this time?
No, sir, other than I had a summary witness for the side of the road, but you know, that would be it. As again, for in-camera proceedings before Your Honor, to get a handle on all of the sort of the 404 stuff that we're talking about.
All right.
No, that would be it. That's that side of the road.
We'll take a break of about 5 minutes, and I will announce my decision regarding this other evidence.
So a lot of things going on in this trial. A few things that I noticed right off the bat is you don't see Alex Murdaugh shaking like we did at the beginning when they had, you know, witnesses that weren't doing anything but really just entering items into evidence and stuff like that. I'm seeing, and I have seen over the last few days, a change in demeanor in Alex Murdaugh behind that defendant's table. And it's just, to me, he seems like he's getting a little concerned. And I really, truly believe he's starting to get concerned. This is really heating up, in my opinion. I think the prosecution is doing a great job at, you know, whittling away at what the defense may bring up as a plausible reason. The defense seems to me, just my opinion, maybe people agree, maybe people don't agree, but in my opinion, it to me seems as if they're desperate, like they're grasping at straws, and they have to go so hard at these people on the witness stand and insult them, and it just, to try to undermine them and demean them because they don't really have the facts on their side to do it legitimately. So they have to almost shame them, if you will, when they're giving testimony. Does anybody else feel that way related to this case? If you do, put a 1 in the chat box. I'm going to try to see if I can get to some of the questions. Defense caused all of this. They have themselves to blame. They better watch after the trail ends. Alex will be gunning for them for sure. Holy crap. Well, hopefully Alex will be broke going into jail. But you know what? His family, I don't know. Like, I'm scared. Like, his family could very well, they're still a very powerful family, and there's still a lot of them. These poor witnesses, what they may need to move. Florida's available. Trust me, we got building going up everywhere. Not that we need any more people in Florida, but if you're looking, come to Florida. Okay. Let's see. Yeah, so getting a lot of 1s in here. The money trail is getting to him. Yes. And this, if I'm not misunderstanding, I was on the road at the time. And correct me if I'm wrong, but I remember Miss Robin telling me that the defense accidentally opened the door to the financial motivation. Is that true? Because I'm curious about that. Because if the defense opened this up, man, no wonder, the defendant is sitting there, because he's not looking too happy. He's definitely not remembering to shake anymore, and he's so that I mean, we at least figured out he does not have Parkinson's disease. Okay, a lot of people were throwing up Parkinson's disease as to why he was shaking. We now know that Parkinson's doesn't go away. I mean, it's there all the time. I know people with Parkinson's. It's there when they're stressed out. It's there when you're happy. It's there when you're sad. It's there all the time. It gets, during the mornings are not as bad. Sometimes it's the evening. Sometimes it's just the opposite. I don't know. So let's see here. No matter what goes on in the trial, AM has numerous changes to his face. Yes, they did. Yep. They brought up the boat accident, which opened the door. Yep, got it. Boy, I bet Alec is pissed. Yes, the defense opened a cross-examination of a witness. I'll be darned. God don't like ugly. God don't like ugly. There's just too many. I mean, everybody wants to talk, but how many, just like kind of with the Wells family, like how do you have 2 people that just seemingly disappear 10 years apart from each other? I mean, that just doesn't happen. So, like, now you've got a man that has 4 people in and around him. Like, I know a few people that have died from natural causes, but this kind of stuff, no. I as crazy as my life has and has always been, no, I don't. And to have his think about it, 3 people. Could we have to consider the nanny, the house care person, almost as an extended part of the family? She was there every day for what, 20 or 30 years? She raised the children. She was the nanny to the kids, so you're talking about 3 immediate family members in a matter of, when did she go? 2008, and they went 2021. So in a matter of 3 years, the only 2 out of 5 people are still standing, and one's trying to off himself in a plot with cousin Eddie. Yeah, something doesn't sound right to me. I think the judge is going to allow the boat accident evidence in. I think so too, because I mean, he was sharp to say to those attorneys, there's no perceived attorney-client privilege if that's not even your client. Like, you can't assert attorney-client privilege for somebody that's not your client. And like, even the prosecution didn't really have to say much. Like, the judge was on top of it. I mean, that judge doesn't seem like he's playing much. He wants to know who to hold accountable for this. It sounds like he wants to uphold the letter of the law. I'm very thankful for that. This seems like a very, in so far of everything I've seen, this seems like a very qualified judge, a very fair judge. And I think he's ruling appropriately for the least amount of appeals. They're going to, no matter what, they're going to appeal. Okay, let's just be honest. They're going to appeal. That's what they do. So, it's just making sure that all your I's are dotted and your T's are crossed. So when the appeals go forward, they really kind of, they don't really survive. That's really what you want. You want the appeals to go through the normal process, but to ultimately be dismissed. So we'll see. Yeah, and if you guys have not been over to the Bullhorn Betty True Crime Facebook group, you should go over there. This is where a lot of cases, even stuff that we don't talk about here, are put. You can see, I know they have just open discussions and conversations to new missing persons, to sometimes you get some really good up-to-date information on breaking cases as they're posting those things into the chat. So get on over there, sign up. You have to be fully vetted, so make sure you answer all the questions or you will not get in. My girls, they have the lockdown on the Facebook group. They have the lockdown on the Facebook group. So answer all the questions so they can make sure you're who you are. We don't want anybody in there that doesn't belong, right? So Crazy Mama Nana says, I hope the judge lets it in. So I guess we're going to get his ruling soon. Now, there may be part of that can come in because there were several people that went up there. Well, actually, no, it wasn't several. They just did wasn't it two? Yeah, it was two different people. Am I right about that, 2 or 3? I can't remember. I should probably go back and look. Hold on, let me see if I can go back and look. Let's see. Yeah, 2 people. 2 people. That guy, the other attorney. So it's all based on attorney-client privilege arguments, it appears. So they have the 2 attorneys. So one may be let in while the other one may be excluded. One may be, both may be excluded, but both may be let in. So we're waiting on the ruling of the judge. Right now we're at, I can't even see that. We're at 11:30. This is really when the judge told the jury to come in. Obviously, they're on break while he reviews probably the law and, makes his determination, his ruling on this. This was very impactful information. I can tell you that first attorney seemed like that they were very nervous about him, because the second one, just about the conversation that was had in the house right before agents went there to arrest Alex Murdaugh, it sounds like. Which I don't know if he was arrested on June 10th, but there was something, they must have executed a search warrant or so. I don't remember all the facts or details related to it. So in an effort, I don't know why the cops were there on June 10th, but the second guy was about conversations that he had with Mr. Griffin. Mr. Griffin was the one that was questioning him because they do not have an attorney-client, and he was wanting to talk about a conversation he had with them or overheard him having with Alec. And they're trying to determine whether that was perceived to be in confines, in privacy. And he's saying, well, there, where he was sitting, for him to overhear it around all those people, it obviously wasn't a private conversation. However, they did have private conversations, and he didn't know what they talked about because they were private conversations. Can Buster claim any life insurance policy on his mother and brother when Alec gets an orange suit? Emma, that is a great question. I don't know. I don't know the answer to that question. It really depends on whether he was on the policy as a beneficiary. Because if only Alec was on the policy, in my opinion, now I'm not legally speaking here. This is just, just based upon my experience. I could be completely wrong. It's really how the insurance policy is written up. But in my knowledge, which I used to hold a 215 insurance license as well. I sold insurance at one point in time. I haven't sold insurance, cutthroat industry, very tough, but did work well in it. It really does depend on the policy and how long that policy has been in place. So, for example, if a policy has been in place for, say, 30 years, the requirements 30 years ago may have been much more lax than they are today. So those policies are grandfathered in. So say if the insurance didn't talk about, suicide or other claims that they won't pay out for, I'm sure murder being one of them, I'd have to think that would that may stop that. But if there's a second, that would preclude that one person potentially. Some policies didn't have all that language in there, and depending on how long that policy has been, they could be grandfathered into a policy that pays out basically no matter what. But other policies, as laws came into place or they found something happen, they would put stuff in their policies. That's why when you get policies, they're 15 million pages long, because that's everything they've been sued over. Pretty much. That's a disclaimer on basically every lawsuit. But anyways, I don't know the answer to that. I really don't. It really depends. But it could, if he was a beneficiary on that and Alex is no longer able to be a beneficiary because, say, he murdered the people, then yeah, Buster might be the only beneficiary to that policy and could recoup the entire thing. I don't know how it is. So yes and no, I guess. Betty, your roast beef looked amazing. It's not roast beef. It's not. You know what it was? It was prime ribeye roast. So it's almost like prime rib, but I cook it and it tastes better. Like that, believe it or not, while my camera was turned off, I went and sliced some off. And so I had, I already had some today. I had it like at 10:30. Shh, don't tell anybody. So I already ate, and I had lima beans with it, and I had Cracker Barrel now makes a mac and cheese. It's like, seriously, oh, they're coming back. Mac and cheese, it's good. So I had that, lima beans, and mac and cheese.
Please be seated.
This issue is before me on the motion of the state to admit evidence pursuant to Rule 404B of the South Carolina Rules of Evidence, and also under the theory of res gestae. Of course, the defendant is on trial for murder of his wife and son. And over the course of the past several days, we have conducted an extensive in-camera hearing. The court has reviewed all of the exhibits submitted and I've considered the testimony of each and every witnesses, and I have concluded that the motion should be granted. Under the law of this state, evidence of other crimes is not admissible to prove the character of the person in order to show action in conformity therewith. An exception, however, exists when the evidence is offered to show motive, identity, the existence of a common scheme or plan, the absence of mistake, or accident, or intent.
Holy crap.
Before admitting this evidence, the
It
court
sounds like
must
they're
first
letting it in.
determine if it's relevant. Our rules define relevance as evidence having any tendency to make the existence of any fact that is of consequence to the determination of the case more probable or less probable than it would be without the evidence. After determining relevance, the court must determine if the evidence falls within an exception to Rule 404. In determining if an exception exists, the evidence must be logically relevant to the particular purpose or purposes for which it is sought to be introduced. And this requires the court to analyze whether a logical nexus exists. Evidence is logically relevant when it reasonably tends to prove a material fact and issue. And of course, the evidence of any other crime offered to be admitted into evidence or proven or testified to must be proven by clear and convincing evidence. And the court is to conduct and required to conduct an analysis under Rule 403, which weighs the probative value versus the prejudicial effect.
Where's the head bobbing? Where's the
According to
head bobbing?
state, the nexus is supported by the unusual circumstances of the murders, in that the defendant was the last person to see his wife and son alive, and the one who discovered the bodies, all in a relatively short period of time. The state has presented evidence in this in-camera hearing, evidence of numerous financial crimes allegedly committed by Mr. Murdaugh. The state argues that the logical nexus between the murders and other crimes is that the looming exposure of financial crimes provided motive for the murders and is evidence of malice, an essential element of the crime of murder. On June 7th, the defendant was confronted about $792,000 missing from the law firm. Beyond that sum, the state contends that millions of dollars were misappropriated by the defendant, and this misappropriation would imminently be exposed. We've heard from the bookkeeper for the law firm, Gene Seckinger, who testified to confronting the defendant on the day of the murders about the missing $792,000 from a case that he worked on with attorney Chris Wilson. She had previously questioned Mr. Murdaugh concerning the improper disbursement of fees in the case of the estate versus Hirschberger, wherein it's alleged that Mr. Murdaugh sought to put the fees in the name of his wife, Maggie, to hide them from discovery in the boat case. She testified that the firm conducted a forensic audit, which then documented millions of dollars of misappropriated funds by the defendants, funds that the law firm had to replace. The defendant and his son, Paul, had been sued following the fatal boat crash, and the defendant had been served a motion to compel production of his financial information. On the day of the murders, according to the testimony, the defendant was preparing for the motion to compel, which was set to convene in 3 days. We've heard testimony from Jan Milanowski, the president and CEO of Palmetto State Bank, who provided testimony and documentation to millions of dollars owed by the defendant to Palmetto State Bank, all while the defendant was frequently carrying a substantial negative account balances. Michael Gunn, a consultant with Forge Consulting, testified that the defendant created a fake bank account using the firm name of Forge. And according to the testimony of Ms. Seckinger, this fake account was used as a main depository for a substantial, if not most of the appropriated funds. We heard testimony from Attorney Chris Wilson about confronting the defendant about the missing $792 and the personal sum to him owed of $192,000 was later discovered. And that testimony or that confrontation took place on June 7th. Mr. Murdaugh later confessed to having stolen those funds along with committing a multitude of other crimes, and also claimed to be suffering from drug addiction. We heard from Michael Satterfield, who Mr. Murdaugh, according to him, represented in a lawsuit against himself involving the death of Gloria Satterfield, Michael Satterfield's mother, who was the housekeeper of Mr. Murdaugh. He testified that he'd heard of through the reports that money had been recovered in the case. And when he discussed it with Mr. Murdaugh told him that no money had been recovered and it would take a year or so. It was later revealed that money had been recovered and that a confession of judgment was later issued in the sum of $4,304,000. Also received testimony from Mr. Carson Burney from the State Attorney General's office, who traced funds in and out of the bank account. I find that the jury is entitled to consider whether the apparent desperation of Mr. Murdaugh, because of his dire financial situation, the threat of being exposed for committing the crimes which he was later charged with, resulted in the commission of the alleged crimes. While motive is not a necessary element, the state must prove malice, and evidence of motive may be used to prove it. And in this case, since the identity of the perpetrator is a critical element that must be proven beyond a reasonable doubt, evidence of motive may be used in an attempt to meet that burden. This evidence of other crimes is admissible and it's non-propensatory, as it does not suggest to the jury that the defendant has a tendency to commit murder. I specifically find that these other crimes will not lure the jury into declaring guilt on a different ground or than the specific charge. Thus, it's not Thus, it is non-propensatory evidence and is supported by state law. Therefore, this non-propensatory evidence of other crimes is admissible under Rule 404B and Rule 403, and that the evidence, which may be prejudicial, but it's more probative than prejudicial. As to res geste, the state alleges that Mr. Murdaugh was under immense pressure after being confronted about the missing fees, the upcoming hearing on the motion to compel his financial information, his dire financial straits, and looming exposure of this criminal activity. And the state contends that that situation led to the murder of Maggie and Paul Murdaugh. Our courts have held that where evidence of other crimes is an integral part of the crime for which a defendant is charged, or it is needed to aid the jury in understanding the context with which the crime occurred, then that evidence is admissible under the theory of res geste or res gestae, as some might pronounce it. I find that the activities and conduct as of the defendant on June 7th, 2021, as testified to, is admissible under res geste, and that this evidence furnishes a part of the context of the alleged crime. It's necessary to the full presentation of the case, which the state is entitled, particularly since the state is relying heavily on circumstantial evidence. I find that it is so intimately connected with and explanatory of the crime charged under the theory that the state is seeking to prove, that proof of it is essential to complete the story. Our courts have further declared that where the full presentation of the evidence is admissible, that there is no reason to fragmentize the events under inquiry by suppressing parts of the res geste. Further, in State v. McGee, the court held that where res geste, evidence of res geste or part of res geste is properly admitted, then no 404B or Lyle analysis is reached. However, as to the finding of admissibility of evidence, which I have done, and the finding of it within the res geste, I've nevertheless conducted a Rule 404B analysis or Lyle analysis, though not needed. In conclusion, the state's motion to admit the other evidence or evidence of other crimes is admitted. I will file a more formal order granting the state's motion later today. Are we ready for the jury?
I believe we are.
Your Honor, one point on Your Honor's ruling. I don't know that they're getting into the financial stuff immediately, but we do have a proposed limiting instruction that we would request the court to give at the time they offer the evidence. And so,
Yeah, thank you very much. And certainly upon request of
This is
the
bad.
defense, the court is required to give a limiting instruction.
Schedule will probably be late afternoon or tomorrow when we started to cross into some of those financial witnesses.
Have you reviewed the defendant's proposed limiting instruction?
Got it right now, Your Honor.
They're looking at something. I think they're kind of in shock about what they're wanting to limit. So it looks like they must have given him some proposed letters and he's checking it against it possibly. I don't think they should limit anything. I think they should keep it to the confines of what they discussed before the judge, in my opinion. But they've turned off turned off the microphones because you can't hear anybody moving about in the courtroom. So he's looking at it. He's making some adjustments on it now. And so they're having their discussion right now. Looks like the defense is listening intensely. Now looks like he might be objecting.
You want me to give this after the testimony or before the testimony?
But before the testimony is offered, Your Honor, from a financial witness.
And after he's like,
That's fine, Your Honor. I would just, as to the specific language here, obviously it has the next to the last sentence as it's being allowed, and it makes a specific representation about the state. It only refers to motive, not identity. It's more of a 404, not arrest geste. I don't know that that sentence is necessary. The last sentence, I think, also has a typo in it. But I would
has to point that out.
generally, though, I have no problem with this charge, and I have no problem with it being given before such financial evidence is received.
You've indicated those witnesses will testify later today or tomorrow?
Probably not late today, but almost certainly tomorrow.
All right. Well, you have an opportunity to submit your own proposed limiting instruction or to confer with the defense counsel and see if you all agree.
Absolutely. We'll work on that, Your Honor.
Yeah. Of course, you have the other question of race geste and whether or not a limiting instruction is required for race geste testimony.
No, I understand, Your Honor, and I guess I understood the scope of the court's ruling to go beyond res geste or gesti and to include prior events he wasn't confronted about on June 7th. Now, if the court's ruling is limited to the confrontation on June 7th and about that transaction, then it would be res geste.
It's not limited to June 7th. June 7th also includes race geste, but the ruling includes all evidence of financial crimes that may likely have led to a motive, lend itself to motive for the crime committed. And that may be before or after.
Yes, I understand the court's ruling. I will, for the record, when it's offered, just make a formal objection to protect the record. Your
Yes,
Honor,
sir. I understand.
showing no disrespect to the court.
No, I understand. Okay, we're ready for the jury?
State's ready to proceed, Your Honor.
Bring them on.
This is going to be pretty epic tomorrow when they bring all the financial stuff in.
Thank you. Good morning. It's right at noon. Well, 11:58. It's still morning. We embark on day number 11. Call your next witness.
Please go. Yes, sir. From the state of South Carolina, we now call Miss Michelle Smith to the stand.
How you doing? Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God? Yes. Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
Michelle Shelley Smith.
Take a deep breath.
Yes.
What is your first name?
Michelle,
Spell that, please.
Mushell.
Where'd you get that name from?
My auntie named me.
And where did she get that name from?
I don't know.
Is it Michelle with a U?
You, yes, correct.
During the course of this, if you don't mind, is it okay if I call you Miss Smith or Miss Shelley or Shelley? I really don't know what's going to come out of my mouth sometimes. Is that okay?
That's okay.
But do you go by Shelley?
Yes.
Please tell these folks, Ms. Smith, about Michelle Smith, where you were born, where you were raised, please.
Hampton, South Carolina.
And ma'am, if you don't mind just pulling this up a little bit and speaking into it.
Okay, thank you.
Thank you. Go ahead.
I was born in Hampton County. Have 4 grown kids.
Louder, Ms. Smith.
I was born in Hampton County, 4 grown kids, 8 grands. And I worked for the Hampton County District for the last 28 years. Food service is my professional.
Pull that chair up. I just want you to be comfortable. Like you said, you had 4 adult kids.
Yes,
Then you said 6 to 8 grands.
it's 8 grands.
8 grands. Okay. And raised where?
Hampton, South
Where-
Carolina.
Okay. Where'd you go to high school?
Wade Hampton High School.
And what did you do after high school, Ms. Smith?
Got married, raised my kids, and that's what my profession, that's it. Mhm.
And that is the hardest profession, raising children.
Yes,
You had 4 kids.
4 kids.
And when you were raising them, you were raising them, taking care of the
Yes,
family.
mhm.
And are any of your family here today?
Yes, my brother and my daughter,
What's your brother's name?
Michael Smith.
Michael Smith, will you stand up? Is that your brother?
Yes, that's my brother.
And who else is here?
My daughter, Rochelle.
Miss Rochelle, will you stand up? Thank you. They here supporting you today?
Yes,
Don't take this the wrong way, but other than raising a family, which is the hardest job, were you doing anything else during that time period?
no, till 1995, I started working at the school district.
Okay. Did you work in your church while you were raising your family?
Yes, I worked at church.
Okay, and that's what I'm asking. What did you do with your church while you were raising your family?
Usher, kitchen ministry.
Kitchen ministry?
Mhm. Yes,
And how long did you do that?
all my life, church.
Are you still doing that?
Yes,
And you don't have to name your church, but where's your church located?
Fairfax, South Carolina.
So at some point after your children moved up in years or got older, did you start another profession?
Yes,
Okay. And tell the ladies and gentlemen what that was, please, ma'am.
private home care,
I'm sorry?
private home care, caregiver.
How did you get into that?
My aunt,
And was she in that business?
yes, she's an LPN. Yes,
An LPN?
Yes.
Licensed practical nurse?
yes.
And when did you get in the home care business?
Probably about 10 or 12 years ago.
Now, prior to that, had you already started with the school?
Yes, I'm still at the school also.
Okay, tell them when you started with the school.
The school in 1995, that's correct, 1995.
And what school did you start with?
At North District Middle School in Warrenville, South Carolina.
North Central Middle, Varnville.
North District Middle School,
North-
yes.
What did you do for them?
Food service.
And how long did you do that at that school?
I've been there for 19 years at North District Middle School.
After that, did you change
Yes.
locations?
Yes, 6 years later, I went to Wade Hampton High School,
And for those of us that don't know, where is that?
Warrenville, South Carolina.
And you've been there 6 years?
Oh, no, 6 years at Wade Hampton High School,
So total years in the school system is what?
28 years,
And you're still there?
still there.
So you started home health care while you were still teaching school, or
No.
still going to school?
Going to school, working, food service.
And will you please tell them, you said your aunt got into business. Were you working with one family at a time, or did you have,
Different families at a time, different families.
and how long would you stay with the family once you became their caregiver?
It all depends on how long if they're deceased, I will move on to someone, another family.
So is it fair to say you'd stay with the family until the person passed on?
Passed on, yes, correct.
And then how'd you get other jobs as far in that caregiving profession?
My aunt always called me and said there's a job, and she let me put me on that job.
So to give the jury an idea before we get to this case, your schedule would be what when you were still working at school?
Yes,
and
at school,
caregiving?
yes.
Okay, so what was your typical day like?
My typical day, I leave home at 7:20, have to be to school at 8 o'clock that morning. And I will stay there till 1:45, make my deposit for the school, then leave and go to my next job.
Can you tell this jury, Ms. Smith, how it came about that you started working for the Murdaugh?
It was a job opening. I think one of the caregivers mentioned it to me, and I said, yes, I'd be interested in going. And now that's how it started.
And one of the caregivers mentioned your name. Do you know who that was?
Yes, yes, sir.
Okay.
It's Barbara Mixon.
Ms. Barbara Mixon?
Yes, sir.
So there's an opening and your name got brought up.
Yes.
And can you tell these folks when that was? When did you start working for the Murdaugh family?
It was October of 2019.
And what was your role as a caregiver specifically for the Murdaughs?
Miss Libby, taking care of Miss Libby, Miss Libby.
Was Mr. Randolph, I knew him as Solicitor Randolph Murdaugh, but was Mr. Randolph, was he there living
Yes.
when you started there?
Yes, he has, yes.
And then that's what we've referred to as Almeida?
Yes, Almeidas, yes.
What was your primary job as the caregiver? Were you there to take care of Solicitor or Mr. Randolph, or was your primary job for Miss Libby?
Miss Libby,
Did you also ever tend to Mr. Randolph's?
every now and then. Mhm.
But your main focus was Miss
Miss
Libby?
Libby, yes.
From October 19th up to June 21st, Ms. Smith, and I want to be very delicate in this question. I think it's something that affects everybody in the world, this jury there, but did Miss Libby's condition get worse?
Yes,
And she's suffering from something that affects all our families, it's Alzheimer's.
yes,
And that got worse from the time you started until June.
yes. Mhm.
Well, in June of 2021, how would you describe Miss Libby's condition?
Alzheimer's, couldn't remember anything at times.
In your opinion, as her caregiver, was she aware of what was going on around her?
No, no.
All right, specifically, in June of 2021, Ms. Smith, or May, June of 21, tell these folks what your school schedule was and then your work schedule with the Murdaughs.
Okay. My school schedule was 7:20. I will leave home, be to school at 8 o'clock, and I leave there at 1:45. Go home, make my deposit at the bank, go home, rest, come back to work at 7:45. Had to be there at 8 p.m. that night. I would stay all night and leave 7:45 the next morning, leave there and go back to the school.
So was that the shift you were working for the Murdaughs
Yes,
primarily?
yes,
An 8 p.m. to 8 a.m.
yes.
shift?
Mhm.
When did you sleep after you went to school?
Took little cat naps every now and then.
But would you go home after you made your deposit?
Yes,
You would rest?
yeah, that's for a couple of hours. Mhm.
And then did you have a change of clothes at the Murdaughs for when you went straight to school the next morning?
Yes. Mhm.
Well, ma'am, I'd like to take you to June 7th of 2021. If you'll go back there, if we can take them back in your mind and take this jury back there right now, please, ma'am. Were you working as a caregiver for Miss Libby Murdaugh on June 7th of 2021?
Yes,
Now, had Mr. Randolph, again, I know Ms. Solicitor, but had Mr. Randolph's condition worsened? Had he gotten, was he in the hospital? Was he there when you got there on June 7th?
no, he was not.
Do you know where he was?
He was in the hospital.
What time did you get to the Murdaugh, Miss Libby's residence and Mr. Randolph's residence on June 7th of 2021?
7:45.
And that's the time you were there?
Yes,
And you're never late, are you?
no,
And is somebody waiting to leave for you to get there?
yes.
And this night, who was there?
Was Miss Barbara Mixon, I'm thinking? Can't remember. I think it was Barbara.
I'm having trouble
I'm sorry.
understanding the words. Can you speak maybe louder?
Okay.
I know you can't change your voice, but
Yes, sir.
a little louder, please. Or closer to the mic.
Can you tell us what Miss Libby, when you got there on June 7th of 2021, shortly before 8, where was Miss Libby?
In the bed.
And as a professional caregiver, and this was what time of night?
8 o'clock that night.
If one of your patients that you're taking care of is in the bed resting, do you like to disturb them?
No,
If they're sleeping, do you want to wake them up?
no.
So when you got there, was Miss Libby in bed?
She was in bed, yes.
And do you get briefed by Miss Mixon on what happened during the day, or y'all exchange, hey,
Just come in with, change or if she need to be changed or whatever like that.
make sure that
She's
Dry.
She's dry. It's okay, yes.
and so where's your desk? What's your position when you're there, when you're in her room, Miss Libby's room?
Yes.
Okay. Where do you sit when you're in the room? I mean, what do you do to take care of her?
In a recliner. Have a recliner. Sit there.
And is there a TV in the room?
Yes. Mhm.
And is the TV usually on when you're there with Miss Libby in the evening, or
Yes.
was it on this night?
It was on, yes.
And do you remember what y'all were watching? Or what was on TV?
American Says, a game show.
Say it again?
American Says, the game show.
Okay. How long has that been on?
It's stays on. It repeats. It's afterwards repeats itself.
What channel is that on?
the Game Network show channel, excuse me.
At some point on the evening of June 7th of 2021, did you see Alex Murdaugh?
Yes,
Do you remember what time it was? Approximately.
the game show was on, so it had to have been 8 o'clock, 8:30, 9:30, somewhere up in there.
8:39, 9:30?
It was somewhere up in there.
Is it fair to say it was later in the evening?
It was late in the evening, yes.
And you had worked that schedule for that 8 p.m. to 8 a.m. shift for how long?
2 years.
2 years.
2 years.
Was it unusual to see Alex Murdaugh at that residence that time of night?
Yes, on my shift, yes,
And that's the only shift you'd work.
yes,
So the 8 p.m. to the 8 a.m. shift, it was unusual to see Alex Murdaugh there visiting, correct?
correct, yes.
Had you ever been over there before that time of night?
I think different off and on, it all depends.
When he got there, can you tell the jury what happened?
He called the house and told me he was outside.
He called the house.
Yes,
What phone did he call? It's a terrible question. I mean, was it your phone, the house phone?
the
I'm
house
not-
phone, the house phone.
And when you answered the house phone, what did he say?
He was outside. They let him in.
He was at the house,
Yes,
right outside the house,
yes,
and he called you,
yes,
and he said, "Let me in."
yes.
And after he called you, how long did it take you to go open the door to let him in?
About 5 minutes.
So he was right there
Mhm.
at the house.
Yes,
You let him in?
of course, yes.
Do you remember what he was wearing?
Shorts
Okay.
and a t-shirt,
Do you remember what kind of shoes he had on?
those cloth shoes, like Sperry's, that type of material, like Sperry's, that type of material, cloth shoes.
Cloth shoes?
Yeah, like cloth, I mean, yes.
And you said something called Spears?
Something like Sperry's, that, that kind of, but it was cloth. That kind, yeah.
Wasn't boots?
No, it wasn't boots, no.
Are you familiar with tennis shoes?
Yes,
Was it tennis shoes?
no, it wasn't tennis shoes.
Cloth, Sperry type shoes?
Yes,
Did he have any socks on?
no, no.
Tell the ladies and gentlemen of the jury, could you describe Alex Murdaugh's demeanor on June 7th when you were there with him and his mother Libby?
He
How
just
was he
came
acting?
like fidgety, this came in,
Speak up, please. ma'am.
fidgety, I'm thinking, it's normal. Like he was fidgety, like, yeah,
Fidgety.
yes,
Is that what you're saying? And did he tell you why he was there?
no, he just came to see his mother.
Did he talk to his mother?
But she was asleep, yes.
She was asleep.
Mhm.
Okay. And what did he do? What did Alex Murdaugh do when his mother was asleep?
He came and sat on the bed, because we was asking what I was watching, I said American Says, I said the game show.
Did he say anything to his mama?
We said, hey, mom, how you doing? Just came and check up on you, yeah.
Did he say why he'd come to check up on her?
Because daddy was in the hospital, call him Hansel, was in the hospital.
And in your opinion, as being there, her caregiver, did she even know that he was there?
No,
The objection's overruled.
You said no?
no, mother, no.
How long did he stay in the room with y'all? When I say y'all, for the record, you and Miss Libby, I apologize.
About 15 to 20 minutes, 20 minutes.
Was he moving around the room?
He was laying on the bed,
Did he have his phone with him?
yes,
Was he looking at his phone?
yes, he was on his phone, yes,
I'm sorry, ma'am. What?
yes. Mhm.
after that initial conversation, you said, he said, I'm here.
Mhm.
Did he have any other attempt to have any other conversation with Miss Libby?
No,
Did he hold your hand out? Did he ever hold her hand?
yes, he did hold her.
He hold her?
Yeah, mhm.
Did
She
you
was-
talk to her?
Yeah, she was in the bed, yeah. Yes,
And her condition then was what?
she was, sleep off and on, sleep.
How long did he stay there? I forgot.
20 minutes, about 20 minutes. About 20 minutes.
What happened after that?
He left. Mhm.
Your shift ended when?
8 o'clock the next morning.
At some point after that, did you get a call from Miss Mixon?
Yes,
Did you learn what had happened at Moselle?
yes. Mhm.
At some point after that, did you get a call from a family member? I really don't know who it was, but
Yes, yes,
do you remember who it was?
yes.
Okay, who was it?
This is Randy,
Randy Murdaugh,
Randy Murdaugh, yes,
Alex Murdaugh's brother.
yes.
And as a result of that, what was, were you expecting people to come over after that?
No,
After that phone call, were you expecting people to come spend the night that night?
yes.
Okay. Who was gonna come over?
Randy told me, John Marvin, Buster and his girlfriend, and Alex.
John Marvin,
Mhm.
Buster and his girlfriend, and Alex.
Yes,
And did you, and in fact, see them later on that night? Or that morning, the next morning, I'm sorry. Did they come to Alameda after you got a call from Mr. Randy saying they were coming? Did they come?
yeah, they came, yes.
And at some point later on that morning, did you see Alex Murdaugh again? Did you see him again that morning?
No,
Did he ever come looking for glasses?
that morning, that night, he was in there. He came with glasses. He said he couldn't sleep.
And Mr. Randolph, or Solicitor Randolph, died shortly, a couple of days after that.
Yes,
Now, you were working the 8 p.m. to 8 a.m. shift. Were you asked to work more after this to get the family through this? Were you
Yes.
asked to help more at the house?
yes,
And were you happy to do that?
of course.
And do you remember the day of Mr. Solicitor, I'm gonna call him Solicitor, that's the way I know him, Solicitor Randolph's funeral?
Yes,
And I've been reading through all this stuff. It was a repast.
a repasses, but everybody come back after the funeral and eat.
Everybody comes back and eats.
Yes,
Well, after the funeral, did people come to Alameda, sort of like a visitation after a funeral?
yes,
Did folks come over there then?
yes,
And was the family there then?
yes.
And during this repast visitation, where were you? And I said, what was your job during that, or what were you doing during the visitation?
I was in the room with Miss Libby, just back and forth.
And sometime that afternoon, did you see Alex Murdaugh?
Yes,
Tell the jury about that, please.
he came in the room,
You'd speak up, please, ma'am.
he came in the room and speak that, spoke like he always do.
And what did he tell you?
That he was at the house. He was at the house.
Say it again.
He was at the house.
And I'm not 100% following you. He was telling you or saying to you that he was at the house?
Mhm.
When?
The night of the murders.
The night of the murder.
Yes.
What was he telling you about that he was at the house the night of the murder?
That he'd been there 30 to 40 minutes.
Was he telling you that? Did he ask you anything about that when he was talking to you?
Yes.
Did he indicate to you what he wanted you to do with that information?
No, no.
What did he say?
He just said that he was at the house for 30 or 40 minutes. That's it.
You said what? Was he there 30 or 40 minutes that night?
Not to my recall.
Why are you crying, Miss Smith?
Because they're a good family, and I love working together. And I'm sorry all this happened. They're good people, you know.
He wasn't there no 30 or 40 minutes, was he?
No.
Can't leave the witness.
Did that conversation upset you?
Somewhat.
You upset right now?
Yes,
Did you call anybody about it?
my brother.
You called your brother after that conversation with Alex
Yes,
to tell him about that conversation.
yes.
And just to be clear, what was the statement he said about how long he was here?
30 to 40 minutes.
But his phrase was, I was here, or you know I was.
I was here 30 to 40 minutes.
Not to pry, but I can't help it sometimes. What else was going on in your life right there?
Just working hours and hours.
You're whispering. I can't understand what you're saying.
When you gonna get married?
I was planning on getting married. I was planning on to.
And had Alex Murdaugh mentioned anything to you about your upcoming nuptials?
Yes,
And when was that?
day afterwards, I'm thinking.
The day after this?
I'm thinking it was,
After
yes.
the conversation you
Yes.
just said? Where were you?
At Miss Baby, at the house.
And what did he say about your marriage, your upcoming potential marriage?
I heard you was getting married. I said, yes. He said, if I could, just let me know, because I know wedding's gonna be expensive. I said, well, thank you.
The wedding's gonna be expensive?
He said, wedding's gonna be expensive. That's well, thank you.
Did he offer to help?
Yes, he offered. That's the type of person, a good person.
And did he ever mention the wedding to you before?
No,
Did you mention that to him before?
no,
Hey, did he have a conversation, anything else about your job? Were you working at the school?
yes, at the school, yes,
Did Mr. Murdaugh mention to you about your school and your position there?
yes.
Tell him what he said, please.
He said that, if you need a position at school, my good friend is there. I said, yeah, I know, worked at the school, the principal.
I believe you testified, did you help out more than just your regular shift the rest of this week?
Yes,
That week after
yes,
the murders and Solicitor Murdaugh's death? Were you working full-time then, trying to help?
yes,
Was school out then?
no,
So you still going to school and helping?
yes.
And after Mr. Randolph's funeral, did you have an occasion to see Alex Murdaugh early one morning?
Yes.
Do you know how long it was, how many days after the funeral, Mr. Murdaugh?
3 days, I think, 3 days.
Can you tell the ladies and gentlemen of this jury what time it was in the morning that you saw Alex Murdaugh?
6:30 that morning,
Say that again.
6:30 that morning.
And that had been a part of your regular shift, right? 8 to 8 a.m.
Yes,
And did he call you and tell you he was coming?
No.
You didn't? Had he called you on June 7th and told you he was coming?
Yes,
And he was right outside the house?
yes,
And this morning at 6:30, he did not call you?
no.
How did you know he was on the premises?
He knocked on the, by the bedroom, yeah, the window.
Not.
Yes, on the wall.
Well, did you hear him say anything after that?
He said, I'm outside.
Say it again?
I'm outside.
Had he ever been there at 6:30 in the morning before that? While you were working there?
No, sir.
Never.
No.
And tell the ladies and gentlemen of the jury what you observed that morning when you saw Alex Murdaugh.
He came in the white, left in the white truck, came in the white truck.
Was there still funeral stuff's not the world road? There's still funeral equipment in the yard?
Yes,
Like what?
the tent was still there and the big old building, they put the food in, had out there. Yeah,
Like a food truck?
yeah, food truck, yes, yeah.
And was that blocking your view some?
Yes, Lord, yes.
So when you saw Alex Murdaugh this morning at 6:30, what did he do after he knocked on the door? Did you let him in?
Yes,
Then what did he do?
came inside.
And was Miss Levy sleeping?
Yes, she was still asleep.
Okay. Did he go check on Miss Levy?
No, he didn't come in.
He didn't go check on her?
I can't remember.
Well, what did he do then?
He came inside.
Okay.
Mhm.
And did he have anything or was he holding anything?
He had a blue something in his hand.
Say that one more
A
time.
blue something in his hand, something blue.
A blue something in his hand.
Mhm.
And can you show me how he was holding it?
Like this.
Sorry if I touch it.
Yeah, that's fine.
How was he doing it?
Like this.
Holding something like this?
Yes.
And what did it look like?
Like a blue tart, like a tart.
Blue?
Blue.
Okay. Was it vinyl?
It's like a tart that you put on a car, you keep your car covered up.
Big thing.
Yeah, blue.
And was he holding it like this?
It's sort of like this.
Could you tell if there was anything in it or do you know?
No, I couldn't tell.
But not holding like this.
Mm-hmm.
Did he say anything when he walked in?
No,
What did he do when he walked in?
went upstairs.
They course notes. States 230. $223, $222, $413, $412. At this time, without objection, I'll save the other two. I didn't call it.
They're admitted without objection.
You testified Mr. Murdaugh came in your Alameda residence that morning. This is States 223. Do you recognize that?
Yes,
What is that?
upstairs, going upstairs.
And is that where he went, Alex Murdaugh, that morning,
Yes.
carrying some blue thing?
Mhm.
And this may be duplicate. If it is, I'm sorry. That's 222. Same stairs, same house.
Yes.
States 413. What is this?
That's the bedroom,
Okay. Where in Alameda is this bedroom? First floor, second floor?
first floor.
Is this where Miss Libby stayed?
No. Mm-mm.
And 412. that the same?
Yes, same bedroom, yes.
We'll show you what's marked 411. Don't call out the answer. This states 411 for identification at this point. Do you see the blue object in the center?
Yes,
Does that appear to look like the object you've described?
yes,
You saying yes?
yes,
Is it blue?
it's blue,
Is it vinyl?
yes,
That appears to be the same thing you saw the defendant holding this early morning hours when he came in the house. Is that correct?
it looks so, yes.
You know, this is states 411 we'd offer at this point. I don't know how to ask except to ask it. Did you ever see that blue thing unfolded when you were that morning, or you saw him carrying it?
It was unfolded
Okay, where'd you see it?
in the bedroom, that,
And where in the bedroom?
on the chair.
And again, I'm not clear. Was that in one of these pictures we showed you? What chair? Did they disappear? Oh, I'm sorry. I apologize. Was that on one of these chairs in this?
Yes,
Okay, and I'm referring again to 412. You saw it on the chair?
yes,
Did you come? You ended up leaving at some point that day, right?
yes.
When you came back the next day, was that there?
No, it wasn't.
It was gone.
Yes, it was gone.
And did you see Alex Murdaugh leave after he went upstairs? Do you know what he did upstairs?
No, no,
Did you actually see him leave the house after he went upstairs?
yes.
And where did he go?
Oh, I don't know. He just left outside and left.
Okay. Did he say, "Hey, I'm leaving"?
Yes, I'm going, yes.
And at that point, what did you think? Did you think he'd gone?
I thought he left, yes,
Okay. Did you see him after that?
yes.
Tell them where, please.
He
That
came back,
morning.
he came back to the house.
And how do you know that?
Because the blind was open, I seen him came through the driveway.
And what did you see him? Was he walking? Was he driving when you saw him in the driveway?
He was driving the truck,
And I'm sorry, Ms. Smith, what truck was he driving?
the white truck.
Whose white truck was it?
I'm thinking it was Mr. Reynolds. I thought it was his truck. He had the white truck also.
He had a white truck also.
Mhm.
So when you saw, you testified, Mr. Murdaugh coming back in a white truck, that was Mr. Randolph's truck?
Mhm.
Whose truck was it?
I don't know.
Ma'am, you must use words as opposed to, or because we need to know exactly what you're saying. Say yes or no if you can.
Whose truck did you think it was?
I thought it was Mr. Randolph's truck.
And were there four-wheelers or ATVs out on that property?
Yes,
Okay. What, if anything, had you observed about a four-wheeler that morning?
it was at the house,
Where had it been previously?
at the smokehouse,
When did it get moved?
the same day of that, the same morning.
Same morning when Mr. Murdaugh was there.
Yes,
And in what direction did you see Mr. Murdaugh leave? When you saw him leave the house and you thought he was gone?
Mhm.
You know where he went?
No,
And when he came back in this white truck, what did he do?
he got another truck,
How long was he gone?
for about 10 minutes or 15 minutes, thinking.
And then you say this other truck. What truck are you talking about?
It was a black truck.
Had you not seen that before?
No,
Why not?
because the food truck, the catering thing was still out there anyway, so I couldn't see.
So that blocked your view.
It's blocked my view, yes.
So what vehicle did Mr. Murdaugh leave after he came back in the white truck? What color truck?
It was a black truck. Black.
You know whose that was?
No,
That morning, this morning when you first saw him at 6:30, did you observe anything about his face? Any on his face?
They like a little color, a little bruise cut or something,
And ma'am, I apologize, a little what cut?
like a little bruise or something.
Where was it?
It's like above his forehead,
Okay. I won't ask you to touch me, but can you touch yourself to show where?
right here, something right there.
Did it look fresh?
This look like a cut, no, I wouldn't say fresh, but it look.
Was there a video system in the house for either Sister Murdaugh or Miss Libby Murdaugh?
Yes,
Can you tell them about that? Where was that? What was that?
it was in the Miss Libby's bedroom.
And how was that activated or operated? It's better. Do you know?
No,
Was it on all the time or not?
yes,
And what color would it be if it was on? Was there a marker that, or a red and black or red and green?
those circles, yes,
And would there be times when that wasn't on?
yes,
And do you know who controlled it?
no.
Get the helmet. I'm going to show you what's marked 410. Do you recognize this?
Yes,
Okay. And does it relate to what we're talking about this morning as far as your location?
yes,
Your Honor, 410, I believe without objection.
Says it relates.
Her testimony, where she was at.
No objection.
It's admitted. Without objection, it's submitted.
Can you see this on your, you got a little thing up there? Do you mind coming down here? Judge, can she come down here?
Yes.
Very briefly, it won't be long. If you would stand up there, so just we don't block the jurors, please, so Mr. Griffin can see. Is this a picture of what we refer to as Alameda?
yes,
And can you show where the, I guess I called the main house? And I'm sorry, we don't have a pointer. That's the main house. And you have to say yes for the record, please, ma'am.
yes,
And down here, I know it's hard to see. Can you tell what that is? Sorry. Can you point to the main house again? I think we blocked some jurors. That's all I'm doing.
right here,
Is that where you took care of Miss Libby?
yes,
Now, down here, there's even a little O on it. Do you know what this is down here? Let me ask you this, what other buildings are on the property?
the smokehouse and a barn, another little shed
And where were the ATVs usually?
at the smokehouse.
Where's the smokehouse?
That's it right there.
There you go, that's the smokehouse.
Mhm.
And that's where the ATV
Shed.
was.
Yes,
And where did the ATV end up when you saw it after you thought Mr. Murdaugh left? Had it moved?
at the main house,
Say that again, please,
at the
ma'am.
main house.
Okay. And when you saw him coming back, you thought he left. Where did you see him in the white truck? Do you remember?
He left him across the railroad track, you know. He left him across the railroad track and went out.
Which way to railroad tracks?
This way, I mean, that's the house. So had it been around, because I had to drive through.
You're not going to say anything, but speaking up.
I'm trying to.
That's good. Go back and sit down. That's
until I
fine.
couldn't
Thank you.
see.
Now, have you talked with either Mr. Griffin or Mr. Harpootlian or one of their investigators?
Yes.
Where was that? Best you remember. I'm not looking for a date and time, but you know how long we got?
It was last year.
And I met with you a couple of weeks ago
Yes,
and just a little while ago this morning.
yes.
And I have to ask you for the record, this Alex Murdaugh who came and saw you the night of the murders with the shorts and the shirt and the Sperry type loafers on, is that him over there?
Yes, sir.
And is he also the person that you said told you he'd been there 30 to 40 minutes?
Yes,
And is he also the person you saw in the house that night with some kind of blue vinyl that you said consistent with this picture we put in? Is that him?
yes.
Thank you, that's all.
Good afternoon, Ms. Smith.
Good afternoon.
We have met once or twice. Did anyone ever show you a blue rain jacket?
No, no, that. Yes, I think so. Yes.
Now, some of our investigators showed you a picture of a blue rain jacket.
Yeah,
correct?
picture of it, yes.
But has anyone at SLED or the Attorney General's office ever shown you a blue rain jacket?
No,
Now, you saw Mr. Alex Murdaugh bring a tarp in, you said, right?
yes,
And I'm going to show you a tarp, which we marked for identification purpose. This is, Your Honor, Exhibit 86. Is this the type of tarp that Mr. Murdaugh came in to the Alameda house on the day that we're talking about?
yes,
Tarp like this that would maybe cover up a car. Is that right?
yes,
Any way to confuse this with a rain jacket?
no,
He was not carrying a rain jacket, was he?
no, it was balled up, I don't know it.
And you said it was balled up, and it was balled in such a manner it did not look like there was a shovel handle, a gun, or anything. It's just balled up. Is that right?
Correct,
Have I balled it up sort of correctly?
yes,
All right.
No, we have no objection to that going in.
Your Honor, move Exhibit 86, I think, into evidence.
Without objection.
Now, when Alec left that day, this was laid out on Ms. Libby's retirement rocking chair, wasn't it?
yes,
And you had, and when you left for end of your shift that day, that's where it was, right?
yes,
And you've never seen it since, correct?
correct,
Now, they showed you a picture, which is in evidence. Do you even know where that picture was taken in the house?
no. In the
Do
closet,
we have that picture? What's the last photograph that went down? Can you see that, Ms. Smith?
Yes,
Do you know where that is, and or even if it is in Ms. Libby's house?
I couldn't say because I don't be in the closets. I don't know.
So you don't even recognize the closet, is that right?
Correct.
And have you ever even been upstairs in Ms. Libby's house?
Twice,
2 times over how many years?
3 years.
2 times in 3 years. And do you know where Alex Murdaugh went when he went upstairs on the day that he brought a blue tarp in the house?
No,
Now, you mentioned that this day that he came over was about 3 days after Mr. Randolph Murdaugh's funeral. Is that right?
yes,
Okay. And it was early in the morning?
yes,
So, and do you remember that Mr. Randolph's funeral being on a Sunday?
yes,
So then it would be Monday, Tuesday, Wednesday of that week. Is that right?
yes,
Okay.
that's correct.
And is that the morning that you said that you thought you saw a bruise on his forehead?
Yes,
So it was Wednesday after Mr. Randolph's funeral.
I'm thinking I can't remember. It's so long, I can't remember.
Yes, ma'am. And and you mentioned that that he came in a truck. I think you said he drove up in a white truck.
Mm-hmm,
Is that correct?
yes.
And he does have a white truck, as
Yes.
far as you know, right?
Yeah, yes,
And then you said he left in a white truck. And are you sure that it was Mr. Randolph's truck or Mr. Alex's truck that he left in?
because it was moved. Mr. Randolph had always keep his truck in a certain position, certain part.
So you think he left in Mr. Randolph's truck and moved?
Yes,
And when you came back, when you left that morning, I guess Wednesday we're talking about, was Mr. Randolph's truck back in the driveway,
yes,
parked in its normal place?
yes,
Anything out of sort?
no,
Was it all covered up with mud, like someone's been mudding in it?
no,
Anything unusual about the truck?
no,
Now, you mentioned there was a four-wheeler that had been moved at some point in time. That four-wheeler had a flat tire, didn't it?
yes, it did.
And was it a front tire, back tire?
I think it was a back tire.
And it was moved up close to the house,
Yes,
far as you know, so the tire could be repaired
yes, it was moved from the smokehouse to the wreck house. Yes,
with a flat tire.
yes, with a flat tire.
Now, you were asked questions about the day of Mr. Randolph's funeral. And you had a conversation with Alec, and he's talking to you about how long he was over at the house on the night of June the 7th, right?
Yes,
And he said he was there 30 to 40 minutes.
yes,
And you said, no, I don't think it was that long.
yes,
And then the next day, I think you said, or day after, well, the following day, or I guess other than Monday, you had another conversation with him where you just brought up back that you were going to get married. I think you said that was a different day, right?
yes,
And he was just being nice, wasn't he?
yes.
I think you used the word good
A
person.
good person, yes.
Who were you referring to when you testified in response to the question by Mr. Meadows that someone's a good person?
Mr. Alex Murdaugh.
Now, he came over on the night of June the 7th. And you said it was somewhere between 8:30 and 9:30 in the evening.
Yes,
And that's just your best estimate of when he got there, is that right?
yes,
And I think you testified that he was there, in your estimation, 15 to 20 minutes?
yes,
Now, when you said 15 to 20 minutes, you're talking about 15 to 20 minutes in the room with Ms. Libby or on the property the whole time?
I'm probably the whole time. Thank you.
Okay, well, now you said it took you about 5 minutes to let him in, is that right?
Yes,
So are you including the 5 minutes it took you to let him in your 15 to 20, or could he have been on the property 25 minutes?
20 minutes. The only thing is
No.
the whole time. So
And you would agree that Alex Murdaugh would visit his parents frequently, right?
yes,
And he would always come over more so than any other sibling. Is that right?
yes,
And you would agree that it was not out of the ordinary for Alex to come at night, correct?
yes.
You would agree with that, right?
No,
So you don't agree that is, so was it out of the ordinary for him to come at night?
yes, on my shift. Yes,
Well, do you recall being interviewed, a telephone interview on June 17th, 2021 with Agent Joe Albiado? You remember that?
yes,
And do you remember telling him that it was not out of the ordinary for Alec to come at night?
yes. It's been long, and I couldn't remember. It's been a year now, so I can't really remember.
I mean, is it possible that you told him that?
Yes,
And here today, you said, as I have in my notes, that when he came over, that he was acting kind of fidgety, yet normal. I believe that's what you said.
Mhm.
Is his normal behavior kind of fidgety?
yes,
He's just kind of a fidgety person, right?
yes.
So it wasn't the first time you'd seen him being kind of fidgety, right?
But he always come different times, so I can't,
But his demeanor was normal for Alec the night that he came over on June the 7th, wasn't it?
I'll say yes.
Okay. Now, you mentioned the clothes that he was wearing. And he came in and he sat on his mom's bed,
Yes.
lay down next to her,
Late. Mhm.
and held her hand. Is
He
that
walked
right?
in and walked in and hold her hand and spoke to her, then went on the bed and lay down.
And lay down.
Mhm. Not lay down, but sit up.
And when he got up off the bed, was the bed soiled in any way? Was it wet?
I can't recall that I didn't touch it.
No. What did Alec Murdaugh have blood on his clothes?
No. I didn't
He had
see-
blood on his shoes.
No,
He had blood on his hair.
no,
Did he leave blood in his mom's bedroom?
no.
Now, according to the records that we've been providing in this case, you were interviewed by SLED on June 16th. Do you remember that
Yes.
interview?
Yes,
And I think in that interview, you told SLED that he had been there 30 to 35 minutes. Do you remember telling him that?
I think it's, yes.
And then you were interviewed again by telephone on June 17th. Do you remember that follow-up call? Do you remember having a short phone call on the 17th?
A phone call.
Okay.
Mm-mm.
Well, whether it's one interview or two interviews, you never told anybody at SLED in June in these interviews, one or two, anything about Alec coming in with a blue tarp. Is that right?
Right.
You didn't say anything about a blue tarp until sometime in September. Is that right?
Yes.
And you initially mentioned something about Alec coming over with a tarp. The first time you mentioned it was to Officer Joseph Dingle of the Allendale Police Department when he was working a wreck. Do you remember that?
Mm-hmm.
Is that yes?
Yes.
Okay. And you had been in an automobile accident, and Officer Dingle was working the wreck and I guess filling out an incident report, and you were having a conversation with him.
Yes.
And in that conversation with Officer Dingle, didn't you tell Officer Dingle that on the night of the murders that Alec came over with a blue tarp that looked like it had a gun in it?
No, I saw him like he was holding something.
So you didn't say,
I didn't say specific was a gun. I said he was holding something.
so you didn't tell Officer Dingle that he came over and you couldn't tell, but stated it looked like a rifle.
No, I said it was like he was holding something. I did not say it was a rifle.
Okay. And if Officer Dingle wrote a report up saying that, he was just incorrect.
Yes.
Okay. And then after you had this conversation with Officer Dingle, then you were contacted by SLED agents, right?
Mm-hmm.
And they asked you to go down to their offices, and that's where you were interviewed in September, right?
Yes.
And in that interview, you told them about a blue tarp that you put over your car just like this, right? Is that correct?
Yes.
Okay. And you didn't tell them because it's not true that there was anything wrapped up in here to look like a rifle.
Right.
And since that day of the interview at the Lowcountry SLED office, have you had any additional interviews with SLED agents other than getting ready for trial last week?
Yes.
How many additional interviews?
Two or three.
And in each of those interviews, did you reiterate to SLED that it was a blue tarp and not a rain jacket that you saw Alex Murdaugh walking into the house with?
Yes.
Is there any doubt in your mind it was a blue tarp like this and not a rain jacket?
It was balled up as a blue tarp.
Because you saw it laying on Ms. Libby's retirement rocking chair, right?
Yes. Yes.
A second, Your Honor. Just one more point. When Alex Murdaugh came over on that early morning, I guess it was Wednesday, you testified. Were you in Ms. Libby's room?
Yes.
And you can't see the comings and goings out of the driveway from Ms. Libby's bedroom, can you?
Mm-hmm.
You can?
No.
Okay. Thank you, Your Honor. That's all the questions I have.
Redirect.
testifying in front of the grand jury on January 20th of 2022, on page 25, line 17, when you were asked about how long do you think he stayed in total, do you remember that?
Yes,
Do you remember your answer being 20, 10, 15, 20 minutes?
yes.
Mr. Griffin asked you about the 30 to 40 minutes. Why'd you call your brother after that?
Because he's a chief, assistant chief police at Warrenville. So I called him.
Had that statement by Alex Murdaugh affected you?
Yes,
How?
I was nervous.
And Mr. Griffin asked you about the evenings visits and the morning visits. Had he ever been there at 6:30 in the morning like he was that morning? Ever?
No,
And his 9:30 visit the night of the murders, that was very unusual for him to be at night, wasn't it?
Objection, leaving.
Don't leave the witness.
I'm sorry.
yes,
Was that unusual?
yes.
Now, so you told an officer, did you tell an officer about this? You saw something that he thought he was carrying
Yes,
before you told anybody else?
yes.
And what was that about, a traffic accident?
I had someone hit my car. He was on duty,
And when was that?
September 11th.
That's my birthday.
Okay.
You had an accident and you told the officer that you had seen him, Alex Murdaugh, come in holding something?
We was talking, was having a conversation, and that came up.
And you just told him that.
We was talking.
Had anybody asked you that before?
Mhm.
You have to say yes or no.
Yes,
Had
No,
anybody asked
no,
you that before?
no.
Okay. So why did you tell the officer that on September 11th?
We was having a conversation and just talking in general. And he asked me a question, and I said, yes, I've been there. And I said, I work with the Murdaughs. His mother.
In response to him, you told him you saw Alex Murdaugh with what?
A lining, a blue tart,
And you saying tart or tart?
like a cover car with a tart,
And you said you saw him with that, and did it appear he was carrying something?
like he was holding something. It was bundled up. It was bundled up.
Bundled up?
Yes,
Like this?
yes.
So you never saw this unfolded?
No, I never saw it
Never?
till the next morning. That was on the chair in Miss Vickers' room.
And you don't know where this tart came from, do you?
No, I don't know where it come from.
And it didn't have silver on one side, did it?
No,
It was all blue.
all blue.
And you said that the defense took a statement from you?
Yes,
Did they record it?
yes.
John, under Rule 613, I'd like a copy of that statement or the recording at this time, if they have it. She's now taking the stand.
Your Honor, under Rule 5, it is not subject to being produced. And we didn't question her about the statement, so.
Rule 5 is pretrial.
Under 613, I think once the witness has taken the stand and she said that they took a statement from her, either recorded or written, we don't have it, hadn't been provided. He asked her about that specifically, dealing with the blue tarp, and when they discussed it with him, I'd like a copy of it.
I actually don't mind him having it, Your Honor. We don't have a copy with us.
Rule says upon request, the same shall be shown or disclosed to opposing counsel pursuant to Rule 611A. So the defense must provide it to counsel.
Your Honor, we do have a copy here. I don't know if we can download it to, you got it?
Is it okay to produce it on flash drive?
Judge, I mean, I can't look at the flash drive, but yeah, I guess. Is it a hard copy?
Not a written statement, it's an audio recording.
Opportunity to listen to that without the presence here. I'm assuming it'd be a hard copy, but I don't want to mess the court schedule up either.
Now, ladies and gentlemen, we'll have you go to the jury room. Please not discuss the case.
Well, it appears right now there is a dispute on certain factual evidence that was, and they, yet again, it appears the defense opened themselves up to a situation where they're now required to produce evidence that they would not have ordinarily been required to produce. They did have that on them, so I guess they were deciding whether they were going to do it themselves. They're coming back on. I think they're about to argue this matter.
We'll be at ease momentarily.
Okay, well, it appears that they are actually, let me just put this up so we can watch it together. And when they come back, they can, come back and we'll pause what we're talking about. But a lot of stuff is going on here. It seems like the defense is making some crucial mistakes that is allowing evidence into the case that wouldn't otherwise be admissible. And we're watching, in my opinion, now the defense, for people that were asking in the chat, the way trials go is the prosecution has to state their case, and throughout that case that they are presenting to the jury, the defense is allowed to cross-examine and puncture holes into the case for the jury. After the conclusion of the state, the defense gets to rally theirs. They get to bring all their witnesses in. And of course, the prosecution can cross-examine their witnesses as well. So right now, all these witnesses that are on the stand are for the state. Every witness, whether they're being interviewed or interrogated or, whatever people would like to say on the stand, questioned on the stand, those are all state witnesses. So that's why the defense is kind of being insulting and demeaning. They're trying to, not show them in the best light for the jury. They're trying, in my opinion, it's just making us really not like the defense. Quite frankly, I don't know how that's affecting the jury, listening to them speak so badly to highly qualified and highly decorated people. It's coming back on now. Let's hear what was said.
Please be seated.
Well, let's see, if you need a half an hour to listen to this tape, we can take.
We have a rough draft of a transcript that we're emailing to them but it's 57 pages long, but we're sending it to them.
A rough draft.
But I'd like to look at the video at this point.
All right, we're going to bring the jury in and break for lunch.
So it looks like they're going to break for lunch, which is typically about an hour and a half. And they're just bringing the jury back in to excuse them. This should give the state enough time to review that interview that they had with the witness on the stand so they can continue questioning her. Again, this is evidence that was introduced by the defense because of them bringing in her statement when they were questioning her. When they were talking about the blue tarp, they brought up the fact that, when we questioned you or whatever, well, that was never turned over to the prosecution. So they're now requesting that be turned over to them. It appears that they have the audio as well as a rough transcript that they are emailing over to the prosecution now. So in light of this and the fact that the prosecution, the state, needs at least a half an hour to review the interview, they're going to go ahead and break for lunch, but they're bringing the jury back in to do so. We'll have some short commentary. We're going to take a short break ourselves. So everybody, it is around lunchtime. If you want to grab your food, your snacks, and come back here, we're just going to take a half an hour break at the top of this as soon as they conclude this before their lunch break. And then the next hour, we'll open up the phone lines. We can discuss this case or any other case that you'd like to discuss. So.
All right, thank you. Ladies and gentlemen, we'll break for lunch till 2:30, till 2:30. And this is Jordan. Juror number 729, I'll speak with you during lunch. So you can return to the jury room, please.
Okay, so 2:30, they're coming back. 2:30, they will be returning. So for right now, we're just going to take a small 30-minute break. I'm going to loop some songs through this while you guys wait. And then we will be back, and I'm going to open up the phone lines. We'll talk about this case. We'll talk about any other case that you'd like to discuss while we wait for the lunch break to conclude.
We're going to take a break for lunch. You just cannot discuss your testimony with anyone during lunch, but you can step down and have a good lunch. And we will be in 2:30.
Okay. I'm going to start, I don't know how long this is, like 8 minutes. We're going to 8 minute, but we're going to probably be gone for longer than that. So I'm just going to loop this for the time being. Actually, can I loop? Repeat video clips. Okay, so this will work.
I know you told your friend you're not okay, and tell me what's wrong and why you never said you felt that way. And guess you're trying to stay strong and fake a smile until I look away. But I've known you too long, it hurts to watch your blue eyes fade to gray as you fade away, as you fade away.
Yeah, I'm about to fade away, cause every time I wake up I feel like it's Monday. Something's going wrong with all the chemicals up in my brain. All of a sudden I don't look at anything the same way. Gotta build up of my thoughts sitting in an ashtray. I'm sorry that I'm so inconvenient, okay. Just let me be me and I'll stay out of your way. I can see the way you look at me, I'm such a disgrace. I never really asked to be brought into this place. You wanna love me? Well then baby I have a taste. All the highs and the lows, no you'll never be the same. I don't really wanna hurt you, but I can't control the pain. If you're sticking by my side, maybe we could be okay. Okay, maybe you could be the change I need today. I promise that I've never felt this way. I really hope that you will choose to stay through all the pain.
I know you told your friend you're not okay, and tell me what's wrong and why you never said you felt that way. And guess you're trying to stay strong and fake a smile until I look away. But I've known you too long, it hurts to watch your blue eyes fade to gray as you fade away. to watch your blue eyes fade to gray as you fade away. As you fade away. As you fade away. What's wrong and why you never said you felt that way? And guess you're trying to stay strong and fake a smile until I look away. But I've known you too long, it hurts to watch your blue eyes fade to gray.
You're rolling up, Uber black Cadillac, high heel boots and a sexy body full of tats. Baby's bad, oh baby's hella bad. After her there ain't no coming back. Wanna take a run at that. I think she's feeling me, turn it up a few degrees. My imagination of her body gets the best of me. Oh gosh, she's such a tease, bitten lips, bruised knees. I'm addicted to her, need her touching me, cause she got a bad little waist. And we tearing down this place, off the liquor that we chase. Got some egos to the face, baby, I don't need no space. Coming closer for a taste, and I'll show you how I make everything just fade away. Cause she's like sex, drugs, cocaine, body so insane. Jealous of the clothing that she wears up on a tight frame. All game, no shame, baby came here to play. I feel like an addict cause she's sex, drugs, cocaine. Got a fine little body and her mind's kinda naughty. They say that once you taste it, you cannot replace it. She could get you high, all the dopamine inside triggers fast once she's naked. Her body's a creation. They say the devil made her for his entertainment, but even he couldn't learn how to contain it. Her high heels make a damn good statement. There is no replacement, a body by statement. Cause she got a bad little waist, and we tearing down this place. Off the liquor that we chase, got some egos to the face. Baby, I don't need no space. Coming closer for a taste, and I'll show you how I make everything just fade away. Cause she's like sex, drugs, cocaine, body so insane. Jealous of the clothing that she wears up on a tight frame. All game, no shame, baby came here to play. I feel like an addict cause she's sex, drugs, cocaine.
Step 1, wake up early, gonna rise with the sun. Step 2, get some good, some food in you. Step 3, think real hard about what you wanna be. Step 4, everybody just do your thing.
Wake up, today's gonna be a good day. 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 Wake up, today's gonna gonna be a good day. Wake up, today's gonna be a good day. Wake up, today's gonna be a good day. Yo, set your affirmations, aspirations. I got shit to do, the aftermath of preparation. Good food, good mood, blood in circulation. One step at a time, yeah, that's how you make it. Set a goal you control and the steps you take them. I try to pick one thought, have some concentration. And if I make a mistake, it's called education. I try to do this every day, call it replication. Wake up, today's gonna be a good day. 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 So life ain't easy, yo, I think there's a reason though. Ups and downs, just like every different season, yo. Sometimes I'm high, other times I'm barely breathing, though. I always gotta fight and hide from the demons, yo. Negative thoughts are poison, they rot. Head full of flies, so here come the clouds. They'll never stop unless I can swap all the bad for the good in my head when I'm lost. Yeah, so I'ma fake it till I make it. Positive thoughts are overtaken, I got patience. One day at a time is how you operate a cadence. A flow, you grow, you show yourself a foundation. Stay away from all the shit that causes temptation. I know that I like to do it cause it's sensation. I live my life in my head like a narration. Don't expect greatness, do my best, man, I'll take it. Wake up, today's gonna be a good day. 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 Wake up, today's gonna be a good day.
Wake up, really gon' rise to the sun. Step 2, get some good, some food in you. Step 3, grow hard about what you wanna be. Step 4, everybody just do your thing.
I grew up in a place where they told you what to chase, told you how to run the race. Every move was on the page, but I didn't like their way. Had to fight and misbehave, had to find a way to change, had to leave to find my way. Caught up in a daydream, I beat my mind up there almost daily. It's how I pass time, no opinions safely. It's how I understand what I want in this place, see. Cause everybody wanna tell you bad things, what could go wrong, what fame brings. But success is a finicky thing, and if you ain't sure, no, it'll never be. I don't wanna let myself down, myself down. I don't wanna let myself down, myself down. Run away, I don't have to plan it. I can go, change my fate, you won't understand it. All alone, that's okay, people I can't stand them. They don't want me to change, keep me where I'm standing. And I don't wanna be where I am, and I want something more, take a chance. It could be possibly my last dance, my last dance. I don't wanna let myself down, myself down. I don't wanna let myself down, myself down. Even when you feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go. Go, 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 go. Hustle hard, hustle every single day. I'll be making moves till I'm buried in my grave. To the system, I don't wanna be a slave. I've been doing shit my way, or the highway. And in the driveway is a nice range. Cause I grind through the climb, I invite pain. You'll never hear me, bitch, nah, I don't complain. Just gotta flip the switch and you can go and obtain anything you want, anything you need. Your mind's got the key ingredient, it's belief. They'll deceive with the negativity, but I just slide right by that energy. Even when you feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go. Go, 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 go. You got a mind, but even that could change. You could flip the gray matter like some batter in your brain. That's why they say, fake it till you make it A. And if you play that game, then you just might make a change. Rearrange all the bad to okay. Take the worst thoughts saying, turn them to a game. Take the best thoughts saying, put them on display. On repeat in your brain till you're feeling no more pain. Never slow yourself down, you can do some more. Push past all the pain and you'll find a door. Open it up and finally explore everything that you thought you could never do before. And even when you feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go. Go, 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 go. Even when you feel low, you can still go. Even when you feel slow, you can still go. Even when there's no hope, you can still go. I never answer to no, man, I still go. Love the chase and the hunt, and I set the pace when I'm running. I always take what I want and I always give it 100. Don't need a bank, no, I'm funded. Play the game like it's nothing. I'm always thankful for something. Don't take for granted, stay humble. Now wake up! It's time to look at the enemy. Look in the mirror if he is no friend to me. It's not working out, maybe it's the chemistry. It's time to break up so I can make a better me. Better believe in your mind, cause it's everything. You can mold, shape, find almost anything. All it takes is some time and some clarity to find your identity. It's mind over everything. And when I feel like this, I'm immortal. 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 Don't stop, just stop it up, don't stop.
Hey guys. So, anyways, the first part of the day was not with the jury. It was not with the jury. The jury came in a little after 11:30 when we had the financial matters surrounding possibly the motive as to why Maggie and Paul are no longer with us was able to be entered into the court record today. The judge did hear it again. It was not, the jury was not there to hear the testimony of the witnesses. It was two different attorneys, one for Mallory Beach and another attorney that happened to be at Alex's home or a family member rather, excuse me, John Marvin's house on June 10th, apparently when law enforcement came there or something to that effect and overheard a conversation with Murdaugh and Mr. Griffin. Mr. Griffin is one of his defense attorneys, but because it wasn't a conversation in privacy, they're going to be allowing that testimony into the court. We heard at length testimony from a Michelle Shelley Smith, and she was the caregiver of Alex Murdaugh's mom. And Alex Murdaugh's mom was she wasn't in a vegetative state, but a lot of the times she didn't know where she was at or had any memory of anything, according to that witness. They also talked about, she said it was that Miss Libby was unaware what's going on around her. And she was at the house usually overnight from 8 p.m. to 8 a.m. And the night in question, the caregiver prior to her was a Barbara Mixon, which did end up calling her along with family members the night of this murder. And that she was told that family members would be coming to the Almeda property to stay. The people that came to stay was Alex, Buster and his girlfriend, and John Marvin, the gentleman's house that they were at on the 10th. Also, they were discussing Randolph's funeral. So who's Randolph? Randolph is Alex Murdaugh's father. He died a few days after Maggie and Paul. And they had a lot of stuff being assembled out the Alameda home. After the funeral, people were coming by. They had almost like a dinner type thing. She was very uncomfortable with a couple things. So the night in question, Alex Murdaugh is believed to have, well, how she basically stated it, I forgot to write it down, so I might be just a little off, just a hair on the details. But she basically said that Alec called her from outside of the home saying he was there for a visit. It wasn't something that she planned. Yes, he had been over there at night previously, but they were few and far between. I'm paraphrasing for the witness. And that night was a little odd because he didn't ring the doorbell or anything. He ended up calling her on the phone to have her open the door. She says it took her about 5 minutes. Unless this house is massive, I don't know. But either way, she said that she took her about 5 minutes to let him in, and that he was only there anywhere between 15 and 20 minutes. And they honed in on that time because she later made a statement that really unnerved her about Alex Murdaugh at a separate conversation. And the question was he there 15 or 20 minutes? And did that include the 5 minutes that it took you to get to the door? And she said total time on the property that evening was no more than 20 minutes. However, at a later time and date, Mr. Murdaugh asked her, basically told her that he was there 30 to 45 minutes. And it really concerned her so much so she called her brother, which is a Yarnell or Yarnell. I don't know if I'm even saying it correctly, Yarnvard or something like that, assistant police chief. So it unnerved her so much that she called him. I'm sure he advised her not to make any false statements on her boss's behalf. I'm hoping that's what he said. However, it unnerved her. And there was other things where he wasn't being threatening in nature or anything like that, where he said, I heard you're getting married and wanted to offer to pay for her wedding. And then spoke about the school where she worked, subtle hints that, in all appearances probably aren't vile threats, but after being asked or told how long somebody was there when you know that they weren't there that long, and then followed by those kind of statements, it could be a little alarming to some. So, I'm not sure quite how to take it, because I don't know if they were said, in a threatening manner. And just because they're said nicely doesn't mean they're not necessarily in a threatening manner. So it's I'm curious of the context. It might have been nothing, and he may have just truly been just trying to, bribe her in a way, instead of it being a vile, like a subtle threat. But, we don't know. We do know that Alec is a powerful person. He definitely was powerful enough to defraud his clients out of over $10 million. And that's only going back 10 years. They couldn't go any further than that. Now, he's been at this firm for a very long time. Now, if we go back to the beginning, how many millions of dollars is that? We will never know to the magnitude that he stole from his clients, and we will never know for how long. It is very sad to think of it, but it is true. And not only that, but think about Gloria Satterfield. He was able to squander $4.3 million from them, allegedly. He hasn't gone to court for those yet, or maybe he has. I don't know. But squander $4.3 million from Satterfield's trust to the family that, without them even knowing. How many other people did he run that scam on? Like, they didn't even know, hey, Hellcat, nice to see you. They didn't even know that they even won that settlement, let alone know that they weren't getting squat. They got a little bit, but that's it. So I'm very interested in this. But anyways, she seemed, I don't know if you guys were watching it, but she almost seemed scared. Like, that's how, like, she was so nervous. I think that poor woman was just terrified of what this is going to do to her reputation in that town moving forward. She was going over, you could tell she really didn't want to be there for the prosecution. And it's sad to say, but she is helping the prosecution, which again is sad to say, but she's trying to be truthful, and she's trying not to rock the boat, because, obviously the Murdaugh family was very good to her. I would be quite scared being a caregiver, since one other caregiver is not coming home to the family. So I don't know. She should be thankful she wasn't in the other house. I don't know what to say, but definitely a lot more. I can feel the intensity. I know that the last 3 days of prosecution's testimony and witnesses have been really putting the squeeze on the defense. They're really got a lot of hills to overcome. And not only that, because the pressure is on, I feel like they're making mistake after mistake after mistake. And, I think when you're making those types of mistakes and you're being insulting to all the prosecuting witnesses, I think it's going to leave a bad taste in the mouths of the jury. Not only that, but a lot of the stuff that we saw at the beginning stages of the fate, where the first responders and all that other stuff, when they were really talking about some gruesome evidence that they recovered from the scene and had to witness and things like that, Alec is just rocking in the chair and, got his glasses on and, dabbing his face every now and again. And everybody's like, oh, he's got to have Parkinson's. I'm like, no, this is trial strategy. Oh, no, he's got, well, Parkinson's don't go away like that. Like, what's been going on the last few days? Where's the rocking? Where's the crying? Where's the sobbing? Now he's in like attorney mode, helping his defense defend him, basically. So you're seeing a whole change in demeanor as things start getting a little more intense for the prosecution. He doesn't have time to play to just to continue with the trial strategy of rocking and sobbing. Now it's time to put the big boy pants on and start defending, because I'm telling you, this stuff is clubbing him over the head. They've got the financial stuff in. Now they've got the attorney for Mallory Beach. I mean, and another attorney, and even the judge is like, wait a minute, you can't claim a attorney-client privilege for somebody that's not your client. If you're going to counsel, then they have to be your client. But there's no perceived attorney-client privilege for one person, one of the witnesses that they were talking to. Even the judge, I mean, the prosecution didn't even have to argue that. The judge argued it for him. Like, wait a minute. There is no perceived attorney-client privilege for people that aren't your client. That wasn't set up even interviewing attorneys is still an attorney-client privilege, but this was just, there was no privilege there. And they're trying to assert one where there is none. So the judge caught on to that really quick and is like, no. So everything the prosecution, it sounds like, brought forward to ask if now that they be the witness or, be called to the witness stand, the judge is pretty much allowed. Unfortunately, it was the defense that punned the ball. I mean, they're the ones that got this stuff admissible when it wasn't. So I don't know. I think the defense is struggling at this moment. I think that the state has the upper hand. I think they are they laid the foundation early on. I remember the first 2 days. I remember everybody in here is like, but we don't see it. They haven't had any slam dunks yet. And it's like, at this stage, there's not going to be any slam dunks because they're just laying the foundation for the stuff that they're now bringing in because of the foundation that they were laying. And they're doing a very good job at, but you know what? We haven't gotten to the defense side. We haven't, the defense hasn't started calling their witnesses. They may have rebuttal witnesses that they're going to come toe to toe with their detectives and their evidence and their science. We haven't heard any of that yet. This is, right now we have the ball in the state's court. They're doing their thing. So, the only thing that the defense can do is cross-examine and try to poke holes in what the state's case is. They're not trying to win the case at this moment. They're just trying to poke as many holes into the state's motive, the state's means, everything that the state has against their client. They're just trying to poke subtle holes in it and do some damage at this stage in the game. At another point, they're going to be, they're going to be able to present their side of the case. Right now, we're only seeing one side, and that's the state's. Pretty soon, we're going to start seeing, after they're done with all their witnesses, the state has concluded, then we'll go over to the defense where they're going to refute the majority of this stuff. And that stuff has still got to get entered into evidence to combat. So, this is, the jury still has a long road ahead of it right now. It's free to tell. Oh, thank you. Let me see if I can, if there's a, Yeah, I finally caught your live today. Oh, thank you, Deborah. A very busy morning for me. Hi, mods, chat. Happy Monday, everyone. Hell, happy Monday to you too. Happy Monday to you too. Now, I don't know what tomorrow's going to hold because I'm going to be at, I think I have a BOCC meeting. Hold on. Let me just see if I do. Let me see. Let me see. What's today? Today's the 6th. Yes. Special work session. I always seem to hit all the special work sessions. What is this one on? Develop service, building division, review, and fee change. Okay, good. They actually have some stuff. Oh, good. They have the presentation added. About freaking time. Way to go, county. I remember the other day we had a special work session. And there was literally nothing but a piece of paper that said special work session. And then they have a link to make comments for the board to hear. So if you can't make it to the meeting, and I'm like, what are these people commenting on? There's nothing here. Like if you know you're going to be presenting a presentation, it should be attached to the agenda for the people that can't attend can write their comments in on what's being presented, whether they're for or against it. I mean, it's just whatever. I digress. So it looks like there is a work session. I will probably be there at least for part of the day. I don't know when it's going to wrap up, but I'll be there at least for part of the day. So I might go live here early in the morning and cut it off after an hour and just put Murdaugh up so you guys have something to watch. Or I may just kill it for tomorrow and we'll just have to reconvene on Wednesday. So I'll make that decision tonight and let you guys know. Just be on the lookout for a community post. Is the trial done for the day? No, Uncle Mike, it's not. They're on lunch break. They're going to be reconvening at 2:30. At 2:30. So we've got about another 16 minutes. I'm going to run to the little girls' room before we start. I got to start a pot of coffee. So, guys, I will be back for commentary in just a few moments. But until then, give me time just to refresh my drinks. There. We'll watch it while it gets back on. So while we have some time, we got a few minutes on here. I will open the phone lines up just a little bit. Oh, I can't. Otherwise, I kick the feed. I can't even open up the phone lines. I keep forgetting. To me, it seems they were trying to as well. What is it? I felt really bad for that witness. She was terrified, Uncle Mike. She was absolutely, in my opinion, just terrified. And I felt really, really bad for her because, you know, she is talking about one powerful family in that area, one of the most powerful, if you will, because again, they held power in Lowcountry for over 100 years, or right about 100 years. I'm not sure if it was 100, 101, 102, or 99. Like it, but it was right up there. It was you know, damn near a century, if not more, that they held power. And even after all that, trust me, powerful families like that don't lose power just because they're out of office. They actually are able to wield probably more power because they're out of office. They don't have a risk of losing their seat. So they, you know, you can look at it any way you want it, but and then we can go over. So I just want to go over just to fill everybody in. Let me see if I can. Hold on a second. Let me see what's down here. Might be down here. There it is. So just to kind of fill you guys in on everything up to this point, hopefully we can do this in the time slot we have before they come on. I kept the volume on so it will notify us when the microphones are turned back on. So in 2015, there was a death of Stephen Smith. Now, Stephen Smith, it is alleged, and I have to say alleged because to this date, I still haven't found anybody to specifically corroborate the information with me personally, is that Buster and Stephen Smith had a relationship and was frowned upon by the family. That's what the rumor mills are saying. I don't know one way or another whether that is true or untrue. But there was a gentleman by the name of Stephen Smith that was friends with Buster that was found dead in the middle of the road that appeared to be a hit and run. It was later determined by autopsy that he died from blunt force trauma. It was inconsistent with a hit and run. However, they still ruled it an accident. His mother has been fighting because she has never believed from day one, because he was known for that lifestyle. He was not in the closet or anything like that. He was open about it. And she believed that it was a hate crime. She still believed that the Murdaughs were involved somehow. And she has always held out hope that the truth would come to light. They have reopened that investigation since this homicide with Alex's wife and son. Also, in 2018, some 2.5 to 3 years later, maybe give or take a little more than that, Gloria Satterfield, a longtime housekeeper and nanny to the Murdaughs, lost their life inside their home, falling down the stairs. That was also ruled an accident. That investigation too has been reopened, and they actually exhumed Gloria Satterfield's body to check it. Then you go to 2019, and that was the accidental death of Mallory Beach. That was when Paul was drinking and operating a boat. He was using his brother's license to get into bars in Beaufort. And, people were asking them to, him to not drive. He insisted on driving. He drove the boat into pilings, and it took over 8 days, or right about 8 days, for Mallory to be recovered in that accident. That opened up this financial problem for Alec because, which we heard from one of the attorneys earlier, that they were finally pressuring him. They were going after him personally. They were not accepting the insurance that was being provided to the family in a settlement type of environment. So they were holding Alex Murdaugh financially responsible and wanted to know any and all accounts. He was either that he owned himself 100%, even if it was joint, or he was a signer on any account. They wanted to know everything. The attorney stated under oath that it really didn't matter whether or not he got it, that this was more to pressure Alec in a better, because he was trying to tell them he was broke, and they all knew he was not broke, that he was just hiding money, and they were wanting to know where he was hiding the money. This was, and he was going to court on this specific thing on June 10th, right before the killing of his wife and son. Now, mind you, Mallory Beach's family would have been receiving a lot of money. In this case, we already heard $1 million thrown out there that they turned down. It was only going to go up from there. So why would they have any reason to go and kill Maggie or Paul in vengeance of Mallory Beach when they were already crippling Alex Murdaugh financially? I mean, they were talking about him selling 2 of his major assets or signing them over to the other family and taking out a payment plan for the rest of the money due to them. Like, he's losing his house. And all this went away. Or allegedly, he would have gone away if Paul was gone. But if he's going to do Paul, I mean, he's getting ready to divorce Maggie, and they're not doing well, right? Maggie's going to take him to the cleaners. Maggie knows too much, right? Would it be so uncommon if he's gonna do it? He might as well go, take care of all of it in one fail swoop, so we don't have to do this again in a few more years. I don't know. So then comes the death of Maggie and Paul, and that happened June 7th, 2021 in the evening hours. And his father, I thought it was a few days later. It was a month. That's right. I keep forgetting. It's a month. About a month away, a little less than a month away, his father ends up dying. Double homicide, false suspicion in case 3. Oh, no, 3 days after the murder. No, I was right. I was reading it wrong. On September 3rd, that was a little over a month after the homicide of his wife and son, he resigns. But his father dies only 3 days after the wife and son. So he loses his mom or his wife, his son, and then his father. And then he resigns less than a month later. The following day on September 4th, so this is one day after he resigns from the family law firm, Alex calls to report a strange roadside incident. And this is where he had this plot with his cousin to take him out. He was going to be leaving all of the rest of whatever was left over to his son, the only surviving heir, his son, Buster. That foiled because even though he was shot in the head, it didn't penetrate anything, or, it caused him, he had to undergo surgery and other stuff. But for the most part, he's alive, right? And functioning, right? He still looks pretty smart behind that defense table. He looks like one of his attorneys because he used to be. So that plot was foiled. And because of the church videos, which we have all this, I was out there for everything. I'll start throwing some of that stuff up. Maybe tomorrow I'll look up some stuff that I'll show you guys. But I was out at the church as well, where this foiled plot happened. And it was the cameras on the church that pinpointed Cousin Eddie as being the co-conspirator in that. Now we're finding out through testimony that Cousin Eddie has received over $620,000 from Alex Murdaugh. This guy that that is just a criminal receiving over $620,000 from his cousin, Alex Murdaugh. It's crazy. We know he was hemorrhaging money at the time. Alex gave up the real plot. He intended to have a friend shoot, him and his surviving son, so his surviving son could inherit the $10 million life insurance payout. Apparently, Buster must have been the loved child, the one that could do no wrong. He must have been the sweet one. Alex posted bond and checked himself into rehab, and only to be arrested for the felony fraud charges in the Satterfield case. By now, the case was a national sensation, making regular mainstream headlines in large parts to one of the local journalists. Mandy Matney had allegedly alienated her former news outlet by pursuing the Murdaugh case in depth than her editors wanted. In 2020, she joined the South Carolina website Fitz News just so she could cover the Murdaughs. Wow. Don't stand in that girl's way. Good job. Good job. I love hearing stories like that. You walk out the door, you want to hinder my ability to do my job. Bye-bye. I love that. Okay, and that's pretty much it, kind of bringing you full circle to what happened and what brought us here today. So there's four major things. There's Stephen Smith that's been open because of this, and Gloria Satterfield that was open because of this. And we have the fraud case, and then of course this double homicide that he's actually going in trial right now for the death of his wife and son. So they should be coming back any moment now. I am going to go and grab a little plate, and I will be right back here. It should be on. It should be on by the time I get back, but if not, it's starting very, very soon. And I will commentate until it starts if it hasn't started by the time I got back here. Okay, I must not be back on yet. Well, we do know that the judge was talking about speaking to one of the jurors. Maybe he ran late with one of the jurors. It sounded like something was going on with the juror when we were leaving, because he said, "And I'll talk to you during the lunch break." So it sounds like something else is going on. You would think I would have eaten while we were on break, but I didn't. I decided to lay down because I was exhausted. I've been up since early in the morning, and I only got to lay down for like 20 minutes, and I had to get up. So 4:30 in the morning, geez, ZA. But you know, I mean, I remember me and my best friend. We used to love. Well, this is when we were teenagers, right? I was like 16, she was 18, and we went and worked at McDonald's. And I remember, no, maybe I was 17. I was 17 because I had already gotten out of school. And anyways, we were working at McDonald's, and we wanted to go to the morning, the early morning shift, the earlier the better. So her and I would wake up at like 2 or 3 o'clock in the morning. Would get to our job about 4:30 in the morning. Or maybe it was 3:30. I can't remember what time we opened, but anyways, we'd get off at like 2:30 in the afternoon, and we always had a bag packed, and we always went to the beach. So we could hang out literally at the beach all afternoon. It was fun. We had fun. It was back when life was simple. I had a little Toyota Tercel. We couldn't even afford lawn chairs. So we backed the car up into the sun and put them over the trunk and the back windshield. And that was it had a perfect lean too. That was our, where we suntanned. I remember back in them days. So fun. So fun. Who knows? He could. You know what, Roxy, to be honest with you, we have entertained that possibility. We have talked about it because it's so speculative. I mean, it comes so close. He was spinning out of control. He was hemorrhaging money. People were about to find out his deepest, darkest secrets. Everything was about to come to light. And it's like, you know, his son and wife were out of desperation, in my opinion. I think he just felt he had no other thing. He was about to get exposed. From what I read from Paul's girlfriend, it sounded like Paul was a troubled kid. It sounded like he probably was the troubled child. In my family, it was kind of the same. My sister was always the best. She did devious stuff and always blamed it on me. But she knew she could because she was the angel of the family. I mean, it wasn't major stuff she blamed on me, but you know, she even jokes about it, like even this, you know, like later in life, like I did this. And it's like, yeah, I remember that. But she was always perceived as the angel of the family, whereas I was the youngest until my little sister came along. But by the time my little sister came along, I was already 18 years old, you know? So it's like Angela and I was always the troubled child. I always got in trouble, always had to get the attention, always just troubled. I don't know what's going on with Google. Hope I can keep awake for this. Got to get up for work. Yeah, I see that, ZA. I can't do no YouTube membership. Google won't let me. I don't know what it is, Tammy. I don't know much about that stuff. I rely on my mods. They posted the membership link in here. I don't know why some work, some don't. I have no earthly idea. I might have something. I don't know. I remember my first membership, though. It was with Adventures with Purpose. And my credit card wasn't set up. So I had to go through this entire process that really sucked. But once I was through it, then I can order anything on here. But I don't remember much about it, but I remember it was like, this is a lot just to get a membership. So good. I need to get something to eat. I wonder what's taking them so. Oh, as I'm saying, sounds like they're coming back on now, guys.
Please be seated.
As council may recall from during jury selection, juror 957 expressed a concern about being here if the trial goes too long, and he mentioned 3 weeks as his limit. So he's brought that to my attention, and he's 729, juror 729. So he's brought that to my attention, and he's pondering the issue. So just bring you all up to date on that issue. Ready for the jury?
I just want to raise one issue.
All right.
It doesn't relate to this witness, but the next group of witnesses the state intends to call relate to this blue rain jacket, and that it was seized as a result of a search at Ms. Libby Murdaugh's house, and it was found in the closet. Based on what this witness had previously shared with law enforcement. There's no evidence that we've been provided in discovery that connects the defendant with this blue rain jacket. And so we'd move to exclude any evidence of the blue rain jacket unless they can represent to the court that they have any witness who connects the blue rain jacket with this defendant, Alex Murdaugh. Thank you.
All right. From the state?
Your Honor, she has identified a vinyl blue in that closet, which she says was consistent with what she saw Alex Murdaugh coming into her house with. She said, yeah, that looks like it. There's some questions that were asked by the defense, which I'm going to ask her about now. When she is asked about a shirt or something else, but she, I believe, has testified, yeah, that is consistent with the color and the vinyl that I saw that's in the closet.
All right. Well, let's bring the jury.
Phoenix Rising, I think that was a misstep because she was at Miss Libby's house at the time this occurred. I think this is all related to the time they were at Miss Libby's, that they were that she was watching Alex Murdaugh's mom and caregiving for her between 8 p.m. and 8 a.m. And that's just to answer this question here that you had or statement. So no, I don't think they searched this caregiver's home, her personal home. I think it's related to Miss Libby's home. If you do gift memberships, no, you do not get to select. I don't get to select them either. So to be honest with you, it's kind of just whoever's in there in the chats the most active is the way I've been able to see how those gift memberships work.
All right, thank you. You may proceed, Mr. Meadows.
Your Honor. Smith, do you remember being interviewed by Patrick McDavid and Robert Purcell that worked with Mr. Harpootlian and Mr. Griffin in October, on October 20th of 2022?
Yes,
And I believe Mr. Griffin had asked you about some shoes in response to our questions. Do you remember telling them that he had, these investigators, he had on some cloth-like shoes?
yes,
And I believe Mr. Griffin asked you about the length of time you were there. Do you remember these investigators asking you about the length of time that Mr. Murdaugh was at Alameda the night of June 7th?
yes.
Objection, Your Honor. He's offering a prior consistent statement, and no one's in, I don't know why, not impeaching her with it. You can't bolster her testimony with prior consistent statement.
Mr. Meadows.
believe he had questioned the 30 or 40 minutes and was questioning whether or not Alex asked her to say that. Through their investigators, it's clarified for me their conversations that directly contradict what she said early on direct that I have through their questioning and interviews, which I just got a little while ago.
All right, Ms. Griffin.
Again, he's offering a prior consistent statement, and it's not admissible unless it's being offered to rebut a claim of recent fabrication, and that's not the situation we have here.
The entire statement right now.
In objection to the statement being entered into evidence.
Yes, Your Honor, it's not a statement. There's a whole 30-minute audio recording. Yes.
All right. Rule 613B addresses this issue, and you may proceed. The objection is overruled.
Mr. Griffin asked you the length of time that Mr. Murdaugh was there when these investigators questioned you in October of 2022. Do you remember them asking you about how long he was in the kitchen and in the room with Miss Murdaugh?
Yes,
And do you remember them asking you about, and he asked you on cross, whether it was unusual, whether Mr. Murdaugh had visited that time of night? Do you remember that?
yes,
And do you remember telling the investigators that he would not come on your shift after 8 o'clock? Do you remember that?
yes,
And that was unusual?
yes,
And do you remember one of them questioning you? You actually registered it in your mind that this is unusual for him to be here that time of night? Do you remember that?
yes,
Was your answer yeah? Because I was like, yeah, to be honest, I was like, oh, why are you here this time of night? Why are you here this time of night, you know? Because we all going to bed?
It's my mind. Yes,
And as far as the length of time, do you remember them asking you how long? And you said it was about 20 minutes?
yes,
You know, and I'm trying to speed this up, maybe court's indulgence. Do you remember, when Mr. Griffin asked you about your recollection as to what Mr. Murdaugh said asked you about the 30 to 40 minute period? Do you remember that? Remember
Yes.
just a little while ago when he was asking you about that? I'm not trying to be, just a little while ago.
yes,
Okay. About whether if anybody ever asked you if I was here or not?
yes,
And do you remember that his investigators asked you if SLED had put that in your mind?
no,
Is that the recollection or something they put in your mind?
He's leading the witness. He's publishing a document that is not a certified transcript of anything. Object.
Mr.
It's their statement. They took.
I sustain the objection.
Did Alex Murdaugh ask you to tell somebody how long he'd been there?
He said, if someone asks you, I've been 30 to 40 minutes. That's what he said.
He said if somebody asked you.
Yes.
Objection. Just repeating her answer.
Mr. Metters?
Is that the answer you gave his investigators
Yes.
back in October of 2022?
Yes.
Now, Mr. Griffin asked you about this blue tarp. Did his or Mr. Harpen's investigators ask you about that when they met with you?
Yes.
Did they bring something with them? Do you remember them showing you something?
No, a picture.
Okay. Did they also show you a tarp?
Yes.
Okay. Did they tell you they just got it from Kmart?
Yes.
Just bought it from Kmart? And I can't. So their investigators brought this with you to the interview
Yes.
and showed you this, correct?
Yes.
And had you already described a, well, who'd you first tell that there was something that the defendant may have been holding in his hand? Who'd you tell first? When he came in that morning after the funeral, who did you tell that first to in law enforcement? That the defendant may have been holding something or was holding something when he came in?
Dango, Officer Dango.
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 Okay. And as a result of that, Sled came and interviewed you.
Yes.
Okay. And then you told them what your testimony's been.
Yes.
Correct? Okay. So in October 22nd, when their investigators came, they were asking you about what you talked about to Dango, right?
Yes.
Okay. And they showed you this, right?
Yes.
And did they also ask you about if you'd seen a shirt? Do you remember when they asked you if you'd seen a blue shirt?
Yes.
What was a blue shirt?
It's a blue.
Well, I don't know. What was it? Just like a dress shirt or a shirt? What was it?
Like a rain jacket or something, like a pullover.
Okay.
Something.
But they described it as a shirt?
No. Not as I can recall.
Do you remember them asking you, you're positive it wasn't a shirt?
Yes.
They
Yes.
asked you that.
Yes.
And your answer was it's vinyl. It was a vinyl, right?
Yes. Yes.
Don't lead the witness.
And Mr. Griffin was asking you about the vinyl, whatever. Do you remember them asking you if there could have been a gun in it, his investigators?
I can't recall. I can't remember.
Thank you, Tammy.
Last question, Judge. Can I have that picture? States 411, Ms. Shelley. You've identified this previously. Does that look like the blue vinyl garment he was carrying in?
Yes.
Say that again.
Yes,
Was it all crumbled up in his arms?
it was balled up, yes.
Was it folded out?
No, it wasn't.
Was he wearing it?
No, he wasn't.
That's all. Thank you.
By the defense.
Ms. Smith, it's clear when you left the next morning, you saw the blue tarp laid out on Ms. Libby's retirement rocking chair, correct?
Yes,
And it was not a rain jacket, was it?
no, it wasn't.
It was a blue tarp, like what's in here as in evidence 86, right?
Yes,
No doubt in your mind.
no doubt.
Now, our investigators, let me ask you, Mark, for identification exhibit 87, did they show you a picture of this rain jacket?
Yes,
Had you ever, and you told them you never seen that rain jacket, right?
correct.
You know, I would introduce exhibit 87 in evidence.
Without objection.
Can I put it up here?
Did you guys see him shaking his hand and playing with his
While they're
pen?
working on that, Ms. Smith, did anyone speak to you over lunch about your testimony?
No,
You talked to any SLED agents or anybody at the AG's office?
no,
So they're putting this up, but he's nervous. You can see his hands twitching. He had to put his both hands on his notepad to stop himself from doing that. That's nerves.
Trying to get that going. Is that in full size? Yeah, let's see if we get the whole picture in there. Okay, thank you. Thank you, Doug. You ever seen this rain jacket before?
no,
Did Alex Murdaugh have that rain jacket with him when he came in to the Ms. Libby's home on the morning, I believe, a few days after the funeral?
no,
And if this photo, exhibit 41, states exhibit 41, can you see this blue thing wadded up?
yes,
If that is, in fact, the photo of the rain jacket that we just looked at, would your testimony be you've never seen that garment folded up in that closet before?
no, only thing I seen was blue velvet. I didn't know it was a raincoat or not. It was balled up.
So well, had you ever been in this closet before?
No, I haven't.
So you don't know what that is folded up there, do you?
Correct,
And so if it's this rain jacket, if that's what's in that closet, you've never seen Alex Murdaugh with this garment before, have you?
no, I haven't.
All right. Now, just very briefly, I know you've been really good here, and I know it's been a hard day, and we appreciate you being here. That day when you came to work, Mr. Randolph Murdaugh had been put back in the hospital. Is that correct?
Yes,
And that was unusual because he'd just gotten out of the hospital. Like a day before, right?
Yes.
And so it was, although it wasn't usual for Alex Murdaugh to come over that night, but this was an unusual day because Mr. Randolph had been put back in the hospital. Would you agree with that?
Yes.
All right. Thank you. That's all the questions I have, John.
Thank you, ma'am. You may step down. You may call your next witness.
State calls Kristen Moore.
Raise your right hand. Left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God?
I do.
Take a seat in the witness stand. State your name again for the record. Spell your last name.
Kristen Moore. Moore. Good afternoon. Good afternoon. Could you tell the jurors where you work? I work for the South Carolina Law Enforcement Division. And Agent Moore, you might need to pull that microphone a little, speak up so we can hear you, make sure to hear you out here. Thank you. And what do you do with SLED? I'm a special agent assigned to the crime scene unit. And did you have an occasion to become involved in the investigation of the murders of Paul and Maggie Murdaugh? Yes, ma'am, I did. Were you involved in the execution of a search warrant? Yes, ma'am. And where was that search warrant executed? At 2175 Yemassee Highway in Barnville, South Carolina. And do you know what that residence was or is? It was the residence of Alexander Murdaugh's mother. And who was there when you executed the search warrant? Several SLED agents were on scene as well as family members. What were you looking for when you searched the residence? We were advised that we were looking for a blue and colored tarp-like material. And what areas of the residence did you search? We searched the entire interior of the residence. Let's talk about the north bedroom of that residence. Do you recall what you located in that bedroom? We located a blue tarp inside the closet in the north bedroom on the second floor.
She's showing the defense the evidence so they can object and have an opportunity to review and object if needed.
Agent Moore, I'm going to show you what's been marked as State's Exhibit 224. Do you recognize what's in that picture? Yes, ma'am, I do. Is that a fair and accurate representation of what you found in the north bedroom closet? Yes, it is. Your Honor, this time the state would move State's 224 into evidence.
Admit it.
Permission to publish?
Yes.
Agent Moore, could you describe for the jurors what you found in that picture? That is the blue tarp that we located inside the bedroom in the inside the closet inside the bedroom. And what was that tarp located in? A storage container. Were there any items in the storage container? There were miscellaneous dishes underneath the tarp. After you found the tarp, did you continue searching the residence? Yes, ma'am, we did. And what else did you find? We located a blue raincoat in the coat closet on the second floor. going to show you what's previously been entered. It's State's Exhibit 223. Do you recognize that photo?
Yes, ma'am, I do.
They put that on the screen so the jury can see. Could you point out that closet for us?
It is at the top of the photo on the right-hand side. So the door immediately above the stairs leads to an attic area, and the door to the right of it is the coat closet.
So not this door right here at the very top of the stairs. The next door is the closet we're talking about.
That's correct.
And I'm going to show you State's 414. Do you recognize that picture?
Yes, ma'am, I do.
Okay. And what are we looking at there?
That is a picture of the interior of the coat closet.
Your Honor, at this time I move State's 414 into evidence.
No objection.
So admitted.
Now, Agent Moore, if you could you point out the blue raincoat or tarp-like material that you found in this picture?
It's in the back of that photo behind the white box, towards the bottom.
And if you don't mind, would you mind stepping down and pointing that out to the jurors? Okay. Would you come down to the big TV? Thank you.
It's right here.
So, and that's how you found the raincoat?
Yes, ma'am, it is.
Jammed down in that closet.
Yes, ma'am.
And if you look at this picture, it appears there are other items of clothing that are hanging up,
Yes, ma'am, there was.
but the raincoat is balled up down there.
That is correct.
And what did you do when you located that raincoat?
We documented it with photographs, and then we collected it in a brown paper bag, which was dated, sealed, and initialed.
I'm going to show you State's 225, which I believe the defense has an objection to.
Your Honor, if this is the raincoat, it's already in evidence. The photo of the raincoat is in evidence. I don't know why we need another photo, but we do object to any testimony about seizing the blue raincoat, anything beyond that, based upon my earlier statements to the court.
Response?
Your Honor, this agent's testifying to what she retrieved from the closet, and I believe this is a picture of her retrieving that item.
Objections overruled.
So, Agent Moore, do you recognize what's in this picture?
Yes, ma'am, I do.
You guys see that? The attorney wiped his face. You can tell they're getting nervous.
Yes, ma'am, it is.
Your Honor, at this time I would move State's 225 into evidence.
Same objection.
Submitted over objection.
All right, and Agent Moore, if you could tell us what is in this picture, State's Exhibit 225.
That is a photo of the blue raincoat that I collected.
And this will be State's Exhibit 226. Without opening this, can you tell us what is in this item? State's Exhibit 226.
Based off of the item number and lab number and my initials, this would be the blue raincoat.
Your Honor, the state would move State's 226 into evidence.
Objection, relevant.
No response.
Your Honor, this is the purported raincoat that was recovered from the closet.
Submitted.
All right. And when you recovered that raincoat, what did you do anything with it besides photograph and collect it?
Not on that day. We transported it back to the SLED Forensic Services Laboratory.
And now in the closet where you found that raincoat, were there any guns?
No, ma'am.
Were you involved in any of the processing of the raincoat?
Yes, ma'am, I was.
And what part were you involved in?
On October 7th, 2021, at the SLED Forensic Services Laboratory, I met with SLED serology personnel to document and do additional processing on the raincoat.
And what processing did you take part in?
It was documented with photographs. The stains on the raincoat were then documented with scale tape and labeled, photographed again. SLED serology department then tested the stains with phenolphthalein, which is a presumptive test for the presence of suspected blood. All testing with phenolphthalein was negative. We then used an alternate light source to look for any latent stains on the raincoat. We observed an additional stain and documented it with photographs as well as scaled it. Then it was tested with phenolphthalein as well, and it was negative. We then used leucocrystal violet, or LCV, which is also a presumptive test for the presence of suspected blood, and it was negative also.
All right, as far as your involvement in the raincoat, does that pretty much sum it up for us?
Yes, ma'am, it does.
All right, thank you, Agent Moore. Please answer any questions from the defense.
Good afternoon, Agent Moore.
Good afternoon.
So I understand you went to Almeda, Ms. Libby Murdaugh's home, to execute a search warrant. Is that correct?
Yes, sir, it is.
And what was the day? September?
September 16th, 2021.
September 16th, 2021. And you were looking for a blue tarp.
We were advised that we were searching for a blue tarp-like material.
Okay. And you found a blue tarp. Is that right?
Yes, sir.
And in that blue tarp, there were dishes wrapped up in that blue tarp, right?
No, sir, no dishes were wrapped in the blue tarp. It was folded on top of the dishes.
Okay. So you seized the blue tarp, right?
Yes, sir.
And did you do any testing of the blue tarp to see if there was blood?
No, sir, I did not do any testing on the blue tarp.
You know anyone who did any blue testing on the blue tarp?
I am unaware of any testing done on the blue tarp.
You seized this rain jacket in here, in this box. Is that correct?
Yes, sir, it is.
And back in the lab, you did some presumptive testing. We sprayed it with phenol first.
Phenolphthalein was first utilized, yes, sir.
And phenolphthalein is a presumptive test for blood, meaning, you know, it could test positive, but it's not necessarily means it's blood, right?
That is correct.
And in order to determine whether something that has tested positive with phenolphthalein, you do another type test to confirm human blood, right?
That is correct.
But the blue rain jacket never tested positive for the presumptive test using phenolphthalein, right?
That is correct.
So it was negative.
Yes, sir.
So after getting negative with phenol, then you use another product called LCV. Is that right?
We did. We used an alternate light source first to make sure that we had all stains documented.
Now, an alternate light source is what?
It is a specific wavelength of a flashlight, and you used a colored filter, and then you can see any latent things that you wouldn't be able to see with your naked eye.
And the alternative light source doesn't tell you whether that's possibly blood or something else, does it?
No, sir, it does not.
So you use that alternative light source and you identified some area. And is that the area you tested with LCV?
We tested the entire raincoat with LCV.
The entire raincoat? Okay.
Yes, sir.
And again, that's a presumptive test like phenolphthalein.
Yes, sir.
And that tested negative.
That is correct.
Okay. And so there's no more blood testing done of the rain jacket, right?
I was not involved in any further processing of the raincoat.
Do you know if that LCV that you sprayed on the entire shirt has turned the rain jacket in that box completely violet?
I have not seen the raincoat since the processing was done on October 7th, 2021.
Okay. What size is this rain jacket?
I could not tell you the exact size of the raincoat.
Well, would you agree with me that the records indicate it's a large?
Yes, sir, it is a larger jacket.
Well, the size being large, do you know if it's large? That's the size?
I do not recall the size.
Do you mind if she opens it up? Your Honor, do you mind if the witness opens the box up? Let's see what size the rain jacket is.
Any objection?
No objection, Your Honor.
It sounds to me like there's a lot being done with this rain jacket to exclude
No, I don't
it.
have scissors, I have gloves.
So I'm curious why, especially since they're saying that all the presumptive tests came up negative. This should be interesting. I'm wondering where this is going. Funny, the microphone can pick up all that, but let witness talk and they can't hear her. Well, if nothing more, it does show that they tried to preserve the evidence very, very well in this case.
Tell us what size it is, please.
Yes, sir. I don't see a tag. I don't see a tag right here at the front. You may want to put gloves on. It has chemicals on it.
Ooh, I don't want to touch it then, which I just did. Okay. Well, do you mind standing up in front of the jury and show them how large it is? Is it a poncho style rain jacket?
Yes, sir. It appears that way.
Okay. All right, thank you.
Thank you.
Smells too good. Do you know if that rain jacket or photos of that rain jacket was shown to any members of the Murdaugh family to see if they recognize it?
I am unsure.
You did not then, did you?
No, sir. I did not.
Did you show that photo or picture, excuse me, the photograph, the rain jacket? Let me scratch that. Did you show to Shelley Smith the rain jacket or a photo of the rain jacket?
No, sir. I did not.
Do you know of any sled agent who did?
I do not.
1 second, Your Honor. That's all the questions I have.
Further questions?
I only brought this up here.
All right, Agent Moore, what happened to that tarp or raincoat? Where is it?
It's in the
back
box.
box.
Yes, ma'am.
All right. State's Exhibit 226. This is the raincoat you collected from that closet at Alameda.
Yes, ma'am. It is.
Now, when you collected it, did it have like this tape here on the raincoat? Where we can, the white tape with the letters on there?
No, ma'am. I placed that on that.
So that was done during processing?
Yes, ma'am. It was.
And we've been talking about a raincoat, but is this what you would normally think a raincoat would look like?
No, ma'am.
This is rather large for a raincoat.
Yes, ma'am.
When you found it, it was balled up like this?
That is correct.
No further questions for this witness, Sean.
Thank you. You may step down.
Thank you.
Call your next witness.
William McElvey.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give shall be the truth, so help you God? Take a seat in the witness stand. State your name again. Spell your last name.
My name is William McElveen, McElveen.
Mr. McElveen, how are you doing today?
Doing well, how are you?
Doing well. If you would, tell the jury a little bit about yourself. Where'd you grow up, and where'd you go to school?
I grew up in Columbia, South Carolina. Went to AC Florida High School. Went to the Citadel after high school. Graduated there in 2017. Went to get my master's at Clemson. Graduated in 2018. Moved back to Charleston, worked for a CPA firm for a while. And now I'm in finance for a home builder.
For where, sorry?
For a home building company.
And what area generally do you currently live?
Live in Charleston now.
Mr. McElveen, were you friends with Paul Murdaugh?
I was good friends.
All right, well, tell us a little bit about when y'all first met.
So I lived in Edisto Beach every summer with my granddad, and when I was growing up, and he was in Edisto all the time, so we just became close. Edisto's a small town, not many young people live there, so the young people kind of stick together. We both love fishing, hanging out, so we just became good friends through that.
So you would spend the summers in Edisto?
That's correct. Yep.
And what kind of things would you do throughout those summers?
Just hang out, work, fish.
What kind of jobs did you get?
Worked multiple jobs there for 5-ish summers. Worked the marina a good bit, a restaurant there called the Sea Cow. I worked at a realty company as an inspector and at the Bilo as well.
Okay. And I think you just said, but you met Paul about the high school years?
That's correct.
Okay. Tell us a little about your friendship. How did it start, and how did it kind of evolve?
It started just kind of common interest in fishing and hanging out. And then he was just a really fun guy. So we just hung out more and more. And I started going to Moselle, hanging out with his whole family. They kind of took me in and went to Moselle, hanging out with his whole family. They kind of took me in and just evolved from there. Yeah.
So did you get to know him pretty well?
Yes, I did.
Did you get to know his family fairly well?
Yes, I did.
Tell us a little bit about Paul.
Paul was just a really fun guy, just like the life of the party kind of guy. Everybody that really knew him loved him. I don't know, just a great guy, very loyal friend, the kind of guy that's always there when you need him.
So if you reached out and needed something, you might have to pull that mic a little closer to your mouth so it picks it up. Just try to speak into the microphone.
Okay.
So was he sort of a responsive friend? Meaning, if you reached out to him, would he respond back?
Yes, he was very responsive.
And how did you primarily communicate with him? What means?
Cell phone normally. Yeah.
Phone calls or text?
A little bit of both, but mostly phone calls. He was a big phone caller. Yes.
Well, I guess tell us a little bit about Paul's cell phone use. Did he like to use his cell phone?
He did like to use a cell phone.
How would you describe it? His use of cell phone?
He used cell phone a lot. Like kind of every time he had a road trip or anything like that, he would use it to call all of his friends and just check in on everybody. And I can speak for almost all of his friends. We get a phone call from him almost every day. And then he used text a lot, Snapchat, that kind of stuff.
Was he on his phone quite a bit?
Yes.
To the point where was it very noticeable to his friends?
Yes.
Did you ever have a chance? Did you have an opportunity to get to know Maggie Murdaugh?
Yes, I did.
All right. Well, tell us about her. What was your observations about her, or your whatever friendship y'all had?
She was just a super sweet lady. She kind of always trusted Paul when he was with me. She would know he's staying out of trouble. I don't know, she just treated all Paul's friends like they were her kids. And very nice lady.
And did she approve of you hanging out with Paul?
Yes.
Okay. Tell us about that.
About what? Sorry.
Well, did she ever comment to you about how she liked you hanging out with Paul?
Yeah, she did. Like hang out with Paul.
And did you have an opportunity to get to know Alex Murdaugh?
I did.
All right. And what were your perceptions of him?
Kind of the same way with the rest of the family. Just took everybody in, all Paul's friends. He was kind of the dad of all of our friend group. Same way with the rest of the family. Yeah.
And is he here today?
Yes.
Did you identify him?
Yes. It's in the brown jacket.
Thank you. Did you ever get to go out to the family property on Moselle?
Yes, I did.
How often would you have you been out there visiting?
Probably 30 or 40 times.
Okay. Did you spend the night when you went out there?
Yes. Normally.
Tell us a little bit about the property. What kind of things would y'all do out there?
Did a lot of hunting. Also, probably more than hunting, just hanging out. Just enjoying each other's company, hanging out.
So you said about what, 30 to 40? Is that what you said?
That's correct.
Okay. If you would, please
Yep.
speak up a little bit. It's okay. All right. Now that the property, was there a main house location?
There was, yes.
All right. And was there a secondary location for kennels and a shed?
Yes, there was.
All right. Did you spend much time out at that secondary location?
A good bit, yeah.
All right. Describe that area for us, if you would. What was out there, and what would you do out there?
So it's like a big shed hangar that side comes up. We'd all hang out over there. And there's the dog kennels. And then a few years back, they built the shed across from the hangar. And it was just a good place to get away from the main house and just hang out and talk.
If you were visiting Moselle, would you spend most of your time hanging around at that shed, the hangar area?
Depends. For large groups, we would have people over there more often. If it was just me and Paul and the family, we just hang out at the house.
You mentioned kennels. Were there a number of dogs on the property?
There were, yes.
Okay. Do you remember them?
Yes.
Okay. Tell us about the dogs you remembered. And what, first of all, were there kind of two different kinds of dogs between family dogs or working dogs?
Yes.
Okay. Did you get to know any of the family dogs?
Yes.
Who were they? Tell us about those dogs.
Bubba is a yellow lab, and then Bourbon, brown lab, and Grady is a black lab. And they were all pretty relaxed, would hang out around the house mostly, but I don't know, they were just good dogs.
Did they, and when you slept over there, did the dogs sleep at the house location, the main house?
Yes, they did. The family dogs did.
The family dogs.
Yes.
And then there were some working dogs where would they stay, the working dogs?
They would stay in the kennels by the shed.
Yes, the location. So the Moselle location, when you started going there, did it have one or two entrances and exits?
Two entrances.
Okay.
And exits.
And describe the two entrances.
So one was the main entrance that was had like brick pillar outside, and that would just kind of go to the house and not really pass anything, go through some trees. The other entrance would be next to the cabin, right behind the shed, and that entrance can kind of go multiple ways when you go in there, but that passes by the cabin and the sheds and then goes to the house as well.
And with that entrance, is that where the mailbox was located?
But I can't remember the mailbox is. I believe those at the pillars at the main entrance, maybe.
Is that the location near the dog kennels?
The mailbox is to the
Yes,
dog
yes.
kennels. I was there, not at the
Was
front
there
main driveway.
one exit that was used more often than the other?
We probably more often use the one by the sheds.
If there was ever a time where someone was leaving the house and you all were down at the kennels, what was the normal course of action for that person, whether it was Mr. or Mrs. Murdaugh?
Say that again?
If anyone was leaving the house or coming back and you all were down at the shed area, the kennel area, what was the normal course of action for Mr. and Mrs. Murdaugh if they were leaving the house and exiting and you were down there?
Typically, they would come check on us and drive by and just say, hey. But
That was normal?
I would say it's normal, yes.
Did you, with Paul, were you guys close enough where you shared your location with each other?
We did find my.
Tell us what that means is this an iPhone?
Yeah, it's the app on Find My Friends on iPhone.
And what does it mean to actually share your location with someone?
Just means any point in time you can open your phone and see where all your friends are and pinpoint their exact location.
Did you do that with many people?
Probably 5 or 10.
Do you know if Paul did that with many people?
Don't think Paul did with many people now.
When you spent time down at the hangar and the kennels, was it common for firearms to be stored down there or left down there?
Not common, no.
In those times, you said you've been about there about 30 to 40 times. How would you explain common? Was it something that you frequently see or not frequently?
I can't remember a time I've seen firearms left at the sheds.
When's the last time you saw Paul Murdaugh?
June 5th, I think, 2 days before.
That weekend before
Yes.
Monday, June
Yes.
7th? Tell us about that weekend.
I can't remember much. We were hanging out with my friends' houses. I think we went to a bar called the Windjammer in Charleston. But I don't remember much from the weekend.
Did you see him on Sunday?
Do not think I saw him on Sunday, no.
Did he stay at your house that weekend?
I don't think so. My friends and I were talking about that. We can't remember if it was my house or one of my other friends' houses.
Would Paul commonly stay when he was visiting Charleston? Would he crash at people's houses?
Yes, he normally stayed at our house.
But you don't remember if that particular time he did or not?
Don't remember.
How were you kind of told about the murders? How'd you find out?
So I missed a few calls in the middle of the night that I didn't wake up to. The next morning, my roommate came in my room and told me.
Your roommate is who?
Frank Chapman.
And he told you what happened?
Yes.
Did you make it out to the property at all?
Yes, the next day I went out to the property.
So the 8th of June?
Yes.
And walk us through what happened out there when you made it to the property. Where did you go?
We just went to the main house and just went to see the family and be with everybody.
A lot of friends and family were there?
Good bit of friends and family, yes.
Back to Parkinson's.
Did you attend the funeral
He
as well?
goes.
I did, yes.
Beg the court's indulgence. Further questions?
That's,
Good afternoon.
Afternoon.
Mr. McElveen, where are you from?
From Columbia, South Carolina.
And are you friends with Will Chapman and Frank Chapman and Will Loving and
I am, yes.
that crowd? Okay. And And so you met with Paul, I take it, down at Edisto with the Columbia group?
Yep,
And you became really good friends of Paul's, correct?
correct,
And I think you described him as a loyal friend, did you not?
correct.
And you became close not only to Paul, but to the entire Murdaugh family, right?
Correct.
You know, there are houses that kids, teenagers, young adults congregate at their parents' house. Was the Murdaugh house at Edisto one of those houses where people would congregate?
It was, yes.
And you spent a lot of time at Edisto there
I
in the
did.
summers?
I did, yes.
And you spent time around Alec and Paul and Buster and Maggie, is that correct?
That's correct.
And how would you describe Alec's relationship with Paul?
They had a very good relationship. They were kind of best friends in a way.
They were close.
Very close.
And how, from your observation, how would you describe Alec's relationship with Maggie?
From everything I've seen, it was great too. I mean, nothing. I've never seen anything negative.
Right. And they like for Paul to hang around with you, and right?
That's correct.
I mean, I think you were asked about that. You strike me as someone who's very responsible. Did they like that about you? You think?
They did. I think so.
And you strike me as someone who if you're down at Moselle, would not leave guns laying around. You wouldn't do that, would you?
Probably not, no, sir.
Okay, so when you were with Paul, hunting, you were responsible enough to be sure that guns got put away properly, correct?
Correct.
You were asked about some of their dogs. Actually, Paul had a puppy, did he not?
He did.
You have that puppy now?
Trial strategy.
What's his name?
His name's Goose.
How's he doing?
He's doing great.
Glad to hear that. And you describe 3 labs: Bubba, the yellow lab, Verdon, the brown lab, and Grady, the black lab.
That's correct.
And when you were at Moselle, I mean, these were family dogs, and they stayed up at the residence.
That's right.
Up at the residence, they had a invisible electric fence around the house, correct?
I didn't know about it, but possibly so.
Okay. Well, was Bubba a handful? Just take off sometimes?
Sometimes.
Right. And you don't know, when was the last time you were at Moselle?
I can't remember.
Was it in 2021?
Most likely.
Okay. Were the dogs there?
Can't remember.
When you heard that Paul had been murdered, did Will Loving come down to your house in Charleston, or was it another friend's house?
Will went to another friend's, but I think he came to our house later in the day. But we had a group at our house as well.
And then you went to Moselle?
The next day we went to Moselle.
Would that have been on that Wednesday? Murders were Monday night, late.
So yes, I guess that Wednesday we went to Moselle.
So not the Tuesday, but the Wednesday.
I believe that's correct.
And who all went with you?
I think Frank Chapman went with me. And that might be it.
Okay. And who was there when you got there? Were any other other friends of Paul there when you got there?
Rogan was there, and Nolan was there. And
what was?
Might have been a couple more, but I'm not sure.
Okay. What was Alex Murdaugh's demeanor when you saw him?
Just sad, crying.
Did y'all hug?
We did hug, yeah.
I mean, did he He was crying?
Yes.
And did you go back over to Moselle after the funeral?
Yes, I did.
And were there a bunch of Paul's friends there?
There were, yes.
And can you tell me, was Alex, is he still crying, hugging all the Paul's friends?
He was still crying. I mean, there were so many people there that it was kind of a line to see him, but from the little bit I saw him, yes.
One second, Your Honor. Don't have anything further.
Anything further? Thank you. You may step down. Break, addressing the jury, 15 minutes break.
So it looks like we're going in on break right now. So a couple of oddities that I found. A lot of focus was on this blue jacket and excluding this blue jacket from evidence. And the blue jacket was in line with the statement from the house, the caregiver to Alex Murdaugh's mom. However, she described a blue tarp. I'm not sure what the whole purpose of that blue jacket is and why they focus so much on it and why the defense was trying to exclude it so harshly. I mean, they really went at it to get it excluded. And I was curious about that because it seems like it would have went in favor for the defense because it had no blood or presumptive blood tests on it. So there must be an analysis that's going to be coming up that's going to, where that jacket is going to be a huge piece in this case. I really don't know. But it seems like they were, working very hard, and they were also with this last witness, William, which is Paul's friend. It seemed like they were focusing a lot on the entry points into the house, making it known that there is another entry point from the house to those dog kennels without going on the road. I think that was it. Plus, they talked a lot about the fact that the guns weren't left at that property or out there in the area where the dog kennels are. And then the only thing the prosecution could really rebut is like, oh, they like you because you're responsible. I'm thinking, he just gave testimony that he was out and he couldn't remember where his friend stayed that night. I have to think that, yeah, he's a good kid, but he's a party animal right along with Paul. Okay, that's what I got from that statement. So it's not like, I mean, maybe in front of the parent's face, he looked like, a boy that was really good, but we all know how that works. You're good in front of the parent's face. When the parents back return, what they don't know won't kill them, right? He seems like that kind of kid. He doesn't seem like a bad kid. I mean, he looked very well put together. He still looks like a normal kid. And hanging around Paul that drinks an awful lot, and then giving testimony that yes, he was here this weekend, but we can't remember what house we stayed at. It sounded like the boys talked about where did he stay, and they all seem like they must have had some amnesia, which is probably most likely alcohol, the weekend that Paul was there. So it's a little sketchy on that, but it was the defense tried to turn that around like, oh, you're so responsible. So while you're there, yeah, naturally the guns go back into the place. I don't think that's what it is, because he gave testimony that, when he goes out there, he doesn't see guns, laying around. Obviously they hunt without him. So those times that they did hunt without him, he didn't see the guns there either. So I don't know. It seems like they're honing in on disproving the fact that the guns were already readily available for just anybody to come there. And two, there seems to be something more to that blue jacket as opposed to the blue tarp. So I'm very curious about that. That blue jacket did look large, but it's long. But I don't know if that blue jacket would have, I don't know if that blue jacket would have fit Alec, but it was large enough that you could bring a rifle. And we have to remember the testimony of the caregiver, which basically said that he took off on an ATV at the mom Libby's house. So Gore-Tex raincoat would like to have a small tarp rolled up. Could look like a small tarp rolled up. Yeah, it did look like one. But I have a funny feeling because I remember hearing the rumors about gunpowder being found on a jacket. So I'm wondering, even if they're not trying to put the jacket into evidence because they believe that there was blood spatter on it, but rather the gunpowder from a gun. Maybe they're trying to say he disposed of a gun, and that's how they believe he disposed of the gun. He wrapped it in that. He took it over to his mother's house, took off on the ATV, and it was never seen from since. But there's something with this blue jacket, because the defense was really trying hard to get that blue jacket out. And again, had no presumptive blood test that pinged on it. Nothing lit up. And they found many spots on it, but none that tested for human blood. So I have a funny feeling that blue jacket's going to contain that gunpowder residue that we've been hearing about. So we will see. I don't know. What are your thoughts? Let me know down below. Do you think that it's, with a show of ones, do you think that they're trying to put this jacket in as evidence for the gunpowder evidence? Or do you think it's something else? Put it a 2 if you think it's something else. Because I heard that there was a jacket with gunpowder residue on it. I was just thinking like a trench coat type thing. It definitely wasn't looking at it being, a gun being wrapped up in a jacket. So this is new for me. And it was a one size fit all, not a large. Yeah, it was pretty big. It was pretty big. Well, she didn't test. She was only there for, yeah, maybe, but she was the prosecution's witness. So maybe the defense didn't want to bring in yet another key piece of evidence, and why they didn't ask the question, because the defense didn't ask the question because they were just trying to enter it in as evidence. And, they said the presumptive blood test did not return a hit. So maybe it's not time. Maybe the prosecution knew that she did not have or was not present for the next round of testing, which could have been the GSR type testing on the jacket. They did locate spots on the jacket. So I'm curious if those spots are gunpowder residue. I don't know. Very interested. Very interested. But I would think that if it was a gun, even the blowback from the gun, I would think that if he would have had it been covered in blood or sprayed with blood, so would the gun itself. I don't know. You would think some of that would have had some cross transfer onto that jacket if that jacket was carrying. I don't know. But I just thought it was interesting. Those are the key factors that I seen out of those two witnesses. Was one, and we can't forget what he was wearing. So apparently he already had showered and changed clothes before he went over to his mother's house. I would have liked the prosecution to have asked, because we had just found out that the father had just gotten out of the hospital like a day or two prior to him being resubmitted into the hospital, and that's Randolph. What I would have liked to hear asked of that witness, honestly, was whether or not when he went into the hospital the first time, did Alec come over that evening? Because Randolph just got out of the hospital. So that would have kind of corroborated that he would have went over. Neither the defense nor the prosecution asked that question. And I was very interested, because I was sitting here like, why don't you ask this question? Why don't you ask this question? Because it wasn't until almost later in her testimony that she said when he was talking about how unusual that event was, and she says, and it was the attorney Griffin, the one that's part of Murdaugh's defense, said this was an unusual circumstance because Randolph had just got was it Randolph or Rudolph? Randolph, yeah. Randolph had just gotten out of the hospital and he had only been home. So it was very unusual that he went right back to the hospital, right? And she says, yes. But he didn't say when he went to the hospital the first time, did Alec come over? Because that would have been a recent event that was similar to this one. And if he didn't come over for that event, then why would he be coming over to this one unless it was in conjunction with it being the second time he went in and knowing he was at the end of life? I don't know. Definitely some questions that I would have liked to hear the answer to that were not asked by the state or by the defense. So honestly, I don't think he'll get anything or may get very little for these murders. I don't know, Mary Jane. I really think that the prosecution is building a great case. The state is building a great case. Granted, we haven't gotten to the defense aspect of it and do not know what Alex's team is going to put together and rebut all this with. So we're not even halfway through this game yet. And it is a game. It's like chess, right? And Alec is the queen and everybody's trying to protect the queen. Or the king, but I think I like the queen. The queen is an important piece, right? So I just think that it's chess moves here. And I think that the defense has made some fatal flaws in this stage of it. I think the fatal flaws of introducing the motive, the financial aspect of it, and then corroborating the fact that they had already asked these questions of the caregiver. They had already put her under deposition and recorded her statement. And they withheld that from the prosecution. However, during the testimony, they brought it up and had to turn that piece of evidence over to the prosecution for review. And she did state the same exact thing that she had stated to them many, many months ago. So that kind of bolstered her testimony. I know we were all here kind of waffling because she seemed very scared giving her testimony. She seemed very timid and trying to not be so harsh on her prior or current boss, Alex Murdaugh. Is she still working for them? I don't know. But she seemed awfully terrified to answer some questions and almost went out of her way to say what a great guy he was. So, hey, Connie, nice to see you. I know they do. They have, sometimes it's just, and some of the questions they asked really, it just seems to me that it didn't really help or hurt. It just seemed like it really didn't matter. Why even bother wasting your time? But they do. And yes, they end up sticking their foot in their mouth. But a lot of it could be because Alec might be on the sidelines pushing him and saying, you didn't ask him this, you didn't ask him that. They may be there saying, look, this is a double-edged sword. Well, I want you to ask it. And it turns around and it's like, we told you, but some of it could be because his defense believes that they got this. I don't know. AM will be a bobblehead in prison. I am Team Summer. That's too funny. That's too funny. I noticed that also she seems a little scared. Yeah, to me, she seemed terrified to give her testimony. She, at some points, just seemed like she was almost trembling. I felt bad for her. She probably, feels like this is going to jeopardize her reputation in that town, and it very well may. But she, at the end of the day, they can't blame her. She's required to provide proper testimony. And if he told her that he was there for 30 to 45 minutes when she knows darn good and well he was only there 15 to 20 minutes, yeah, that could put her in a predicament that makes her feel very, very uncomfortable. And then finding out there's a murder trial in which she's a witness for the state, that kind of compounds that nervousness, in my opinion. She did good. Yeah, she did do good. I thought she did very well. But you could just see that she was very uncomfortable there. No Phoenix Rising. I heard Cousin Eddie will be here Wednesday or Thursday, from my understanding. That's if the information is accurate that we have. I don't know, is Cousin Eddie going to be working for the state, or is he going to be more help for the defense? That's something that definitely we would like to get to the bottom of. I'm curious as to how he's going to explain receiving $620,000 from his cousin. And I further want to hear how he's going to explain the day that the botched suicide in September happened. I'm interested in that information. Absolutely. I felt bad as well. Yeah, it's hard not to. You could just tell. I bet she is so glad that's over with. And God, she probably crossing her fingers, praying to God they don't have to call her back. Because they can call witnesses later down that they've already spoken to if they forgot something before the conclusion of their case. I sent you a message. I think it's a clip of the boat party. Okay, thank you, Pebbles. Maybe I can't play it while we're here because it'll kill my feed to Court TV. And my feed, it's this whole thing with these computers is driving me nuts. And I just can't seem to find the time, to research other stuff, other software to use. I don't have the time. I've been trying to find the time to even do the littlest, stuff so we can get off the StreamYard and get things back the way they need to be. But you're talking about me having to learn a whole entire new system when I have a freaking plate full of crap to do. Plus, after we get off this, which this won't be off until 5 or 6, I still have to study for my meeting tomorrow at the county. Yeah, the accident sounded sus in September. I think in the back of her mind, she knew something was wrong. I think she knew something was off when he showed up there, and then to find out his wife and kid was killed shortly after he left, supposedly, or during his stay there, supposedly. But I don't think that's what perked her curiosity more so than him coming up and trying to change the time he was there at his mother's on that night. That sounds really sus. So much so, she called her brother, which is an assistant chief in another adjoining county, probably for advice, saying, hey, this guy did this. And he probably reached out to somebody on her behalf saying, look, my sister works in that house. Something ain't right. For all those, I see somebody else posting in there. Yes. Adrian, what was his name? I got it written here somewhere. And I have the file in here with me. Hold on a second. I guess I don't. The Adrian kid that we talked about this morning on our live. Oh, here it is. Adrian Fauci. He went in there. They were doing voir dire. They were picking out the jury selection, and he went ahead and confessed and does not want the trial. He's going to go ahead and confess to that case. He's going to save the taxpayers as well as the families a lot of additional grief by going ahead and pleading guilty. I'm sure that was at the representation or at the suggestion of his counsel. They probably realized there's no good need to move forward, that they're not going to be successful in this case because of all of the damaging evidence against him. And in an effort to save him some time, or, he's underage, so he's not going to get the death penalty, but he was being charged as an adult. And so it might have been part of a plea deal as to why he went ahead and pled guilty to the crime. So we'll see what the sentencing phase prescribes, but that's just an update. There wasn't a lot. I was actually tempted to go up there and watch the trial because it's so close to my house. It's here in Florida, and it's an extraordinary case. that was garnering a lot of attention. However, a lot of these other cases kind of drowned it out. And I just found out about it this morning. And one of the reasons why we were running late this morning, I didn't start at 6:30, is because I was researching that case to talk to you guys about it, because I knew voir dire was going on. Apparently, he just wanted it over. He wanted the sentencing to begin. He didn't want to fuss anymore about it. It seems to me like he was taking I don't know if he was taking personal responsibility or if he just gave up because his attorney said there's no way to win this. We don't know which, but he did. The case is over. He's admitted to his wrongdoing, and he's going to be held accountable to what the courts deem appropriate. This is a long break. And holding that info in her head must have been terrifying. Oh, you guys are welcome. Yeah, I mean, tomorrow's going to be a little tricky because I'm going to be at the meeting tomorrow, but I'll leave this open. I can't imagine me being there for this longer than noon, but who knows? It may roll over, but I'll just keep this live up tomorrow so you guys can watch. I won't plug in because then it does something. It makes all the cameras come back on. I can't turn the camera back off in my office. So I'll just let it run live. Those that want to watch it can. Those that don't, don't. Since I wasn't doing anything today, I figured I would regulate and monitor this a little closer for witnesses and things like that, so we can actually have the proper spellings of their names and know who is speaking and what they are speaking regarding. So I'm trying to keep up and trying to listen really hard and intently to the people's names so we can get them right on here so you guys know who's speaking. I'm starting to get tired. BHB curious, Chef Dizzy, that neighbor Ian Harsh, why did he go silent when Brian got arrested? Did he know him? I don't know. I mean, to be honest with you, just Samantha, he was attacked really heavily, like that Jeremy kid that came out and talked about, some stuff. Every time anybody comes out and talks about anything related to the case, these cockroaches and vultures come out and just attack them needlessly, but because they went to the meet. Like, who the hell do you think you are to try to silence people? Like, people are idiots, and it's across all social media platforms, not here on YouTube. Quite frankly, the biggest violators of misinformation are the TikTokers, and a lot of the stuff coming off of TikTok is just insane. Like, I expect it from Facebook, especially in the discussion groups, because that's what the discussion groups are about, is discussion and speculation and stuff like that. But honestly, I really don't. I can't tell you. I'd have to think that maybe it just wasn't worth it to him. He came out, he said his piece, he made changes to his stuff. You never know. Maybe the reason why he put that no screams in there is because law enforcement told him at the beginning of this, don't let this tidbit of information out. But as information was leaking, he's probably saying, look, I did hear the scream. And we don't really know. All I know is that social media can be very unkind, even to people that are witnesses in a crime. These vultures, they're so busy pointing the finger, saying, hey, look over there, so you're not looking at them. But we need to start looking at them, because we know who the true vultures are, and it's not the people that are bringing these cases to you. It's the people that are attacking the people for bringing the cases to you. What are they making money off of? The same damn cases. They're just complaining about them. They're still making money off of them. Still making money off of them. All right, I'm going to go silent. Looks like they're coming back on. They must be coming. The jury must be lining back up. I thought they'd be back in since they reposition the cameras. Usually when they reposition the cameras, it's usually when the jury's coming in. Oh, excuse me. Starting to get late for me. All right, I'm going to get up and stretch my back. I'll be back.
Please be seated.
Is there anything before the jury comes?
Ladies, courts are both one moment.
Oh, good, they're back.
Ground for attempting withdrawal. It shouldn't be a complicated
Issue with Mr. Waters and I are complicated people.
Yes, sir.
Mr. Waters and I agreed to some consternation on your part to this charge. And of course, obviously, it's a suggestion to you.
Yes, sir.
Which is suggested you obviously have authority.
All right, Mr. Waters.
Your Honor, and I don't know if Your Honor has another instruction that you prefer. I probably would do the language just a little different in that particular one, but I think fundamentally the principles are accurate. I do think that the next to last sentence is superfluous because that's already said, but I think that's fine. And in the end, I don't think that there's too much that we have an issue with that particular charge.
And Your Honor, other matter before we bring the jury in, you want to hear from me now? The state intends on not this witness. If this witness is another witness, there's a GSR person, specific GSR person.
That's correct. It'll be the witness after this.
Okay.
They said
Evidence
GSR.
of GSR gunshot residue on that blue jacket. We would object to any such testimony under a 403 analysis. Prejudice outweighs the probative, and I'm struggling to figure out what the probative is. So I'm in this
I mean, I think
I
it's
knew it.
factually driven. I think the state needs to give you some sense of what it proves. A jacket, I might point out, no one has put in the hands of the defendant. And the tarp that they found, they never tested for GSR, blood, DNA, and everyone says tarp. That's a jacket. I don't know how you connect it to the defendant. If the prejudice far outweighs any probative value in that it's not been connected to him, even circumstantially not connected to him. The only witness to it, Shelley, who I've talked to a couple times, indicated that was not what he had in his hands. She'd never seen it before, never seen it with him. So, Your Honor, we'd oppose it under a 403 analysis.
Yes, Your Honor. I think if you listen to the testimony of Ms. Smith in totality, first of all, she identified a picture where she said, yeah, that looks like what it was. It was balled up. And that picture, of course, was then identified by Ms. Moore as where they recovered the actual raincoat, which, of course, is a very, very large raincoat and very easily could be identified as a tarp. I think any issues that Mr. Harpootlian wants to make, he can certainly argue those to the jury, but the connection has been established between Ms. Smith and that particular raincoat, and looking at the picture and saying, that looks like what I saw. Additionally, with that other tarp, she also testified that there was no silver on that tarp, and if you look at the picture of that other tarp, it is half blue and half silver, so it's a very...
Which other tarp?
There was, I think, Miss, and I'll have to find the exhibits for me real quick, Your Honor. Today, yes, please.
So right now they're trying to object to the GSR because the GSR evidence and analysis is going to be coming in.
So, Your Honor, and I can put them up with the elbow or hand them up, whichever you prefer, but we have State's Exhibit 224, and this was a tarp you can see with a lot of silver on it, but State's Exhibit 411, Ms. Smith identified as that's what it looked like. You can see that balled up thing right there, and that is ultimately the rain jacket, which as you saw, particularly on redirect with Ms. Gowd, this is extremely large, very easily could look like a tarp. And when she balled it up, Ms. Smith said, yeah, that's what it looked like. So I think there's been enough of a nexus established as to the probative value. And what you'll, of course, hear is that from the GSR experts is that very high levels of GSR were found within the inside of that blue rain jacket, which again is this big and very, very long. Again, Mr. Harpootlian can argue to the jury whatever inferences he wants to, but I think the state has established enough of a nexus to not only make it relevant, but to make its probative value not substantially outweighed by the danger of unfair prejudice. Yes, sir.
I think he either misunderstood or is misquoting what Ms. Smith said. She said, when she was shown that photo, she said, it's the same color or like the same color. She never, ever, ever said, that's what I saw him with as he came through the door. And by the way, she found the tarp. That couldn't be the tarp because the tarp was found downstairs across a chair, which is what she said he walked in with. So the tarp in the box obviously isn't it. And I mean, she said the tarp that he came in with was the one that was on the chair when he came down, not the coat. All she ever said was that blue coat, balled up, appears to be the same color. No one has ever said that she saw him or anybody saw him with that jacket. And I would also point out that I hate to say this, but I would suspect there are a number of rain jackets in this area of the state that have GSR on them, in them, around them. So there's
but not on the inside
no one
of
that
them.
says he had possession. All she ever said was, and by the way, it was all balled up. All she said was, it looks like the same color. She saw a picture of the rain jacket and said, that is not what he was carrying when he came in.
All right. The item is in evidence. The witness testified as to the location of the item of evidence and where she believe that it was placed by the defendant. It's in evidence. Obviously, the state contends that it has some inculpatory evidence on it. This is a circumstantial case, and circumstantially, proof may be offered on the issue of whether or not this gunshot residue or whatever it might be can be traced to the defendant. And I overrule the objection. I find the evidence offered is more probative than prejudicial, though I do not believe a probative versus prejudicial analysis is required on this issue. But to the extent that it is, I find that it's more probative than prejudicial, and I deny the motion to prevent the state from offering testimony.
Accept your ruling.
Yes, sir. If you bring the jury.
Alex Murdaugh does not look too happy. Oh, you guys heard me sneeze? I tried to step away. Yeah, it's a key piece of evidence. Because who else think about it, who else in the Mia house would have left that there and would have gun residue on it, on the inside of the jacket? The caregiver was a key witness in this case. Alex doesn't look too pleased. Let me guess, he thought he was going to get away with it? Probably telling his attorneys right now to go F themselves. What do you bet?
The jury is present, sir.
Thank you. Your next witness. State's next witness.
Johnny James for the state calls Natasha Moody.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court in this trial shall be the truth, so help you God?
I do.
Thank you. Take a seat in the witness stand. State your name again for the record. Spell your last name.
My name is Natasha Moody, last name Moodie.
I spelled it with a Y on my paper. I'm sorry.
It's okay.
Ms. Moody, where are you from?
Jacksonville, Florida,
And for whom do you work?
Bank of America, NA.
What do you do for Bank of America NA?
I am a consumer resolution associate.
Consumer Resolution Associate. What does a Consumer Resolution Associate do?
I manage a portfolio of litigated matters. I appear on behalf of the bank for trials, depositions, mediations, and I also review our business records on a daily basis.
Your business records, were you asked to review business records for Bank of America NA in relation to this case?
I did.
I am showing you 3 items labeled for identification as State's Exhibit 415, 416, and 417. Do you recognize these items?
I do.
And how do you recognize them?
I reviewed them and I also initialed them.
And generally speaking, what are these items?
These are documents for this case, opening account documents, monthly statements for various accounts, and
copies of checks for this account, for various accounts.
So are they bank records?
Yes. I have some. Thank you.
Your Honor, state moves to introduce exhibits 415, 416, and 417 into evidence at this time, my understanding with subject to any objections from Your Honor's previous ruling off today.
Yes, sir. Ms. Harpooth.
Your Honor, may I confer with Mr. Murdaugh?
Yes.
To the admission of these records, I would ask you to give whatever cautionary charge you're going to do.
All right, I'm happy to. Ladies and gentlemen, evidence or testimony is about to be offered that the defendant may have been involved in other criminal activity. And that evidence is not evidence or proof that he committed the offenses charged in the indictments. This testimony has been allowed and is being allowed for the limited purpose of assisting the state in proving motive. You may not consider this evidence for purposes of character of Mr. Murdaugh, nor may you consider this evidence as evidence of his propensity to commit other crimes, or that it is more likely that he committed the crimes with which he is currently on trial. It is being allowed based on the state's representation that it helps explain the defendant's motive to commit the crimes for which he is accused. And you may proceed.
Very briefly, Ms. Moody, we had 3 discs that are now in evidence. What information is on that first disc? You indicated that it was bank records. Do you have any additional information to describe those bank records?
I do, but I don't have the disc in front of me.
Okay. Showing you state's exhibit labeled 415. What records are on that disc?
There are checking account ending, it involves checking accounts, and I can give you the last 4 digits of those.
If you would, please.
Checking account ending in the last 4 digits is 6779. It has account opening documents for that one. The next one is account ending in 7991, and those are account opening documents for that account. And then checking account ending in 7625, and that's account opening documents for that account, and then also monthly statements and supporting documents for all 3 accounts.
Thank you. Now showing you state's exhibit 416. What's on this disc?
These are credit card ending in, 9559. And those are monthly statements in that and account opening application documents.
States Exhibit 417, what's on that disc?
Also another credit card ending in 8591. And these are application accompanying documents and monthly statements for this account.
Your Honor, I don't believe these are in evidence, but we would not have any objection to them except as to our previously made objections.
Yes, sir.
State moves to admit these 3 exhibits. No further questions for this witness, Your Honor.
Thank you, Ms. Moody.
Moody.
Moody, you may step down and you're excused. Let me call your next witness.
Yes. Now called Jamie Hall.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to give the court shall be the truth, so help you God?
I do.
State your name again for the record. Spell your last name, please.
My name is Jamie Hall, Hall.
Good afternoon.
Good afternoon.
Where do you work?
I'm currently employed at the West Columbia Police Department as an evidence custodian
How long have you been there?
since April of 2022.
Will you please tell the ladies and gentlemen of this jury about Jamie Hall, as much of your background, as personal background as you want to. I'll leave that to you, but specifically your education and background that led you to law enforcement, please.
Yes, sir. I grew up in the Midlands area of South Carolina. Upon graduating high school, I attended Clemson University and obtained my Bachelor's of Science degree in Wildlife and Fisheries Biology. After that, I spent a couple years traveling and working some various jobs. I moved back to the area in 2013 and began looking to start a career and ended up at SLED in 2015 as an administrative assistant in the Trace Evidence Department in the Forensic Services Laboratory. I was an administrative assistant until 2017 when I became an evidence technician, a forensic technician too, in the Trace Evidence Lab.
When did you graduate Clemson?
In 2010.
So after you traveled some, you started working in SLED in what year?
In 2015.
Okay. What was your job then?
I was an administrative assistant.
And what does that mean?
For the Trace Evidence Department, that involved answering phone calls, filing documents, pretty much normal administrative duties.
Did you further your education or your experiences while you were at SLED in that field?
No, sir. When I became the technician in 2017, that's when I began the in-house training for that career.
Okay. Tell us about the in-house training when you became the forensic technician.
Yeah, so that training involved oral and practical examinations in-house under the supervision of an analyst, in which I learned how to properly handle the evidence and process the evidence for potential GSR. I also oversaw some testimonies of some analysts to be familiar with courtroom policies as well. And I took some outside training from Hook College in Chicago as well.
Hook College in Chicago?
Hook, yes, sir.
What was that training?
It was training regarding the scanning electron microscope, which is used for GSR analysis.
That's the acronym is SEM for that?
The SEM, yes, sir.
And when did you leave SLED?
In March of 2022.
And do you mind, you're working where now?
at the West Columbia Police Department,
West Columbia Police Department, and you are there what?
evidence custodian.
Now, back in June of 2021, you were a forensic technician for SLED.
Yes, sir.
Special agent, forensic technician?
No, sir, I was not considered an agent or considered law enforcement. I was just the forensic technician too.
So then, in June of 2021, what was your job on a day-to-day basis?
My primary role in the trace evidence department as a forensic technician was to prepare evidence for GSR analysis. That include GSR kits as well as inanimate objects that came in for potential GSR testing.
And we're going to have Ms. Fletcher testify right after you, but what is a GSR kit?
A GSR kit is an envelope that goes out to officers or investigators so that they can collect on scene from a potential suspect's hands. And it involves, it has all the items they need: gloves so that they can make sure they're not contaminating the subject's hand. And then the little vials that contain the GSR particle lifts with a double-sided adhesive that's used to dab across their hands to pick up any potential GSR.
So those are kind of done in the field, if you will?
Yes, sir.
After a local law enforcement agency uses one of these kits, what happens to it?
When they decide that they need it analyzed, they submit it to the laboratory. And then when it comes into the laboratory, I prepare it for analysis. So that involves me making sure it's been properly sealed and initialed, handled properly, the correct kit. There are a variety of kits out there. Our lab has particular kits that we accept. So I confirm that it is an acceptable kit. And I also confirm that it was collected within the allowed time frame. On a living person, we're touching things all the time and possibly contaminating or removing the GSR. So we do have a 6-hour time limit on kits collected from individuals.
So if a kit comes into SLED or your possession, do you check to see if it was collected during that 6-hour time period?
Yes, sir, I do.
And how do you do that?
We have what we call an information worksheet included in each GSR kit that the officer fills out that includes the time or the estimated time that the shooting occurred, as well as the time that the kit was collected.
I'm going to show you what is marked States 13. Can you tell if you were involved with States 13? And if you can, how can you tell?
Yes, sir. This has the unique SLED lab number and item number, and it also has my initials on the day that I processed it.
6821 JEH.
Yes, sir.
What's the E stand for?
Elizabeth.
Now, Court, would you open this, please? Oh, sorry.
Thank you.
Did you examine States 13?
Yes, sir. Again, it also has my date and initials from the day that I processed it.
Your initials again, JEH?
Yes, sir.
6821?
Yes, sir.
And when you're processing this, tell us again, what are you looking to see, whether it's what's done or not, or just tell us what you
Okay. So for a GSR kit, I start by using what we call an inventory worksheet. And on that worksheet, what I'm doing is confirming the manufacturer of the kit as well as the lot number for the kit. They have lot numbers for quality control purposes to make sure they're not contaminated before they're used for collection. I'm confirming who the kit was collected from, that 6-hour time frame. And during that time, I also label the individual particle lifts inside with the unique lab number, item number, date and initials for control purposes.
And I believe a sheet has been entered where Murdaugh collected this GSR kit from the defendant. Are you aware of that?
Are you referring to the gunshot residue analysis information sheet.
That's exactly what I'm referring to.
Yes, sir. That's what I would have used to confirm the 6-hour time frame.
And it's in evidence already. I'm not sure exactly what number, but do you have that copy?
Yes, sir, I do.
Okay. And this is already, if you'll trust me, this has already been entered into evidence. Did you use this in examining, determining whether this was collected properly?
Yes, sir, I did. It also has my date and initials on it.
So using the form, show these ladies and gentlemen what you did. How you came up and.
There's a section here at the bottom. So we have the subject's name from whom it was collected.
And who is that?
This one says Richard Alexander Murdaugh.
Okay.
As well as the time and date the shooting occurred, 6/7/21, 10 p.m.
And that's information that's gathered at the scene from somebody, right?
Yes, sir. This particular kit says that it was filled out by collecting officer Brian Vandor. Sorry if I messed that up.
Good enough. Okay.
And then at the bottom, the collecting officer has also signed and dated that it was collected on 6/7/21 at 11:15 p.m.
And would that 11:15 fit in the time period where you're saying, okay, well, I can pass this on to be analyzed?
Yes, sir. It's an hour and 15 minutes.
And so not taking away from what's your job at all, but one of your jobs is to make sure that's done correctly?
Yes, sir.
And then do you inspect the vials, if you will, to make
Yes,
sure?
sir. I make sure that there's nothing out of the ordinary with them. Occasionally, you would have a little crack in the vial, but I've never had anything damaged.
So in your opinion, these were collected properly and you passed them on for analysis?
To the best of my knowledge, yes, sir.
Now, were there, let me ask you this much. Local agencies that you examine items for potential evidence, in this case, gunshot residue, how do they get to the lab?
Typically, the officers from the local agency submit them through our evidence control department. And once they're submitted that way, that's when they're assigned their unique lab number and item numbers for each piece of evidence. And then based on the type of analysis that agency requested, we would get notice that it needs to be processed. And so I would pick it up from evidence control and bring it upstairs to the trace lab to begin the processing.
And is all that documented from local agency to y'all and where it goes from there?
I can't attest to what the outside agencies do. I believe it probably varies agency to agency. But once it's been logged into our system downstairs, it is tracked throughout the laboratory for every hand that touches it.
That's kind of what we refer to as a chain, correct?
Yes, sir. It's referred to as the chain of custody.
Chain of custody. Now, did you have some other items of potential evidence in this case that you examined?
Yes, sir. I had several other items.
Okay. I'm going to show you what's marked states 418. Ask me if you can just identify this. That's all, and does it relate to your testimony?
Well, I can no longer see my initials, but I did process items that were in container D, and this is marked with container D for this case number. Yes, sir.
And would you open it up then to see if you
Yes.
can further find your mark with the court's permission? you what's marked 21, excuse me, it's your lab number 21 contained in states 418 at this point for identification. Do you recognize that?
Yes, I recognize it as the lab item number 20.
And what is lab item number 20?
It was a brown paper bag containing one pair of green cargo shorts.
And also contained in 418, lab number 21. Can you tell me if you recognize that?
Yes, sir. It's lab number or item number for this case 19, which was a brown paper bag containing one white t-shirt.
Now, Jim. Your Honor, all 418 without objection.
Without objection.
They're admitted.
I'm going to show you what. Thank you, Your Honor. Sorry. I was going to ask you, please, man, I'll just correct the question. Look at 423, 424, and 425. Do you recognize these, and do they relate to what you're talking about right now?
Yes, sir. These are PGSR collection worksheets from clothing that I generate during my process of collecting from inanimate objects.
Okay. Inanimate objects.
Yes, sir.
Okay. Now, let's start with the shirt, 423.
Yes,
It's
sir.
in evidence. Tell these folks what you did with the shirt.
So anytime we're processing clothing or an inanimate object in the lab, we start by making sure everything's been thoroughly cleaned. And we also place down parchment paper to just as an extra check and balance to make sure there's nothing contaminating the evidence. We also place what we call a clothing blank out onto the table where we are processing. That's just another one of those double-sided adhesive stubs, and it's left open and exposed to the environment to make sure there's no contamination in the environment. That's how I start all of my clothing. Then I confirm that everything is adequately sealed and documented, and I open my items and lay them out on the parchment paper. I photograph items, and then I do label those items for identification later if needed. And then I will sample the clothing item closest in the areas that would be closest to the discharge of the firearm. So in this case, we're talking about a t-shirt. So I will sample the right chest and sleeve area together and the left chest and left sleeve together. So if you want to draw a line down your midline for right and left, and then we typically go down to just below the chest area.
And is that what you do with every shirt?
Yes, sir. If it's a long sleeve garment, I would typically use a separate particle lift for the chest area and the arms, just because the adhesive doesn't last quite as long.
And if you said this, I apologize, I'm tired. Why are you doing those areas?
It's closest to the discharge of a firearm.
Potential discharge, so that's where you test.
Yes, sir.
Well, looking at the shirt, look 418, the shirt that's contained in here. Which one's the shirt?
19.
19?
Yes, sir.
Before you get to doing the particle lists, what's the first thing you do?
I confirm what the item is and that it's properly sealed and initialed.
Do you open it?
After I clean, I open it. Yes, sir.
And do you make observations of items when you first open it?
Yes, sir. Anything that seems out of the ordinary for any item is documented on the worksheet in the comment section.
And you have a comment section. That's where you put your thoughts, right?
Yes, sir. Anything that may, again, be out of the ordinary or affect the analysis later.
And just to go back, You go down a bit, yeah, so this is right sleeve, right chest, left sleeve, left chest. Hanes beefy shirt, right?
Introducing 423 into evidence. I don't think it's in evidence yet, but no objection.
We offered it a little while ago, without objection, 423, 24, 25.
I have no objection to those three exhibits going in.
I thought I'd said that. If I didn't, I apologize. Is this a Hanes beefy t-shirt?
Yes, sir, it was.
And item 19.1, what are your comments underneath there?
Small reddish brown stains observed. Shirt had an odor of laundry detergent.
What do you mean by that, an odor of laundry detergent?
It just smelled freshly laundered, which is not typical of the lab. Typically, clothing smells slightly musky when we get it.
And you examined this shirt when?
On June 8th of 2021.
Now, you didn't know, did you have any knowledge about this case whatsoever?
I just knew that we had asked to make it a priority in the lab.
And you attempted to collect particle lists from that shirt?
I did collect particle lists from the shirt. Yes, sir.
Next, states 425. Sorry, we're out of order here. This is also your clothing worksheet.
Can I see the top of that sheet? I'm sorry.
I'm sorry.
Oh, yes, sir.
And what was this that you examined?
This was the worksheet we generated when we collected from a seat belt that was collected from a 2021 Chevy Suburban, South Carolina, tag CZL420.
I think we have it marked for ID only. Do you recognize this? Strike that, I'm sorry. The seatbelt states 100. Thank you to everybody. States 100. Can you look at this and see if you haven't examined that before? Does it relate to your testimony?
Yes, sir. This was sled item number 142, and it also has my date and initials on it as well.
All right, what did you do with states 100?
At the direction of the analyst, Megan Fletcher, I collected samples from various areas on the seatbelt.
Can you tell the ladies and gentlemen of the jury, how did you determine where you were going to collect samples?
Since this was not our typical item, I collected from areas in which Megan instructed me to collect.
Which was where?
We collected from the buckle, 3 different areas of the belt, and the latch plate.
Can you show the jury where you collected?
Yeah. So this, I believe, was what we call the latch plate.
Okay.
Sorry if I'm misspeaking on that, but, and then the buckle was, oh gosh, this area here. And we did the top and bottom of it. And the 3 sections were just, we measured the length for each section, did a section, rolled more out, and did the next section.
And how are you actually doing it with the particle list? How are you collecting them?
So as stated before, the particle lifts have a double-sided adhesive on it. And you just repeatedly dab that across the garment or the item that you're collecting until it loses its adhesive abilities.
100, we'd offer, Your Honor.
No objection, Your Honor.
Did it? Thank you. And looking back on the sheet, this noted here, that's where you went through and did your inventory sheet, correct?
Yes, sir.
And this is to document you did what you did, right?
Yes, sir.
Now, did you also have an occasion to examine the pants in this case? It's already, I believe, in evidence.
I did collect from some cargo shorts.
And those were also included on what I just took down off the MO, but can you tell the folks where you collected or tried to collect lifts off the cargo shorts and why you collected in those areas?
Yes, sir. For any type of pants or shorts, we always collect from the right groin and the left groin area. Again, that's the area that's closest to the discharge of a firearm.
And that's standard. That's what you do.
That is standard practice.
Now, did you? Without objection.
Is that correct, Mr. Griffin?
Yes, Your Honor.
Is that minute?
Would you mind opening up for, first of all, do you know whether or not you examined a pair of shoes in this case?
I did, and these are the shoes sled item number 21.
Okay. Would you please open that for the ladies and gentlemen?
Yeah, it's gonna be a lot of stuff on it. I use gloves.
Sure. Yes, ma'am. Before you cutting that, do you see JEH on here?
Yes, sir, I do. On 6/8/21, I signed my initials.
What is all that right there?
I believe it's yard debris.
Court permission to dump this right here, or can I get a trash can? These are states 419 in without objection. Can you show these to the jury?
Sir.
Show the jury what you, I'll hold them. Show the jury what you,
So with shoes, when we collect from them, we're going to collect again to the area that would be closest to the discharge of the firearm, so the front of the shoe. So in this case, I would do the area where the laces would typically be and the front toe. Depending on how well the adhesive continues, it will depend on how far back I go, but I start with the toe and then work my area down the sides.
is this the condition they were when you saw them on June 8th, 2021?
There was more grassy type material on them when I had them.
And what I just dumped in the trash can with the court's permission and in here, did you indicate on your comment section
Yes.
whether or not yard debris was present?
Yes, sir. I commented that shoes were wet with yard debris present.
Wet with yard debris.
Yes, sir.
Did you, on June 8th now, go back in your mind,
Mhm.
when you saw these, in addition to wet and yard debris, did you make any other notes in the comment section about those shoes?
I did not.
Do you remember, did you see anything that looked like blood
I did not make any note of that. No, sir.
with your naked eye?
No, sir.
Top or bottom?
No, sir.
Did you have any other items that you examined that were presented to you for examination either by yourself or with Megan Fletcher?
Yes, sir.
What was that?
It was sled item number 173. And it was, we described it as one blue rain jacket / poncho.
Okay. And was this the same? No. When did you examine the poncho?
I believe we began on October 5th, 2021.
Okay. So is it fair to say that the clothes, the shirt, the pants, and the shoes were on June 8th of 2021?
Let me check my notes. Yes, sir, that's correct. June 8th of 2021.
And I didn't ask you this, and I apologize. When did you examine the belt, the seat belt?
The seatbelt was examined on September 1st, 2021.
And again, the specific date for the raincoat was what?
October 5th, 2021.
And tell the ladies and gentlemen, take us to the lab now. How did you examine that garment, the rain jacket?
This was also not our typical garment, and I believe there was some information provided from investigations. So everything I did in this case was at the direct, or in this, for this particular item, was at the direct supervision of Megan Fletcher. She essentially told me where she would like me to collect, and she documented everything on the note sheet while I physically collected the particle list.
On 420 and 427 without objection.
Is that correct?
That's correct, Your Honor.
They're admitted.
And Your Honor, 421 are the particle list from the rain jacket, and I believe there's no objection except the further the objection they made previously. No additional objection, 421.
They're admitted.
So let me go back in time real quick. Are these the particle lifts you took from the seatbelt? 427?
Yes, sir, my initials are also on each individual stub.
And that's sort of like the officer has in the scene. You're now doing it in the lab, taking particle lifts, correct?
Correct.
And particle lists from 420 lists from 19, 20, and 21, which I think are the pants, the shirt, and the shoes. Were these the particle lists from 420 that you actually took?
Yes, sir.
Again, in the twos.
Yes, sir.
And your initials is on.
Yes, sir.
Now, 421, you said it was a little different, unusual. How did you take the particle list on this rain jacket?
I believe everything was considered in Megan's custody while I was doing the collection. And then it was transferred directly to my custody when I carbon coated the particle lifts. That's just a process where a thin layer of carbon is added. It allows the analyst to get better images on the instrument. It doesn't do anything to add or remove GFSR. It just simply adds a very thin layer of carbon. So it was in my custody at that time, but prior to that, it was in Megan's custody.
Okay. We'll show you what's marked as 226. Is this the rain jacket that you were describing?
If I can check the bottom cuff. Yes, sir. My dates, the date and my initials are here in the bottom cuff.
So you looked at this rain jacket,
Yes, sir, I did.
and Megan Fletcher was with you.
Yes, sir.
And tell the ladies and gentlemen, how did you process? Where did you attempt to get particle lifts?
Basically the entire garment. We marked it off in different sections again, where Megan advised me to collect from, and I repeatedly dabbed the particle lift across each section until it lost adhesive.
These particle lifts?
Yes, sir.
You dabbed each one of these?
Yes, sir.
Okay. And what are these little things on here? These tape or the,
I'm not sure what those are.
now you did the outside of this garment.
Correct.
Did you do anything else to it?
We also sampled the inside of this garment as well.
So you actually turned it inside out and took samples from the inside.
That's correct.
Megan Fletcher was with you.
Yes, sir.
What about the hood? Did you test it or take samples from the outside of the hood?
Yes, sir, we did.
Did you take samples from the inside of the hood?
Yes, sir, we did.
Had the court's indulgence. I'm not wearing gloves here now, but when you're examining all of these items, do you wear gloves?
Yes, sir.
Does Megan Fletcher, did she wear gloves?
Yes, sir.
Why?
To make sure we're not contaminating it, as well as to protect ourselves from anything that may be on the garment.
And as far as the, to not contaminate it, you don't want to put anything of you on that garment.
Correct. It's standard practice for us to wear a lab coat, gloves, and if it's going to be processed for DNA later, we also wear a mask.
And is that in a controlled environment when you attempt to get these particles?
Yes, sir.
Thank you, Judge. That's all.
My other defense.
Yes, Your Honor, thank you. Exhibits 423.
Oh, here they are. I'm sorry. Yeah.
Good afternoon, Ms. Hall.
Good afternoon.
You said if you're going to do DNA testing, you wear a mask.
Yes, sir.
Did you wear a mask?
Yes, sir, I did.
So to your knowledge, were some of these items processed for DNA after the GSR processing?
It was my understanding that they had the potential for DNA analysis. Yes, sir.
Okay. Now, let's just talk about how you go about sampling for GSR. And you talked about the shirt, and you said you would do the chest and sleeve on either side. How does that work? Do you lay the shirt out on a table?
Yes, sir. So as I stated, the table is thoroughly cleaned, and then we place down parchment paper as well, sterile parchment paper, and lay the garment out on that so that we can access all the areas.
And for the shirt here, I think it's item 19, did you just check on the two areas at the top on the chest side?
Yes, sir. Unless we're given information from the investigative team or from an officer who submitted it that there's potentially a reason to test somewhere else, we only test the chest and sleeve area because that's the area that would be closest to the discharge of a firearm.
And that's what you're looking for is, you call it gunshot residue, is that right?
Yes, sir. It's microscopic, so you cannot see it. Therefore, we're testing the areas where we would expect to find it.
And you would expect to find gunshot residue on the shoulders of a person who had recently shot a gun, I would take it.
Yes, sir.
That's what you're looking for.
That's what we're trying to find out, yes.
Right. And then you did some GSR testing of a seatbelt assembly and buckle and whatnot, correct?
Correct.
And you did GSR testing of this rain jacket here, right?
Correct.
And shirt, shorts, shoes, and Officer Murdaugh, I think's his name. You received a sample from him, and you just checked to be sure it was off.
I didn't
Murdaugh's
physically
hands.
receive it from him, but he was the collecting officer listed on the sheet. Yes, sir.
Okay. And so he would have taken the sample, or whoever did it would have taken it from Mr. Murdaugh. And that would be item number 18, I believe.
Slide item 18. Yes, sir.
And those are the samples taken from Mr. Murdaugh's hands, I take it?
Yes, sir.
Okay. Now, you can get gunshot residue on you by just simply picking up a firearm, can you not?
Those questions would be better asked of the analyst. I can only testify to factually what I did.
Okay. And the analyst here is Ms. Fletcher?
Yes, sir.
Let me ask you to take a look at your worksheet, which is in evidence 423. And do you have that up there?
Yes, sir.
You know, I think I'd rather put it on the Elmo so we can. Do you have it in?
I have my copy. Yes, sir.
Okay, great. So all right. Yeah, go to the top. Okay, let's stop right there. Agent Hall, it says that this was a brand Hanes beefy T-shirt,
Yes, sir.
and then particle lifts, right sleeve, right chest, left sleeve, left chest, correct?
Correct.
And it says description, paper bag containing one white T-shirt. Is that right?
That's correct.
And Doug, if you'll go up, down a little bit more, okay. And then there it says, comment, small reddish brown stains observed. Shirt had odor of laundry detergent. That's what it says, correct?
Correct.
Do you know what those small reddish brown stains looked like?
They looked like small reddish brown stains on the shirt.
Were they tested?
I have no knowledge of what was done after I handled the object.
Okay. Now below here, it says sealed brown paper bag containing one pair of green shorts. Is that just an entry for another item?
Yes, sir. That's item number 20. The sheet is designed where we can put two items on one sheet.
Okay. So when you received the shirt, item 19, was it in its own separate bag?
In this case, it was. Yes, sir. That's why I made the note that that individual item contained its own brown paper bag, while the description says brown paper bag containing.
Okay. And the shorts, those are green cargo shorts. And again, you lifted, it says right groin, left groin.
Correct.
And it's just is it on the inside of the pants leg or?
Well, it's on the outside of the garment, down to, a reasonable distance, depending on the type of fabric, could depend on how much adhesive it has, depending on how large the garment is from the person. A small garment versus a 3XL is completely different. It depends on how far I can go down on the garment.
And to do this, you take a sticky something or another? And
It's a
just-
double-sided adhesive on an aluminum stub within those little vials. The bottom has a holder for that, and then we grip it by the bottom and repeatedly dab it across the garment.
Until it loses its stickiness.
Correct.
And then, do you do one vial per area or multiple vials?
It's one vial per area listed. If for some reason I needed to use an extra vial or an additional vial, that would have had its own listing on the worksheet.
Okay. Now, I tell you, you don't know what the results of your lifting were, do you?
No, sir, I do not.
That you would then finish your work and send it up the chain?
Yes, sir. All the items are either given directly to the analyst or they're securely stored in the trace evidence lab until the analyst takes possession of them.
And this blue rain jacket, you said you put carbon on it or something?
Yes, sir. It's a standard practice for anything collected from an inanimate object. We typically get a lot of debris, sand, dirt, or fibers, typically from clothing, and that can cause it to be a little bit more difficult on the instrument for them to get pictures of the particles. So the carbon just allows them to get a better picture of the a better picture of the particles when they do their analysis, but it does not do anything to add or remove GSR.
So you put the carbon down before you use your sticky thing?
No, sir, that process happens after the collection.
Okay.
So it goes into a small device, and there's little rods of carbon that are rubbed against each other inside of the instrument to put the layer of carbon onto it.
I see. But you're not putting carbon on the garment?
No, sir.
Got it. Okay. One second, Your Honor. Ms. Hall, are you involved in any way with DNA processing?
No, sir, I'm not.
Okay. And so you don't know whether any of the items were processed for DNA?
I have no knowledge of where the items went after they left my department.
Okay, thank you so much.
You're welcome.
No, sir. Thank you.
Thank you. You may step down. Unless you have a 2-minute witness, this will be it for today.
We don't, Your Honor, unfortunately.
Ladies and gentlemen, that'll do it for this day. We'll resume at 9:30 tomorrow morning. Please do not discuss the case.
All right, guys. Well, it's been a long day. Lots of has come out. They're starting to seam this case together for many people, where it appears, as many of us had speculated early on, that he went over to his mother's house for, one, an alibi, and two, to dump evidence.
Be seated.
Hold on. Something else happening here.
Mr. Harpootlian, concerning the item that you were objecting to the testing, I think was that the blue, what exhibit number is that?
Not the t-shirt, not the shorts, not the shoes.
And regarding that same number 226 rain jacket, is the same item that Mr. Griffin cross-examined a previous witness concerning? Ms. Smith,
Yes, sir.
concerning,
Examined her extensively about whether she'd ever, first of all, was that the rain jacket in his hands when he came in that morning? 2, had she ever seen him with that rain jacket? And 3, did she, I mean, when she looked into the closet, did she know whether it was a tarp or whether it was a rain jacket? Was it the same color? She said it was the same color. That's it. And I objected to it because I thought that prejudicial outweighed the probative.
So we're hearing that they are, after the jury has left, they are arguing whether something can be entertained in as evidence. They're still trying to fight to
So I
preclude
also recall
that blue
Mr.
jacket.
Griffin questioned her as to whether it appeared there was a gun or different things in it.
No, Your Honor. I questioned her as to the tarp. This witness, Ms. Shelley Smith, they never showed her the rain jacket. She's never identified a rain jacket. And when asking court here, a photo of that rain jacket, she says, Your Honor, that is not what he had. And what's so prejudicial is they have introduced GSR, and they will introduce an expert tomorrow to say it's covered with GSR. And that is extremely prejudicial. They have no evidence connecting Mr. Murdaugh to that rain jacket. And the only witness they relied upon to get a search warrant, Your Honor, says that he came in with a tarp. I questioned her whether in the tarp, it looked like there was a gun in the tarp. She says no. She says he went upstairs, he came down, he laid the tarp open on his mother's retirement rocking chair. And she leaves that day and she sees the tarp laid out, and it's a tarp that looks like it goes over a car. And now they're coming in, showed her a photo of something in the closet that they seized and says, yeah, does that look like a tarp? And, I mean, does that look like what you saw? She said, well, it's blue. And now they're putting in GSR on an item in a house he doesn't live in, on an item he's never had in his possession, to the best of anybody's knowledge. And that's the basis of our objection, Your Honor.
So, Your Honor, again, if you look at the testimony, excuse me, in its entirety, Ms. Smith described she testified, of course, that Alex Murdaugh had showed up early in the morning, which was highly unusual. He was carrying what appeared to be a blue tarp balled up. And then she was shown the picture in the closet where it's balled up and said, that looks like the item. Now, when it was pulled out and shown by them, she said, that's not what necessarily I saw, but she did recognize the balled up item and the balled up item in the closet, which the investigator said that's how they recovered it. She did identify that picture, and then if you put the two chains of evidence together, that's what the investigator recovered that she identified. Now, certainly they can argue to the jury whether or not that's the right tarp or not, but she did say that that is consistent with what I saw, all balled up, which was the only way she saw it. Again, this is also evidence that, was admitted and has been extensively examined before the jury on. So certainly they can argue all these points to the jury, but there's enough of a chain that's been established by the testimony for it to be submitted to the jury.
Your Honor, might I make a suggestion? Yes, sir. We're getting daily transcripts. Perhaps overnight you could, the prejudicial piece is the witness they're going to put up tomorrow, I would suggest. Perhaps you could look at that daily transcript of her testimony alone. And I don't believe, I submit, she said what he said, maybe what he wished she said. I don't believe she said what he said. Your Honor, I think Mr. Waters is arguing this. I don't believe Mr. Metters has a dog in this.
Y'all just did.
Well, good for the goose, good for the gander, but 520, I just thought maybe this was a simple solution. He's going to say this is what she said. We're going to say this is what she said. I think it's clear she never said that what was in the closet was what he carried in. And of course, you have a court reporter that could, I guess, not type it tonight, but perhaps give you an audio of it. But it's a very simple question. It boils down to what she said about what she saw in the closet. Because clearly she said that when shown a picture, that's not what he walked in with. He walked in with a tarp, which he left over a chair. And, other than their supposition that he somehow brought that rain jacket in and wadded it up and threw it up in the closet, no evidence that there was a gun, no evidence that anything was balled up in it. They'd want to make a giant leap of logic. It's not circumstantial evidence of anything. So I would ask the court to perhaps look at the daily transcript. Somebody's got one right there. And just look at her testimony, not all of it, just her, or even a piece of her testimony. What did she see in the closet in response to Mr. Meador's question? Now, Mr. Meadors believes she said something, and Mr. Waters believes she said something different than what we think. The proof is in the pudding, as they say, or whatever. That's not really a legal aphorism there, but I would suggest strongly that maybe overnight look at it and then let us know what you think.
Mr. Meadors, you had something? Mr. Waters, yeah.
I think, and I guess on the redirect through their investigator's transcript, I think they were asked, I asked her if they had asked her about whether it could contain a firearm, and she said, well, I don't know. But that was brought out, I think, which would directly from their investigators who asked her about it. So that, I think, made it relevant. They certainly thought it was relevant when they were interviewing her. So that's why we do think it's relevant, and we hope Your Honor will let us keep going tomorrow with the GSR to see if there's anything potentially in the rain jacket that has GSR evidence.
All right. Okay, we'll adjourn for this day.
So what we heard is it sounds like the judge is going to, I'll monitor this until I make sure everybody leaves the courtroom so we don't have any other surprises. But it looks like the defense is having a problem with the jacket. And we noticed that early on with the questioning of one of the first witnesses and them trying to put doubt in people's mind of what she saw. I can see how she made the leap of a blue tarp and that blue jacket. It crumpled up under somebody's arm. I have to think they look similar. So with that being said, this testimony, I recall her in him saying when the other person bunched up the blue jacket and put in there, I remember that she said, yeah, like that. So I think that I'm not sure how the judge is going to rule on this. I'm interested in the morning. So we know first thing in the morning at 9:30, the jury's not going to be brought right in because they're going to have to resolve this objection before they move forward as to what is relevant and what can be kept in the jury or in the trial transcript, what evidence has been submitted in this case. Not everything you hear, especially for us at home, is going to be submitted into the court record. That means that the jury is not hearing a lot of the stuff we're able to hear. For example, the two attorneys first thing this morning, that was not in front of the jury. Many of you guys noticed the jury did not come in. You guys informed me because I had missed the ending of Friday. So you guys informed me that the jury wasn't coming back in until 11:30. And they came in a little after that because the judge needed to take its time to make the ruling to decide whether or not the attorneys can be brought into this case or if it was prejudicial to the defendant. He ruled that they can be brought in and nothing, that their testimony is relevant. So that's an example. We heard all that testimony when nobody else did. So we have to keep that in mind as well, because quite frankly, there's some stuff we're going to hear that's not going to be in that court record. And we're going to be, when we come to our determination at the end of this, it might differ from the jury's because we were able to hear testimony that they were unable to hear. So always keep that in mind as you watch from home and listen to the orders of the judge on the testimony given, because some of that stuff we're not going to be able to take into consideration when it comes to whether the defendant is innocent or guilty. So anyways, guys, it has been a very long day. I have actually sat with you here the entire day, except for about 20 minutes when I laid down. And we've kept you guys up to date on who was called, who was standing in the witness box when the prosecution was examining the witness, and when the defense was cross-examining the witness. So you guys got to see it up close and personal. The more and more witnesses I hear that are entering evidence into this case, the more and more that I see Alex Murdaugh's fate being sealed. It looks like they've got a pretty damaging case against him. I'm still interested in what the defense is going to bring up to dispute some of these facts. They're going to bring their own witnesses in, that's going to dispute witnesses on the prosecution side, the state side. We haven't gotten there yet. All the defense is able to do right now is cross-examine the witnesses the state brings forward. That's all the defense can do. And it's going to be likewise when the defense brings its witnesses before you, then the prosecution will be able to cross those witnesses as well and examine those. So we're still a long way from hearing the totality of what the defense is going to bring to dispute this damaging evidence. And I have to believe that jacket is going to stay, that jacket is crucial to the case. We can all acknowledge that she has said multiple times it was tarp-like material, it was vinyl material. She never said it was a tarp. She said it was tarp-like, from what I gathered from her testimony. So we'll see what tomorrow brings. Thank you, Tammy. I don't know if you heard me during the thing. I got that. Thank you very much. God bless you. But we'll see what tomorrow holds. Again, tomorrow I've got meetings. So I'm literally not going to be commentating. You're going to see Alex Murdaugh Trial down here, and it's going to go. I'm going to set it and forget it until I get back here. And you guys are going to have to catch me up to speed because I'm going to be in my own meetings tomorrow, and I'm not going to have an opportunity to watch it in the meetings. So we'll see you then. So God bless each and every one of you. I hope you guys enjoyed today. I know that this is, again, it is a popular case for some folks on YouTube, just not on our streets of YouTube. So it's very interesting to me, and I'm going to continue to follow it because of all the bells and whistles that go along with this case. But until next time, guys, don't forget to be fearless. If you see something, say something. An ounce of prevention is worth a pound of cure. Good day.
As you wake up in the morning, you want to find the latest, greatest information about criminal cases and have an intuitive conversation about the suspects associated with these cases. Head over to the Bullhorn Betty channel on YouTube. Get breaking news right here on the Bullhorn Betty channel. Welcome to the Bullhorn Betty Coffee Club. Enjoy your stay and enjoy your day.